Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And 10 minutes late and gay already. Yeah. Yes. My adorable daughter, it's her fault. It's her fault. But hey, guys, how we doing? How are we today? I hope you guys are doing well. We had a members only stream earlier today, so I saw some of you already, which just means my day is enriched and wonderful. You got any pizza casserole? I do not. I do not. I don't, homie, don't get down that dirty. Did she ask for Taco Bell again? No, it was some hair dye. And I was like, she's like, I need it right now, like before school. So tonight. Oh my God. Nice job blaming your daughter for being late. Truth is truth. Truth is truth. I'm disappointed you didn't try the black tie. The black tie, that was the other shirt. I don't know where my solid black tie is. I have an all black tie, but it's got a paisley pattern that catches the light. So it's not, it's not just black. There's some patterning on it. Hey, what's up, Emmy? I believe I saw that. Oh my goodness, it's starting off already. Sarah Nevada. Sarah Nevada. I think I've been calling you Sarah Nevada. Sarah Nevada gifting 5 memberships to the channel. Thank you. Good, sir. And giving 5 beautiful souls the opportunity to enjoy your membership is really a wonderful thing to do. I'm happy that you have done that. And we are specifically, we collectively, we communistically, not really. We are doing, a minimum of 1 member show a week, typically on the weekends. That's been the plan. We're already up to 2 membership shows. Well, we did one last week and I just did one today. So we had the weekend one, then this one, and then there will be a weekend one at least. But we might do more member shows. We might do more member shows this week. We'll see. I'm happy to report that the member show today led to the topic for tonight. And it is it is something special. In my humble opinion, it is Mardi Gras. Happy Mardi Gras. I hope you guys are all getting fat so that you can get skinny afterwards. Very important. To do that, I've almost got my chat windows organized, guys. I'm professional. And so I've been doing that without letting you know. I'm very secretive about it. Okay, we need to move this over. We need to move this. Oh my God. Sorry, guys. It's baby's first time streaming. Leave me alone. All right. So earlier today, we were doing just a members only fat stream, watching fat people do things, talking about fat law, which led us to the culmination of the member stream, which was starting to watch Uncivil Law self-review the lawsuit in which he is representing someone. The fish says, Jesus fucking Christ, Raggets. I have everything fatigued, so please take us away from the horrors of our pedo leaders. Oh, none of that's going to happen tonight. We don't need to get deep politics. What we have tonight is very specific. It is the purest of law. The purest of law. The Roz Rodriguez. Hey, what's up, Roz? Sometimes I want to watch you on here, but the Rumble app makes my phone physically hot. Yeah, the Rumble app, I mean, say what you will about YouTube, Rumble, and all that. All the nonsense between them. Like, the Rumble app is just not as well put together as YouTube. YouTube has a huge head start in, like, trillions of dollars. Sunderwear says, I missed the members stream earlier. Look, missing members, that's the worst. Eclectic Divergence says, is this shirt more gay than last night's shirt? Yes or yes? Yes, it is, of course. And, but I have complimented it to bring the homosexuality level down. I've complimented it with a leather yellow tie. So, that can also be used for a little, offensively, but sensually. So we have that. Haven King Nick is less gay now than tomorrow's stream. How did you know? How did you know? Okay, so we've got and Kenzie Wills, yes, it is leather. And yeah, to answer your next question, yes. Let's see. I think that's unfair criticism. That outfit looks perfect for an 80s pop band like Wham or Culture Club. Wait, what about what you just said makes it not gay? That's what I want to know. You motherfucker. The patterns on Nick's shirt break up the outline of his small shoulders. Oh, wow. Thanks for making me feel better about things. Okay. Okay, yeah, I'll start with the vid that Connor sent me. We'll do that. But what we're going to do, the ultimate drive of this show, the main thrust of it, the repeated pounding obsession of this show is Uncivil Law. My former colleague, Kurt Mueller, is representing someone in court. Someone other than himself for the first time. A fact that he kind of obscured for all of his time on YouTube. And more importantly than that, he has decided it would be a good idea to live stream about his representation. So there is the initial complaint. Well, his initial part of the complaint. So the lawsuit was filed and they hired Kurt after filing. So an initial complaint was done. Then they hired Kurt and he said, no. I'm going to do this. Hello, everyone. I'm Uncivil Law and I'm going to do this the right way. and he filed the first amended complaint. And then he waited a couple months, and then he reviewed it. He reviewed his own complaint, which is so fantastic. It is perfect. It is everything I could have hoped and dreamed. And I've only watched the first 9 minutes. He is going to tell us how good his complaint is, going through it as if someone else wrote it and he was reviewing it. It's perfect. It's perfect. I've been holding off on doing these videos. I wanted to give him a shot, but it was like Mardi Gras. Well, at the end of the member stream, we'll take a look at it and see what it was. So we have that video. That's an hour. Who knows how long that's going to take to get through? Probably forever. Next, after that, the other side responded, of course, and Kurt reviews their response. Buckle up, buccos. That is what we are up to tonight. This is a full-on law review. There's nothing about, this isn't about, whatchamacallit. This isn't about like roasting his cooking or making fun of his sexual preference for questionably young women. This is about Kurt and law and him putting his money where his mouth is on all of it. And I am here for it. I'm here for it. What's up to the Glarer? How you doing, man? Hey, brother. Hear me out. I'm officially extending flesh in a handshake to invite you to an upcoming episode of my new YouTube series. Okay? And it is called The Cookoff. Hear me out. What do you do with your friends? You have a cook-off, of course. What is a cook-off, you say? I understand that you like to review videos of people who cook food, maybe with less skill than others. All right? I also share this hobby. We have so much in common, we should kiss. That aside, the cook-off is one of us chooses any cooking video to review. Any cooking video, it doesn't matter if it's your person, my person, any person, new person, old person, doesn't matter. We pick a video. Let's hypothetically say that video is 1 hour, just for the simpleness of explaining the show concept. We will take 60 minutes and put it on a chess clock where each of us will have 30 minutes, okay? We will start the video. There will be no pauses. And we will go back and forth roasting the video. Each time you say a joke or like have a zinger, bam, you hit the button and it switches to the other person and they have to say one. We go back and forth. Whoever runs out of time first loses and the other person finishes the set and gets to use the rest of their time to finish out the show. What do you think? I think that's going to be a fun show. I think that's going to see? We've already got a positive review. Brian Dunham says, wow, that's happy. There you go. So, yeah. See, Melody says, nice tie, Nick. Thanks, Melody. Didn't you see it earlier? You were watching earlier, I think. Can we bet on who wins? Polymarket has already put me losing every single show at 90%. So there we go. You weren't. Okay, no, it must have been last night's show then. I saw your name earlier, but it's starting to blend on with all the streaming. Let's see. I think you should change the video audio to make sure that y'all can keep saying stuff but not having to like battle over the person talking in the video. How does that work? How does that work? Your money's on Will the Glarer. Well, you're banned. You think about that? Want to rethink your answers? I didn't have a tie on. Okay. I did today. I don't know. Who knows? Doesn't matter. Miss PG Keen, it's just speed. It's timed chess. It's timed chess, but with jokes instead of moving pawns and stuff. No math. You need a painting of me in that outfit for your dart wall? Why? So I can stand there next to the dartboard and like encourage you to hit the dartboard? I think that's what you're saying. He's already banned someone today, right? I mean, probably. Oh, you're talking about my shirt, not the game. It sounds fun. Oh, okay. Sounds great. Sounds great. Yeah, so we're going to do that at some point soon. I'll get it set up. I have to find, someone sent me the app that should allow us to do the speed chess back and forth where you just, you just click on your side and it syncs it up. Okay, here we go. And as Nancy says, you are looking prettier than average today. Oh, thank you. Thank you. Thank you. Stacy Q, hi. How are you? What does the winner get? A hand job from the loser, obviously. And after I said that, the Glare says, get at me, I'm in. See? He's already excited for the prospect of winning or losing. Okay. We do have super tips activated. We have lots of them in stock. Make sure you check out the full selection. You can go to supertip.gg/RL. If you go to supertip.gg/RL, you can insert money and export, take out, extract, remove, comedy. So you can send, it's like a super chat, except instead of being a super chat, it can be voiced by an AI robot that's already intent on killing me. So there we go. What is going on here? Miss Peachy, I did not sign up for this. Oh, that's all true. It's all true. Let's see. We have, oh my goodness, Soldier of Providence gifting 5 memberships. Thank you so much. Welcome. Thank you for sharing your member with people forcefully and without consent. Obviously, that is how we encourage that to be done on the stream. There were 5 earlier, right? So that is that, or is that the first 5? Oh, damn it. I can't remember. Everything's blending. Yeah, so we're up to 10 members already. 10 members already to start the stream, which, that's good. That's good. That's as it should be. As it should be. If you don't know what a super tip is, let me text you. You'll find out. Here we go. 1 second. That was a joke, by the way. You won't find out. I mean, I don't know.
As someone who has been in legal distress before, one glance at Kurt's YouTube channel, he would be the last motherfucker I would hire. Micropeen whale ass.
Micropeen whale ass is the name of his law firm, actually, incidentally. Try it out. Wait, Fatso the lawyer's first lawsuit? When was this? Now. It's now. He's never done it. He's never done this. The only person Kurt represented before this was Kurt. I don't know if he was even a lawyer back then. He sued the patent office. Old School Gamer says this guy is still streaming. Lemafau. Yes, I am still streaming. I've not stopped ever. It's actually gone on the whole time. Richard Head 99 member for 2 months says Will versus Nick, good match. P.S. that tie still sucks. Wow, you're the one I banned earlier, but you're still here. Oh my goodness. Oh my goodness. Well, thanks for sharing your member chat. Okay, here we go. Let me find. Why does Grok have notifications for me? I don't like that at all. What am I doing? Here we go. All right, 1 second. Let me share this. People are asking me to share this video that Connor, the son of my very, very missed friend, Jeff, he sent me. And almost got it. Okay. All right, I think, oh, here we go. There it is. There it is. So people are asking me to play this before we get started on the Kurt stuff. So we'll do that right now. Calvin Stove Jr. says, hello. Hello, Calvin. Hello. Is it me you're looking for? I can see it in your eyes. Sorry, here we go.
I may be dressed like a Polish pimp, but I'm actually a non-practicing Minnesota lawyer. I may be dressed like a Polish pimp, but I'm actually a non-practicing Minnesota lawyer.
No lies detected. No lies detected. That's just truth. Nothing but the best. All right. So some of you who were here earlier will have to.
Yep.
No. Some of you who were here earlier will be enduring a little bit of Kurt that we already did watch. No, in the cartoon you don't look gay enough. Smokey says, I just wish this channel would provide legal analysis. We're literally going to. That's all I've been doing for months. Oh my God. Nice. Thank you. Nick looks like Urkel's other next door neighbor, the one they wouldn't allow on television. ACAB True Crime says lots of Polacks in Minnesota. Is that true? Is that true? My branch of Polishness came from Detroit and then down to Houston. Okay. Let's see. Hong Kong Fooey says, hi, Nick Ricada. Wait, he didn't say hi at all. He just said, Nick Ricada, stop wearing sunglasses indoors. You look like a fool. Well, where am I supposed to wear them? Outside? That's dumb. Doesn't make sense at all. Let's see. What branch of Pollock are you? Marine or Air Force? Jackson. I think. Yeah, Grim, the guy's a hero. He comes in here, he's like, I'll make everybody else members, but not myself. I don't know. And it's a strange strategy, but I do respect it. It's different than other people take, and sometimes the unorthodox is the way. Okay, should we get this started, y'all? Should we get this started? Is YouTube still having their thing? Alaskan DW says, you're getting old. Just buy readers already. I don't want to. I don't want to do that. Aaron James says, I want serious legal analysis. Well, I don't even want to tell you what I want. If I'm willing to do mine, are you willing to do... Or wait, if I'm willing to do yours, are you willing to do mine? Kevin Butler says, I don't know how I feel about the newer Much Gayer Nick. Look, buddy, it's okay to be confused. Don't worry about it. Just let it happen. Just let it happen. Brian says, Nick, don't forget us about us over here on Rumble. Nick, why aren't you dressed like an 80s porn star? I invented a time machine. He's going to be the kind of boomer that still wears his starter jacket. I don't even have it anymore, okay? What do we got? What do we got? Joe just let you out? Oh, man. That was nice of him. Foulmouth Jerk says, hello, Nick. Joe sent me. What a bro. To the Joe viewers who are here, welcome. We are just about to get started. Nina Infinity says, what the hell are you wearing, Nina? What the hell are you wearing, Law? Look, Nina, you're right. I'm sorry. Let me take it off. I'll just take it off. Just a second. Wait, why is it 70s gay porn star? Someone said I look like an 80s porn star. I don't get... I assumed hetero. Speaking of hetero, Debbie Baker gifting 5 memberships. Oh my goodness. Thank you, Debbie. What's up, Joe? Thanks, brother, for all the raids lately. He says, better call Nick. How you doing, my man? How you doing? I'm going to see if I can get a hold of you tomorrow. It's been too long. But yes, thank you, Debbie Baker, for the 5 gifted memberships. That brings us to 15. 15 of those. And for anyone who's just joining, you know, because they were dutifully and diligently hanging out with my homie Joe Neerman. For anyone just joining, we're about to analyze, another law tuber. This is my new hobby. It is to review the legal analysis of other law tubers, to see how they're doing, to rate them. Rate them. Smokey LGC says 30 minutes in, he's just been talking about himself the whole time. Get to the point. I'm already there. I'm already at the point. Goodness gracious. Oh. So the oh my goodness. I haven't just been talking about me. There was that video about me also. My goodness. Aaron James says, I'm here because I heard bad things about you. Honestly, I do my best to remain objective. Wait, see, you're like, oh, I heard a bunch of bad shit about this guy. I better show up and check it out. I like that. That's cool. That's awesome. So no more hot tub streams. Why would you say that? I haven't done them. But that was mostly because I haven't been using my hot tub much this winter, which has got me depressed, and I've gotten a request from Lady Raggets to remedy that. So 30 minutes in, we haven't pointed out how gay his shirt is enough. That's true. That's true. Nina says Nick is a good boy now. Well, I guess I'm a sober boy now. I don't know if I'm good. Only God is good, Nina. Our works are as dirty rags to him. That's such a depressing line from the Bible. Nick, so how's your best friend Kurt doing? Love his cooking shows. He has not been cooking lately. I'm really worried about him. What Peachy, don't tell him. Shh. Kurt has not been cooking. I'm really worried that he's in a food desert or something like that. I'm concerned about his health, but like it's up to him. People have to want to get better. So he hasn't been cooking. I'm not sure what happened. He for a while he was doing them with some relative regularity, and then all of a sudden it stopped. And I'm not sure if there was an instigating event, but it's he just hasn't been doing them lately, which makes me sad. But there's plenty of other stuff. This isn't the Kurt only channel. It's just the Kurt often channel. BC and Fam says you made him cry. I hope not, unless he recorded it. That would be funny. But if he didn't record it, it's not as funny. Aaron James says, why does the cat on the wall look terrified? Okay, do you not know, are you not familiar with you can't see the top of it, but it says, I'm mirrored. It says, I am not a cat. It says, I am not a cat. It's a meme. There was a Zoom hearing for a court case, and the lawyer is this old guy, right? And his granddaughter had been using his laptop the night before. He was playing with filters. And so he's on his Zoom meeting with the court, and he shows up as this big fucking cat. And he's like, we're trying to fix this. Says, I am prepared to still proceed. I am not a cat. It's just a super endearing moment. It was a viral video that went around, and my friend is a guy named Eric Waugh. He's an artist, a Canadian artist. I've recommended his execution a couple times because of the Canadian thing, but whatever. But he sometimes paints paintings for charity. So he paints them and then auctions them off on Facebook for charity. So I picked it up because I really liked it. So, okay. Here we go. What do we got? Forlorn Tim. Wait a minute. How's your... here we go. Okay. Forlorn Tim. Yeah, so we're getting an update on your situation, I think. Banner Day, leaving the hotel for actual month-to-month room. Meanwhile, wife has house full of my work equipment, but I can't just get it or I go to jail. I'm not sure why jail is in quotes, because I think you go to actual jail. But she complains she wants it out. Makes no sense. Just buy more, huh? Yeah, isn't it amazing how that works? Ruby. I know who you are, Ruby. What's up? Welcome, Ruby. Nice to see you here. Thanks for showing up. Did I paint the Joker? Dear Christ, no. I have no talent in borderline Parkinson's. Do I feel like the Joker? No. What I really liked about Joaquin Phoenix as the Joker specifically was, that movie came out after a series of interesting happenings online. And it was, it was a silent scream of the we'll say 24 to 35-year-old male in America, particularly white male, at the time that it came out, following things like Sky King, the guy who stole the airplane. And, he had a radio conversation with the air traffic controller that went out on the internet and went viral. And you're like, why is this going viral? And it's like, because this guy is saying what this generation can't, what they're begging to say, what they're all dying to say. They're all sitting there saying, why the fuck won't you guys listen to us? We do all the work. You underpay us, you disrespect us, and then you trample us, and then you call us evil. And he said, I'm not going to take that anymore. And he took a plane instead, and he did some barrel rolls in an airliner, and then he crashed into the ground. And the way that impacted a specific segment of a generation of men, of white men in America, was reflected in the Joker movie. It was embraced by in the same way that Sky King was. And like that cultural phenomenon made me love the movie so much. It was to watch it. Also, like I was slightly aged out at the time it happened. I was a little bit older than that. I had kind of been through the process of like waiting for people to respect you because of an arbitrary thing like your age. Just waiting to have any sort of attention paid to you at all. And then all of a sudden, it's like between 33 and 35. People are like, oh, wow, you're respectable. You're like, wait, like 2 weeks ago, you told me to go fucking kill myself. Today, you're like, no, I want to hear your ideas. And it's literally that fast. It's such a weird thing that guys go through. It's like a second puberty, but with employment and social interaction. And it doesn't make any sense. And it was thinking about where we've gone from like 2018 to 2026 with things like the Me Too movement and, then going through COVID, the Summer of Love riots, watching the progression from towards leftism and then a hard correction back towards the right. And all that was sort of encompassed in Joaquin Phoenix Joker. So I've always, I resonated with that movie immediately because of what I had witnessed, not particularly because of what I'd felt. Like I said, I was a little older than that, but yeah, that movie really hit home in that way. I liked it. That was a long answer. Hi, Ruby. How you doing? Being a millennial is weird. I'm not a millennial. I'm a Gen Xer still, I think. I'm like the last, one of the last years of Gen X. Kay Starler, I think the funniest thing possible would be to find out. I don't know if he ever said the artist's name, but to find the artist and be like, can you paint me that exact painting and then hang it on the wall? I think that would be so fucking funny. God, that'd be good. Okay, let me hit these super tips, and then we are going to start the show. Like, we're going to start into the actual topic of the show, and it is legally based. It is also based, so that'll be fun. Mistress Meg, micropeen peep show. Why is there a pole dancing peep? Yeah, I find that to be wildly charming. Thank you. A-Cabs is my favorite version of the Joker sent too soon before. Joaquin here. Yeah. You're a liberal and Joaquin Phoenix is your favorite version of the Joker. Okay, very cool. Very cool, very cool, very cool. Yeah, I like it. The guy who painted it, if you're curious about the artist, it's a guy named Bill Mack. He's mostly known as an American sculptor, but he's a phenomenal paint artist as well. Forlorn Tim says, at least can look down on Kurt and his career, maybe. Yes, everyone can do that. Like, even if you were like, even if it's not real or like justified, you can still do it. Forlorn Tim, chat, just send someone is indirect contact, also jail. Great news, though, can coordinate with her mother, my biggest fan. I'm sure you can guess. It's like, that's how they just, that's like the subtle self-gatekeep. Okay, we've got this avenue for you to, go ahead if there's anything that you really, really need to take care of. Oh, what is it? Here, talk to your mother-in-law. All right. Can I do it by putting a 9mm to my head? Still hilarious. You haven't seen the Peep Show in forever. Is that an old? Okay, so that must be an old thing that I missed it. Millennials are 1983 to 2000. That's why they are called that. Google is asshole. Yeah, I'm 81. So we are Zennial. Chris V. Clements. Yeah, I guess I get that. My sister's 5 years older than me. She's, she's in Gen X. But in that 5 years, there's some change that happens. As she got all her trouble out early on, I waited till I was 40. Destiny X Rose. I love you, Nick. Well, let's get to it. I'm fighting my sleeping pills. Okay, let's get started. I love that. See, that was direct. It was forceful but gentle. It was respectful, but with a little bit of, come on. Come on. I know you like to be slapped a little bit, Nick. I don't like that. Have you seen Kurt has a Zoom hearing coming up in his case? I have not seen that, but it's a federal case. I don't think you can record it. All right, here we go. We're going to get started. What is this? Like Nick's sex life. What are you answering? With that? I'm very insecure right now. I'm just kidding. Chechunia. What is this show about? It's about laughter and mirth. Come on, Chechunia, you know what it's about. I'm having a good time. Here we go. Felzu says, you are drinking like a fat. Dude, I know. Thanks for calling me out on that. Did you get some Glazers with that pop? Ew, don't call it pop, please. Quick Trip does make some sweet pastries. This is a Taco John's soda. It was brought to me while I was streaming. My kids went to Taco John's after school. Treasure Island says, am I disappointed by the lack of outfit change or happy to see the yellow tie again? I can't decide. Fashion is a fickle mistress. Both. You can be both. This is a serious stream. Grim602, very uncouth, says, come on, Chunia. Come on. Why would you do that? I mean, no, I know why you would do that. Why would you say... Okay, listen. I like the cut of your jib.
I like how you have become the boogeyman of Uncivil Law. Cooking with the Ogre got canceled. I missed the horror of that show and the sodium counter and the impending heart attack or stroke.
The sodium counter fucking kills me. Let's do some math here and figure out how close he is to dying. Chichunia says, who's coming on me? I don't know. I'm not privy to that information. Treasure Island says, nobody come. Stop it. Oh, I'm going to come. What the fuck? What is happening on this show? Whoever the host is an idiot. Oh, wait, what is this?
Nick's shirt isn't gay. He plays the token white background actor in Kid and Play movies. Dude's got cum on his shirt from jerking off to Tootie from The Facts of Life. Do you like black people?
It's like, okay, mild intro, little insulting. Bam! Dude's got cum on his shirt. Like, Jesus. It is Mardi Gras. I'm indulging. Leave me alone. Hey, Cab, it's been the most fucking fun thing. On stream, off stream, it's been the best. It's been the best. I fucking just every day I'm so happy for the dumbest reason. Okay, I need to just update the YouTube banner because I think I didn't update the member number. Or no, I did. We're at 15 members for the show, 1 micropeen, and we are go time, baby. Let's go. Are you ready to be yelled at?
Well, hello, everyone, and welcome to Uncivil Law. And for today's story, we are going to discuss a case that yours truly, Uncivil Law, has filed in federal court on behalf of my clients. It's been a while since I've done one.
Oh, wait a minute. Mr. Gix, there's no echo. I prepped this time. Your tie matches Kurt's mic. I want his mouth on my tie, too. Was that a snort from Kurt? Oh, I don't know. I was busy focused on me. Hold on. Let's go back and check.
A story. We are going to discuss a case that yours truly, Uncivil Law, has filed in federal court on behalf of my clients. It's been a while since I've done one of these.
Okay. I didn't hear a snort. We're going from jump. I know you heard that last line where he said it's been a while since I've done one of these. A while being forever.
Well, hello, everyone, and welcome to Uncivil Law. And for today's story, we are going to discuss a case that yours truly, Uncivil Law, has filed in federal court on behalf of my clients. It's been a while since I've done one of these, and hey, you know.
I love it. I love it. It's been a forever, literally, since I've done one of these. Chartard says, Gypsy Crusader was the real hero we need. There you go. There you go. Here we go.
There's good content. So I do support work from time to time, and other people.
Damn it. I chuckled at doo-doo in the member stream, too. I knew it was coming. I still am like, like an idiot.
Most cases and consulting work and stuff like this. But it's been a...
Hold on, guys. I need to take just a minute. Wildling Soul. Be groomed. Get groomed. I'm sick and tired of you showing up here and not being groomed. So, again, get groomed. That's all. I think you understand.
Hot minute since I've run one of my own cases. So we're going to discuss this wonderful case as it goes. So we're going to pick up where we started off basically 3 months ago. So that's sort of how I'm going to do this to prevent me from discussing things that are like, happening right now where things could be a little bit sensitive. I figured, the best way to try to approach this is like do it, but with a delay, right? So rather than discuss things as they're happening right this second, where things could, obviously invoke tactics and strategy and stuff like that, we're going to just do things based on what happened a couple months ago. So we're going to pick.
So yeah. This stream, by the way, is from about 4 months ago, so 3 months prior. So we're 7 months behind.
Proud for doing his goddamn job, because YouTube sure as shit, ain't it?
Ruby was in a band called the Groomers back in the day. That sounds good. That's good. K Starler says, Nick, that Brennan dude said no grooming from you. It's like, why is he trying to get in the way of my dreams? I have a mission. I'm out here trying to groom all these people with like gnarled up hair or whatever. I'm just trying to fix it. He's like, not Nick Ricotta. He grooms women. Notorious groomer of women. I'm like, yeah, I didn't need a cheerleader, but I'll take it.
Pick up with the file.
Wait, I am a cheerleader. Fuck.
From a couple months ago, and then we'll like proceed forward in time from there as we go. Now, obviously, things are a little bit tricky here for me as counsel because I'm obviously biased in favor of my client.
Count the smirks per second in this video. It's fucking unreal. I'm obviously in favor of my client. Yeah, we know. Oh, are you?
So I can't be the normal, quite objective uncivil law that you would see where I try to provide things in a more objective light. But I will try to provide things, how about this, in the view of counsel's light. So I'm not going to like openly discuss my own weaknesses because that would be really dumb, right? I'm not going to try to highlight things where I think I'm weak.
That's what I'm here for. Don't worry. We got you covered, brother. You are in no danger of looking strong.
Like I know places where like any chess game, I have spotted places where I think I might be attacked, right? This may or may not correspond to where the other party thinks I'm weak. But I, like, you know, a good military general or like a good chess player or like any good strategic player have
any good strategic player. I like how you put good in front of all those. No, like a good thing, like a good thing, like a good thing. I am great. I said this earlier. I'm not going to delve too far into it. Like there's a thing about streamers where people like accuse them of being narcissists because, you know, they're in front of people and they get attention. They kind of, you know, they drive themselves off of that attention. So, which kind of looks like narcissism. And I went into a whole spiel about how narcissism was defined before mass amounts of exposure and attention were broadly available. You had to go through major media channels. Now you don't, because of democratization of the signal. Hack the planet! That has allowed anybody and everybody to be in front of hundreds to thousands to 10,000s to millions of people just because they have a phone. And everybody has a phone. It's amazing. Narcissism was defined before that was real. So now, you know, they're going to have to go through and start peeling back that as a manifestation of the underlying condition of narcissism. You know, that isn't such an easy way to identify a narcissist these days because it's available to all of the non-narcissists also. Kurt is truly close. I don't know if he's fully narcissistic. I'm not trying to diagnose him or anything, but he is truly close to it, and it's a marvelous thing to behold, in my opinion. And it's heaps of it in this video. 2 scoops like Raisin Bran.
Spotted places I think I'm weak. So I have ideas where things are weaker, but I'm not going to tell you that. First of all, I don't need to give the other side any ideas. And second of all, you know, like they may not think I'm weak there. So why, you know, exactly. Why do that? That sounds dumb.
Tom Colby says, ever notice how the mirror steams up when you kiss it, Nick? I know someone who doesn't use tongue on their mirror.
So we're not going to do that, but we are going to do covering the case, and we're going to pick up from the first amended complaint, which is document number 15. So the brief procedural history of this is that this was initially filed in state court, and then the government defendants removed it to federal court, the fancy term for taking it to federal court. They don't call it transferring it to federal court like a normal person. No, we call it moving it to federal court.
No one calls it moving it because most of us don't vomit words out. What is going on? I thought the first one was a weird burping thing, but that's just apparently how he says move. No, it's not called a transfer because it's not a transfer. A transfer is something within systems. A removal is a removal from the system to a different one. Removing from state court to federal court removes you from the state court system into the federal court. They're separated by the layers of federalism. It's not a transfer. A transfer would be from, you know, maybe one county in the state to a different county, something like that. Something within the same thing. Pulling it out of the state court system is a removal. That's why it's called a removal. It's not a transfer. That's why they don't call it a transfer. It's not because of some thing. It's because it's not that. It's specifically different. I'm going to lose my mind on this.
Ricky, that we need like Kurt smug emote for the chat.
Just smug Kurt emote. That'd be pretty good.
Because we have to be all fancy about it. So they removed it to federal court. And then once it was removed to federal court, my clients contacted me and be like, okay, can you help us out? I'm like, sure. So the original complaint.
Tom Colby, Nick's streams always bring out the worst of me, lol. Me too, brother. I'm with you 100%.
Was the complaint that was filed in state court. But then, of course, once I took over the case, I'm like, well, I want to file an amended complaint because I'm going to run the case. So we're going to pick it up from the first amended complaint. So this is the
Kurt saying, I'm going to run at all. My brain just starts laughing. I don't care that he's following it up with something else. Okay, Ms. Divine says, hey, Ricada Law and fam, what the freaking heck is up? I heard this is where everyone was coming. I do have a reputation for that. Welcome. Come share your turgid member in the chat. Don't ask for permission. Just ask if they liked it. Here we go. I was looking for something. Shit.
Case of Austin Hamblin and Kiska Hamblin versus Martin County Sheriff's Department, a whole bunch of Sheriff's Department officials, and a guy named Brian Snellgrove. So the Hamblins versus sheriff's deputies, and a guy, Brian Snellgrove. Okay. And of course, this is all going to be based on public filing because I'm not going to discuss privileged information because I'm not an idiot.
That remains to be seen. I have seen people in the chat asking, can he do this? Yeah, you can. He is fully able to talk about this case. It would be different if he was a prosecutor or a judge. They cannot talk about, they have, some ethical obligations. Oftentimes, attorneys, their ethical responsibility of zealous advocacy for their client, it behooves them to, in some way, put out some form of messaging, and how you do that varies from client to client and lawyer to lawyer. There is nothing particularly automatically unethical about doing what he's doing. And so far, I haven't seen anything unethical from him, but I've only watched 10 minutes of this thing so far. So we'll see. But that being said, is it wise? Is it the right move? I'm not so sure, man. I'm not so sure. I think talking about a case after you represented someone in it is fine. Talking during the representation, he's given it a multi-month delay, so I guess that's the thing. But I'm just not sure that it's. To me, it doesn't seem prudent. But we all do our things our own way, don't we?
Okay, so let's discuss. Let me make this a little bit bigger so you can read it a little bit easier. Hold on. There we go. Make it.
PG, are you talking about a 6-hour stream here or somewhere else? Are you talking about Kasi G doing a 6-hour stream or me doing a 6-hour stream? Because it's quite possible we'll have a 6-hour stream tonight. Oh, yeah, I'm sorry. If you're showing up now, you don't get to leave. You got to stay. You got to stay until I am done. And I take a while to finish.
Nice and pretty. That's better. Great. All right. So Austin Hamblin and Kiska Hamblin find themselves stripped of their possessions due to the actions of Austin's former employer, Brian Snellgrove.
Okay, just as a point of, a point of explanation, because he didn't do a very good job. He's starting to read the First Amendment complaint with his first paragraph. The first paragraph is kind of an introductory paragraph. When you write When you do legal writing, the typical format is called IRAC. It's intro, rule, analysis, or argument, and then conclusion. And you set that up. And you structure your entire document that way, and then you structure places within the document that way. So if you're within your overall argument section, for example, you may have several issues that you need to address and go through and make arguments for. And so you'll do the IRAC format kind of through each one in some way or another. That's how it goes. It's the structure and substance of legal writing. So your intro should always be a banger, right? Like your opening line better be worth it. I recommend, "Hi, I have cocaine. Do you know where the bathroom is?" It's a good one. Give it a shot. I bet you get some miles out of it. That being said, Kurt chose a different route. He has, so it's important to bring this up because what Kurt has to do at the beginning of this document is hook the judge. This is storytelling 101. Hook the judge. It's not 1970 anymore. Our horror movies don't have 45 minutes looking at you, The Exorcist, where basically nothing happens until suddenly we have a child talking about sucking cocks in hell, which is kind of funny. We do things way different now. Shit happens fast, happens early, it grabs you. You got to tell them why it's important. You got to grab them by the collar and you got to bring them wherever they're going. I don't know. Make up something cool that I said. But you have to do it right from the start. So this is Kurt's hook. This is his, like, I'm going to grab you by the lapels, right? And I'm going to take you on a storytelling adventure. That's this first paragraph. So here's where you're supposed to tell us what's going on. Remember, the court doesn't know. This is a first amended complaint, but who cares? This is your first words of the story to anybody.
The villain of the piece, as it were. Despite Austin Hamblin's innocence and eventual dismissal of criminal charges for lack of evidence, Snellgrove manipulated law enforcement into an unwarranted raid of the Hamblin marital home.
Kurt's leaving out part of the story. So Kurt's client, whatever that guy's name, Austin Hamblin, was employed by Brian Snellgrove. Brian Snellgrove said, "You're fired. You're fired. Get out of here. Not any good. You never were. You never were any good. I never liked you. Never able to complete a task." And Brian Snellgrove says, "Yeah, get out." Austin retains some of the tools of whatever trade. Whatever trade. He doesn't really say what trade it is. I'm not sure why, but he retains some of the equipment. Snellgrove reports the theft of his property as the business owner, whose employee retained equipment that did not belong to him, and the police executed a search warrant in which Brian Snellgrove participated to the extent of identifying the items that belonged to him. This led to the criminal charges for the unlawful conversion or theft, however you want to do it. I'm not sure what the actual charges were. Maybe Kurt will get to that, but conversion or theft that was charged to Austin. Now, Austin beat those charges, possibly because he came up with a defense like, "I didn't actually try to take him. Like I forgot, or I didn't know, I wasn't aware." Whatever it is, he was able to beat the charges. That doesn't mean that the property belonged to Austin. Now, the soul of this lawsuit, its beating, thumping heart, is that Austin is mad that when he beat the criminal charges, the government returned the property to Brian Snellgrove instead of him. He's like, "No, I beat the criminal charges, therefore my theft is justified." It's not quite how property rights work. So now Kurt is suing the government and Brian Snellgrove for violating Austin's rights with regards to this property that wasn't his. That's the soul of this lawsuit. That's what this is about. And it's one of the most amazing, conceptually amazing things I can think of. Like imagine you leave, your employment, you work at a IT company or whatever, you have a company issued laptop, and they're like, you got to return the laptop and, maybe a couple external hard drives or whatever. You're supposed to return those back to the company within 60 days or probably faster, probably 2 weeks or something of your termination. So you got 2 weeks to, get rid of them, give them back to the company. And you don't do it. And they send you a letter and they're like, you need to do this, and you don't do it. So then they, inform the police that there's been a theft, because there has at that point. It's their property. It's likely in your severance agreement, your termination agreement, or your employment agreement, somewhere that any property that was given to you that wasn't specifically, granted to you on a permanent basis would need to be returned at the end of your employment within X amount of days. Like I guarantee you it's in there, because if it wasn't in one of those agreements, the first time the company got burned, it would be in everybody else's agreement after that. So this is not an abnormal thing to have that happen. The amazing thing is that someone's like, no, I'm going to sue over this. That's crazy to me.
This egregious abuse of trust and authority.
Oh my God. Tyler, the perfect storm. When are you going to face Keanu again? When she can spell vociferously without help.
Led to the seizure of Hamlin's property and unjust enrichment of Snellgrove. Defendant disregarded the legal boundaries and proper procedures that only violate Hamlin's rights, but has also inflicted significant personal and financial harm. This case seeks.
Mind you, he is suing the police for executing a search warrant with probable cause. He's suing them under 1983. That's an insane proposition because they executed the search warrant. But maybe they didn't have probable cause. Maybe that's why there wasn't evidence or whatever. It'll be interesting. Forlorn Tim says irony abounds.
Is it unethical to have such a micro penis that it needs a special microscope to view it?
Yes, that action is unethical. Actually, I saw that. I've been looking up earlier, in the ABA recommended rules of professional conduct, if that was unethical, and they did say yes, it was. So thank you for asking. Sometimes I get to do useful research during the show.
To rectify the injustices endured by the Hamlins, ensuring such predatory behavior is acknowledged and rectified in the eyes of.
Tyler says he knows Keanu cooked him. He has yet to get his revenge. I accomplished exactly what I wanted to do on that stream. I have no problem with it. Dumb bitch.
The law. So, a little nice little cold open, a little spice, a little bit of drama to try to get, people interested,
He's telling you how good his storytelling was in that intro. he's like, look, I had a little cold open. Why do you have a cold open? What are you talking about? A cold open? Little spice, little drama? There was zero spice or drama. Autistic people telling you about the elements of storytelling is phenomenal. It's one of my favorite things.
Don't want to overplay your hand here, but just a little spice to get you started, and a little bit of excitement to get the energy and the blood rolling. All that good stuff. All right, great. All right, so why are we in federal court? Well,
thanks for telling us why you did your intro that way. It was really helpful.
The government defendants removed themselves to federal court, so they want jurisdiction. So yeah, we don't really have to have a jurisdiction fight because the defendants themselves took it to federal court, so it kind of solves that problem. But in any view, we'll just do jurisdiction anyway. This court has subject matter jurisdiction over claims pursuant to 1331, as there are claims that arise under the Constitution, laws, and treaties of the United States. Namely, this action involves federal questions pertaining to 42 U.S.C. 1980.
42 U.S.C. 1983 is, I think it's deprivation of rights under the color of law. So it's when a government action, or when someone uses the auspices or artifice of government to deprive you of rights improperly. It's the claim you would use for, police officer improperly detaining you and stuff like that. It's a pretty broad catch-all statute. What's about to happen here is frankly amazing. Frankly amazing. He says, this involves federal questions pertaining to 42 U.S.C. 1983, thereby granting this court authority to adjudicate the matters herein. That's fantastic. The next line, the court has supplemental jurisdiction over related state claims. Where was it? Oh, it's going to be in the... But am I crazy? Hold on. Okay, no, it's in the next section. It's in section 3. Section 3 has this magical moment. I'm sorry, I thought it was in paragraph 3. I thought it was in paragraph 2 that had the magical moment, but it's in paragraph 3. So I'll wait. I'm previewing it because if you know your civil procedure, it's really funny. Speaking of people who know their civil procedure, the MG Law and their viewers have just stopped in because they're raiding this castle. But buddy, the gates were wide open. All you had to do was show up with some non-alcoholic beverages and cocktail weenies.
3. The general cause of action if you want to sue the police. Right? The police did something wrong. I'd like to sue them for a violation of my rights. 42 U.S.C. 1983 is your go-to, right? So that's our federal question.
I'll be watching.
And also there's a whole bunch of state law claims that are coming along for the ride on what's called supplemental jurisdiction. Federal courts hear federal claims, but they can hear any related state claims so that the entire piece gets adjudicated all in one thing. The court has jurisdiction over the parties, as in this case.
The MG Law says I showed up with beignets. Un homme après ma cour. Man, I want some beignets now. I thought that was a nice thing that you said, but I've changed my mind. That was rude. Now I want some fucking beignets.
The defendants committed acts giving rise to this claim within this district. So the acts that happened in this place. So that kind of solves that problem. The events or omission giving rise to the contact occurred within this district, thus establishing minimum contacts. Yeah, you don't really...
This is wild. Because this is Kurt. Kurt is a drafting perfectionist. Kurt puts in that this is a federal question. Cool. Makes jurisdiction really easy. And then he puts in sufficient minimum contacts. Now, I don't know how much any of you know about civil procedure and diversity jurisdiction, but sufficient minimum contacts is from diversity jurisdiction. Now, Kurt is about to tell us this, so I'll let him do it because he's going to do it well. And you're going to just sit there wondering, why the fuck did you put this in, you dummy?
Need minimum contacts when the event actually just happens there. I mean, but this isn't diversity. So
You don't need minimum contacts at all. What are you talking about? I mean, I guess you would have to show personal jurisdiction over each of the people if like that was a question. But yeah, this isn't diversity jurisdiction. All these people live, they're all there. They're all there. Why are you talking about minimum contacts?
Really didn't need to say minimum contacts because minimum contacts is only really a concept in diversity jurisdiction. And this isn't diversity. This is federal question jurisdiction. But I guess what the hell? It's not like.
He wrote it. He wrote this. He wrote it. He's like, what? Yeah, the guy who wrote this didn't really need it. I mean, you don't even really need this at all. Why? You wrote it. Why'd you put that in there? That doesn't make any sense. He's even confused about it.
It's not like wrong to say it. It's just perhaps slightly out of place, but whatever. With a form satisfy constitutional due process. Venue is proper under 1391 because the events occurred here. So yeah, the jurisdiction is proper because it happened here, and the venue is proper because it happened here. Great.
The venue is not proper because it happened there. The venue is proper because it's the most convenient forum for the highest nexus of I guess availability for all parties and the locus of the primary evidence and the ability of the court and the parties involved to review it. It's not because it happened there. That's jurisdiction. Venue's different.
Moving on. The parties. Well, the plaintiffs are just some people. The government is the government, and the defendant, Snellgrove, is just a guy. Okay, moving on. Here are the basic factual allegations.
That section might be interesting, but because he completely glazed over it, I guess we'll just assume it's not. But if any of those people don't live in the forum, there would be potential problems there. And you maybe have to say why the court would have jurisdiction over them personally. But I assume they do live in the forum, so we'll just roll with it.
Allegations. Plaintiff Austin Hamblin was an employee of Brian Snellgrove, who operates a distribution business for Snap-on Tools. Easy enough. Defendant Snellgrove reported to the Martin County Sheriff's Office that he suspected plaintiff Hamblin of stealing tools and products from his business.
The amateur Ann says, I think the company I work at is going to be involved in a mining/dam failure. I'll probably die, but would my family sue, or should I just up my life insurance policy? That's an interesting conundrum. Why not both? Up your life insurance policy. Also, your family can sue for wrongful death. Having a good life insurance payout does not preclude a wrongful death suit. So, make sure you do both. Also, Godspeed, and may the hand of the Lord protect you from whatever rubble or water-related hazards are coming your way. The amateur Ann says, if someone died at work and had private life insurance, should the surviving family sue the company or the life insurance? If someone dies at work and had private life insurance, they should file a claim with the private life insurance. Private life insurance should pay out the claim, and if they want to, if they want to try and recover from the works insurance policy, they can go after the employer. The person can also, again, still sue for wrongful death, even with the payout. In fact, the insurance company may pursue the wrongful death claim, as part of that. So they'll pay it out, but then they'll seek compensation from the company or the company's insurance, to put the cost where the fault is, if that makes sense. Hope that helps. Make sure when you enter the pearly gates, first of all, tell St. Pete I said sup, and see you in a little while or whatever. But make sure you get a heaven phone that you can text back to your loved ones and let them know what to do next. It's very important. If you don't get it's like prison. They give you that tablet to use. Get one of those. Okay, Miss Divine says, oh, once upon a midnight dreary, I woke and saw Kurt in my head. I couldn't escape the memory of his gross face. Man, he looks like he's dead. But, dear Kay, Miss Divine, at least you did not see him in your bed. And that is that's my bars back to you, girl. Here we go.
Nick's shirt isn't gay. He's going to put on a dashiki and read poetry about black slavery. I'll yell if I want to. I don't live by your rules.
Yes, you do. You live by whatever fucking rules I put down.
Based on Snellgrove's unsubstantiated allegations, the Martin County Sheriff's Office initiated an investigation in the matter, leading to the involvement of Sheriff James Ingram and other law enforcement personnel. You know,
Why are you smirking? What's your smirk for? What about that was smile-worthy?
just the facts, ma'am. In May of 2023, law enforcement accompanied by and with active participation of Snellgrove executed a search warrant at plaintiff's residence located in Texas. Okay, so that's, I guess, the first spicy allegation, right? So I'm alleging not
I would put it at mild.
only did the sheriff's department, you know, do a search warrant as they might do, but I'm also alleging the guy, the victim, also participated in that search warrant himself directly. He himself personally participated substantively at the time with the search and seizure.
He thinks this bit where you talk like this to emphasize your point isn't gay. But it's gayer than a whole bag of dicks going in your mouth. For men. That's not gay for ladies.
Listening to this for a second time today makes me want to blow my brains out, but I have no more brain cells left from listening the first time.
He just did a little dandruff swipe on his shoulder. Look, as someone who has seen an occasional flake, I gotta say, there is little more terrifying on the planet than when you're looking at yourself on camera and you see one just sitting there and you're like just a little one, like just right here, and you're like, how the hell am I gonna do this? You're like, oh, let me look for something. I didn't find it. How do you do that? It's the worst. It is the worst. And do I think Kurt bathes? He's scratching and wiping his face a lot. Well, you've ruined my evening because my brain automatically pictured it. So thanks for that. You know, some people are real bros, and then there's you. All right, back to this. Back to this.
Himself. See, now that's a problem for Snellgrove.
Why? This is amazing. Why is it a problem? So Kurt's like, he helped the police. He did. Just a guy. But that doesn't really mean much of anything. Kurt's got this legal theory brewing. He's brilliant. That he is going to show the court that because the guy identified the tools that the police were seizing during the execution of the warrant, thus assisting the police by identifying his own property and avoiding the improper or extraneous seizure of property that wasn't his, that the police might have been confused about. By doing that, Kurt is going to try and craft the idea that this guy is a government agent or a quasi-government agent, and therefore bound by the rules and principles of the Constitution because he is now a state actor. This is, I doubt this is going to be effective. This is the only way he can sue Snellgrove under 1983. He can't do that because Snellgrove isn't a government actor. He's a He's just a guy, like he keeps saying, just a guy. So, which, by the way, is not you coming on here and saying he's just a guy over and over and over, like that doesn't help your case at all. It doesn't hurt it much, but it undermines the whole premise that he's not just a guy. He's a government agent in disguise as a normal citizen. He is the government's tool that they use to subvert the rights of your client. That's what you should be claiming, because if you're not, you don't have a fucking case. The state actor theory, or the state actor doctrine, is the idea that if someone is employed by government or appointed by government or empowered, deputized, and trusted with government authority, what do you want? Why would you do that? You gave me a heart attack. You don't know what to do? No, it's not. What you need to do is go to bed. You need to stop messing with a girl. I can't help you. I'm on a show and completely unqualified for this issue. Did you ask Mom? What do you think I'm going to be able to do in the middle of the night? You're going to be cooked right here at home in just a minute. I've got an oven. I was going to make a Hitler joke, but you're too young for that.
I make Hitler jokes all the time.
No, you don't. She does not.
I hate Jews.
What? Stop! What? Get out of here. No, I can't help you. I don't know at all what to do. No, I'm busy. I'm working here. Your hair is not purple. I'm looking at it.
Color as my face.
Your face isn't purple either.
Okay, well, my hair is not either. Look, it's the same color.
I'm sorry, y'all. Is this a live stream? Am I live? I think so. What? No. I'm not live. What do you, I don't know how to do anything about your hair color. Take it up with the Lord. Yes. Get out of my office. I'm going to make fun of you in just a second. Get out of here. I did not. Don't tell anyone. Help your daughter, man. She dyed her hair last night and she didn't like the results. And she's been trying to fix it. And I'm like, you really don't have any attempts at this, because you'll cook your hair and it'll all fall out and you'll look like Sinead O'Connor or whatever. And you should look like Sarah Connor, because she's a badass. And she's like, Dad, my hair looks purple. It doesn't, by the way. It looks blonde, because that's what it is. But she's like, it looks purple. What am I going to do? Like, go to bed. I don't know. And she's, help me. Do I look like an aesthet? I might look like someone who knows about like coloring hair, but I'm not. That's an illusion. I just realized, do I look like some gay who knows how to color hair? Fuck. What stage is she in the hair dyeing issue now? Post-mortem. Damn it. Short Bus Dave has joined his member rising in the chat. Short Bus Dave, welcome. Welcome. All hail my massive member. Oh my God, he joined at the super lawyer level. The best life decision anyone could make. And that applies to both whites and minorities. That also brings us to 16 YouTube members for the stream. Thank you so much to all of you who are brave enough to leave society and join this cult. What do we got? Sassy J in the UK bringing 5 more into the fold. Thank you, Sassy J in the UK. We will forgive your Britishness because you are here. You are here bringing people to a better tomorrow. Thank you so much. Thank you for joining us. All right.
If true, right? That's a problem for Snellgrove because, well, you know, when you do government action thing.
I just got interrupted. She interrupted me in the middle of my thing. I was yelling about this. So Kurt's theory is this state actor theory, the state actor doctrine. He's going to try and convince the court. And I'm sure he thinks this is brilliant, legitimately, that Snellgrove is a state actor. But to become a state actor, you have to be empowered or entrusted by government with a government task. So given the authority or apparent authority and actual authority of government, you have to do the thing. This would allow you to use the color of law as a non-law enforcement person to infringe on the rights of another. That's what Kurt is allegedly suing over with the 1983 claim. Okay, so he thinks that this is a smart thing to do. It isn't. It isn't. It isn't smart. It's not really an effective use of the state actor doctrine, in my opinion. I think opposing counsel is probably going to do untoward things to Kurt's argument. But I think Kurt's argument will like opposing counsel afterwards, even through the crying. Speaking of crying, life in general, stop noticing. Is what I've heard. Are we just going to gloss over her yelling out, "I hate juice"? Yeah, apple, orange, mango, doesn't like it. Not at all. Not at all. Fletcher boy gifting 5 memberships. Oh my goodness. Thank you. Thank you so much, Fletcher boy, for helping people find the way. Do you know the way, brothers? Let's see. We got the amateur Ann. Says the guy running the repair operation on the dam forgot the dive hat fittings, and we couldn't even make any repairs today. This thing's gonna burst. Hey, look, I've said this thing's gonna burst a whole lot in my life, and I have never had a dam break. So, you know, maybe he was talking about something else. Maybe you guys are. Have you considered that you're talking about something different? Stay alive, man. Don't die. It'd be really depressing. Do you need a lawyer to adjust your will? I'm just kidding. I'm no. John Jelaine says t-shirts are better than tattoos. Ball caps are better than dyed hair. I don't get that at all. I knew I liked you, Miss Divine. Dropping some Blues Traveler in the chat. Oh, you want to give me the run around? Yeah, there's a surefire way to speed things up when all it does is slow me down. You know the Blues Traveler song that I like the best? There's only like 3 that I've ever heard in my life, but the one that I like the best is actually called Amber Awaits. It's a really good song, but I don't know if it's available on... It's not available on the karaoke app that I use. Might be on YouTube Music. Amber Awaits, great song. The writing in it's very poetic. Patently homosexual.
Yeah, that's a problem for you. Because now suddenly you get bound by government action rules. So, yeah. So that's a problem.
Kurt, you're talking about him being bound by government action rules, but the rules are the execution of the search warrant. If he is a state actor, they have probable cause and a search warrant, unless you're going to suggest that they don't have probable cause, in which case I don't know how they got the search warrant. Maybe they got the search warrant invalidated by saying there was some sort of false representation made after Frank's hearing. I don't know. But like Kurt's like, it's going to be a problem for him. I don't know if it's gonna.
During the execution of the search warrant, Snellgrove was physically present and actively participated in the search. Snellgrove personally identified items he alleged were stolen and directed law enforcement to seize them.
Rizla says, are you still talking about cum swapping with Aaron? You're mistaken. There was no swap involved at all. He just stole mine. It was very rude. Very rude. That was not for him at all.
Yep. That's a problem. Based on Snellgrove's representation and acting in concert with and at Snellgrove's direction, law enforcement officials seized numerous items from plaintiff's property, including but not limited to Snap-on tools and equipment. So basically making Snellgrove...
Wait a minute. Wait a minute. Did you just say including but not limited to Snap-on tools and equipment? Meaning the employer's tools and equipment? Did you write that? Including but not limited to. So you're asserting that they stole extra stuff, I guess. But any of the Snap-on tools and equipment don't belong to your boy. What are we talking about? Here we go.
A government actor. Fun. In November of 2024, the criminal charges against Hamblin were dismissed by a prosecutor due to insufficient evidence of theft. Huzzah, right? So
Not huzzah. That doesn't make the property his. It just means that they don't have enough evidence to finish the prosecution. The property wasn't his.
the police had a complaint, a criminal complaint. They got a search warrant. They went to the house. They took the stuff. The prosecutor filed charges. The prosecutor unfiled charges. You know? Now,
Wait, so the prosecutor declined to prosecute? You didn't even beat, like, your client didn't even beat him? It was dismissed by the state, not by the court? Holy shit, your case is cooked, homie. What are you going to do? If you had beaten it because you'd shown the warrant, or the other lawyer, if their criminal lawyer had beaten it because they shown the warrant to be improper or the probable cause to be lacking, and they got the evidence excluded or something like that, where they showed that the government acted inappropriately and that's why it was there, then you might have some semblance of a case here. But your case is based on a withdrawal of the charges? Holy fuck, you're gonna get spit roasted.
yeah. It was interesting because one of the trolls in my channel gave me shit over this language.
One of the trolls? One of the trolls told me he gave me shit over this. Was the troll like an attorney with any experience at all? He wasn't giving you shit. He was just like, bro, this isn't good. What are you doing? This doesn't make any sense. I see Ice Dancer in the chat, by the way. Don't tell anybody that I've DM'd you. God, oh my goodness. We don't want the world to know. I see Ice Dancer in the chat. Why is he suing? Yeah, it's a great question. Homeboy beats his charges. He's like, no, I really want the stuff I stole back, though. Can we get that? Can I get the stolen property back? I mean, I did the thieving.
What is the over-under on Kurt violating the rules of evidence in his first real case?
I think it's a high probability of him making some serious errors here. The one thing that I think might be okay is the argument section of his briefs might be okay. But I've actually been noticing, as I started to back up, as I started to back away from Kurt, which is hard. Gravity pulls you in. But as I started to back away and take like a broader view, which has led me to where I am today, I started to notice something. Kurt doesn't like. You ever know that person that can recite facts about anything, but they don't seem to understand why those facts matter or exist at all, or like how they interact? Kurt can recite things about Supreme Court cases. Excuse me. Every time I see him try to apply those principles, I notice something. I always disagree with him every time, every single time. Whenever I would go on his show and like we'd talk about something and be like, I don't really agree with that. I don't know about that. We would have, and they were fun little intellectual debates about law and discussions, but they were usually like kind of like loftier legal principle sort of things, and then he would say, well, the Supreme Court said this. And be like, okay, but yeah, like I get it. But what if the Supreme Court's wrong about it, like the principle and stuff like that? Because so you have these philosophical discussions, and those are fun and stimulating, and I liked them. But every time I looked at his application practically, I'm like, wait a minute, that's not right. It just isn't there. I don't think he knows how to do it. So I say that his argument section might be well written, but I don't know that it's gonna be because I have no idea why it would be. Actually, I think he has problems with synthesis. I think he has problems generating analogy. I know he has storytelling issues in general. So like we'll see, I guess.
On such a petty thing, I liked when the troll gave me shit over this. He's like, well, technically it wasn't dismissed by the prosecutor. Technically only the judge can dismiss it. It's like, give me a fucking break.
Okay, Miss Divine. Which masterpiece? More lines of which masterpiece? Now I want to know. Are you still on Run Around by Blues Traveler, or are you talking about a different masterpiece? And if there's a masterpiece, what's the slave piece? How many slave pieces are there?
Yes, technically, I suppose the prosecution filed to dismiss, and I suppose technically the judge actually dismissed it. But every lawyer would say it this way, unless they had a reason not.
No, they wouldn't. What are you talking about? Why are you quibbling over this? Yeah, the judge signed the dismissal. Okay, cool. But the prosecutor dismisses the case. Yeah, that's fine. If a prosecutor has an ethical obligation to dismiss a case when they have insufficient evidence to prosecute. So if new information comes to light, or they find out that information that they believed, they confirm that it's not actually accurate or true, they have an ethical responsibility. It's a fucking rule that they have to dismiss the case. So this is a proper language. You're quibbling over the wrong language and focusing on the wrong things. This is going to be a great disaster. Like, I can't wait. I can't wait. Silverhawk 216 says, I feel he is the guy that can memorize the book and pass the test, but couldn't explain it to you outside of the black and white. Yeah, I mean, that's kind of what I'm talking about. It's kind of what I'm talking about, but it's more like someone, if you've seen someone who has a photographic memory, for example, they can look at something and they can tell you all of the stuff that they saw, but they may not understand any of it. They might not even understand the context of it, for example, but they can just recite it because they can see the page and read the words, Eidetic memory is so fucking cool. By the way, it's the curse, right? Shout out to Lord Nikon. Hack the planet!
Too, so whatever. After dismissal of the criminal charges, plaintiffs sought return of their property seized. Yeah, see, that's typically how that works, right? The police seize some things, believing it to be evidence of a crime.
Oh,
the
my
crime
goodness, hold
is
on.
not.
It's adorable. Looks great. No, not a chance. I'm sorry, her name is... I'm not going to say the joke. Satan. Her name is Satan. That was a joke. What? Yeah, Regina George. No, I don't think so. Here, do you want me to... Here. Okay. If anybody bullies you tomorrow, I'll kill them. Wow, so tough. I'm not tough. Leave me alone. So cool. Why aren't you in bed? She's literally, that girl's the funniest person I have ever met in my entire life. No one even comes close. No one even comes close. All of that happened with Kurt's face like this on my screen. Tell her you love her. She's gone. I'll text her. Don't worry. See, okay, here we go. Back to this. Sorry for the distraction.
No longer a crime because it's like, so give me my stuff back. Right? I mean,
yeah, usually they say my stuff back. Give me that guy's stuff back. And it was really hard for me to keep that when it wasn't mine. I need it back. Amazing.
seems pretty normal. Please give me my stuff back. Not so much. Plaintiffs were then informed that at least some of the seized items were no longer in possession of law enforcement or the court, but had been transferred to defendant Snellgrove without judicial determination of ownership or any due process. Yeah, that's...
Hey, cool. Why don't you bring a civil action to assert your property right? I guess that's what you're doing, right? Like to do that. Do you need a judicial determination of ownership? Again, the prosecutor didn't prosecute. Your client should count himself fucking lucky, tuck the tail, and back off. I'm like that. If someone came into my office when I had one, was like, I want to sue the government over this, I would have been like, are you serious? You want to sue your local police who executed a warrant on your house because you want to keep property that you took that wasn't yours? They dismissed it out and didn't charge you, or like withdrew the charges. And you want to kick that hornet's nest? Here, you know what we're going to do first? Let's go piss in Tyson Fury's oatmeal in front of him too, like while we're at it. That seems like a good idea. Want to do that? You got some urine built up in there waiting?
The big crux of the thing, right? That's the problem. That's the big problem, right? The property became...
Aaron James says they can charge for something similar. Even better, they withdrew for lack of evidence. Jeopardy didn't attach. That thing... They dismissed it. He didn't say they dismissed it with prejudice. And if they had dismissed it with prejudice, that would have been in the brief. And if it's not in the brief and it was dismissed with prejudice, then he's a bigger fucking idiot than I thought. But the reason he didn't say how it was dismissed with or without prejudice is because it was dismissed without prejudice, because there was no attachment of jeopardy. There's no adjudication on the merits. They could recharge him right now. We say, nope, we got the evidence now. This is an insane proposition. Like this is where you counsel the client and you say, look, I would love to represent you. I want to take your money. I want to help you get what you're after. But have you considered that you're fucking dumb for trying to go after the police on this matter? Do you drive in your town, sir? Because I feel like you might be getting some new tickets soon. This is a terrible, terrible choice.
Property of Snellgrove, somehow magically, even though there was no hearing, no adjudication, no court process, nothing, right? It's like my clients were in possession of the things. The police seized the things. Was there any sort of hearing or process or anything, anytime that, they didn't own the things? Nope.
Frequently the police are involved in the retrieval of property and pass it to the rightful owner without a judicial determination of ownership. Because most of the time people aren't stupid enough to sue over something that they, they know it's not theirs. This is crazy. This is a wild lawsuit because of this. I love it.
To be fair, if you pissed in Tyson Fury's oatmeal, he would probably tell you that Jesus Christ is his Lord and Savior and could be yours too.
Followed promptly by, why don't you ask him about it, and then he kills you.
Can we have the things back? Nope. Where are they? Well, some of them are Snellgroves now. Wait, what? How's that work?
Not Snellgroves now. They always were. The illegal conversion of property into your possession from someone else's doesn't actually impact the property right, the property rights holder's interest in their own property. You can't steal something and be like, well, this is mine now, like my ownership rights have transferred. That never happened. That didn't happen unless you can show that the right of ownership did transfer. You even called them Snap-on tools. You're going to get fisted on this case. It's going to be great.
I'm confused. Yeah. At no time were plaintiffs determined by a competent body to not be in lawful possession of the property seized.
So this is crazy. So they don't have to be. Hold on, what do we got here? I knew I had forgotten to update the member counter. I've been counting members. It's a hobby of mine. 26 members for the stream so far. Speaking of members and streams, I'll be right back. We are not done. Don't leave. I'm going to play the peeing song because people keep asking me to. Stay. Bad chat. You stay. I'll be right back.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited. What you have for us when you're beating is through. When you have small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa!
Okay, I'm back. Sorry. Hold on to your butts. Chairman Lamau, don't go. I'm not gone. I hate you guys. Still going to use. See you tomorrow, guys. Every time I play it. Every time. Okay, let's get back to what matters, and that's my thoughts. Here we go.
Kind of feel like that's important. Kind of feel like that should have happened.
Why do you kind of feel that? See, this is one of the interesting things about Kurt. He's like, I kind of feel like that's important. Why? Kurt, tell me the legal principle that says that a judicial determination is required to restore the rights holders' ownership and possession of their own property. What legal principle says that a judicial determination is necessary? That because property was temporarily in the possession of someone who is not the rights holder, you now need a judicial determination. Tell me why. Why is that? What legal matter? What principle? What case? Well, anything. Anything to show me that that's the proper necessary procedure. Almost everybody returns property that has been converted or stolen or temporarily relocated. Almost everybody does it without a judicial determination. The majority of resolutions of property ownership happen absent judicial determination. To get one is actually odd. Nizat says, is responding to Ben Hops, who says, has he ever tried a federal case? Nizat says, not that I know of. This is the first time in years I've heard him talk about having clients. This is his first case ever. Like, there is no federal cases, no state cases or whatever. He sued his employer on his own behalf, pro se. And after that, he's never represented a client. So this is it.
Upon information and belief, at least some of the IMCs from plaintiff's marital home have since been sold or otherwise not in possession of the defendants. Any of them. We believe that some...
Hold on, I missed what he said there. I was reading chat. It's my problem.
And belief, at least some of the IMCs from plaintiff's marital home have since been sold or otherwise not in possession of the defendants.
Okay. So, I'm no lawyer. If I'm representing this client, again, I'm counseling him. I'm like, you don't want to do this. This is dumb. Don't do this. Just be happy that you're not going to prison. Kurt frames this as no judicial determination was made. You notice what he hasn't said in the filing? Plaintiff's property. Item seized from plaintiff. Not plaintiff's property, though. He hasn't said that so far. Some items seized from plaintiff's marital home. Okay, who cares what those items are? Like, are those his items, though? Is it his property? Because some items being seized, it doesn't fucking matter if they're sold, if they're not his. Yeah, I stand so he could have just bought the items instead of suing. It would have been cheaper. Unless Kurt took this on contingency, which would even be funnier. Oh my God, I hope so. He has not asserted his own client's ownership of any of this property. None of it. And during all this, he hasn't done that yet. It's crazy. It's crazy. The items seized by law enforcement and Mr. Snellgrove belong to Austin so-and-so as the sole owner and rights holder of that property. Where is that line? Why wasn't it the first fucking thing after they seized the property, saying all of the property seized is owned by Austin? None of the property seized is owned by Brian Snellgrove. Instead, he has a rookie mistake, which is a weasel phrase. No judicial determination was made as to the ownership. You're suing over ambiguity? That doesn't make sense. You sue over a clear matter of rights. If you're suing over ambiguity, I guess you would sue for some sort of like quiet title action, though there's no title to these tools. Where is your assertion that your client owns the thing that your client is claiming the government should have given back to him?
Any of them. We believe that some of the items have now been converted into like money or otherwise. So
that's not what conversion is. You're a lawyer and you're talking about law right now, Kurt. Come on. Conversion is not the changing of one thing to another. Conversion is the abduction of someone's possessory property interest for a period of time. That's conversion. I don't know why they don't call it a transfer.
the items are gone. So that's a problem.
Why is it a problem? You haven't told us that your client owns the stuff. Ryan Snerdley says, not on contingency, but Kurt charged about $1,700 for work up to the point of the amended complaint and spent it on a watch. I forgot that he had done that. It's amazing. That's amazing.
The actions of the defendant have deprived plaintiffs of possession of property in their possession without due process in violation of 4th, 5th, 8th, and 14th Amendments to the Constitution. Search and seizure.
Wait, he mumbled through that. I don't know what he said. Aaron, don't ever suggest that Kurt doesn't know about abduction, Nick. The actions of defendants have deprived plaintiffs of property in their possession without due process of law. Listen to how he worded that. It's not deprived plaintiffs of his property or their property, of property in their possession. But possession is only one of the bundle of sticks of property interests. It's only one faggot out of the whole roll of faggots. He doesn't say their property. The actions of defendants have deprived plaintiffs of their property, which was in their possession without due process of law, in violation of their rights, because it says his rights after plaintiffs, which is a he and a she, under the 4th, 5th, 8th, and 14th Amendments of the United States Constitution. Wait, the 8th? I'm sorry. How is this an 8th Amendment issue? It's not an excessive bail. And it's not cruel and unusual punishment. Am I wrong on the 8th Amendment? What the fuck are we talking about here? Hold on. Am I forgetting something in the 8th Amendment? Nope. Come on, load it up. Why is it so difficult? Hell. 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Are you going to say that the deprivation of property was an excessive fine or something? What kind of retarded legal theory is this? Bail, excessive fines, cruel and unusual punishment. Which one of those occurred? This is insane. Like, this is nutty. He probably thinks this is really brilliant. Really brilliant. Cat Black says this is not going to end well for Kurt's client. Oh my God. Yeah, I mean, who knows? Who knows? I would assume the client is a fan, which makes it funnier. I have no interest in saving them.
Deprivation of property without compensation, unjust fines, and 14th Amendment, which incorporates it all. The conduct of defendants constitutes various state tort violations, including but not limited
Did
to
he just say it?
fines and 14th Amendment, deprivation of property without compensation, unjust fines, and 14th Amendment, which
He's going with unjust fines. Homie, he wasn't fined. They withdrew prosecution. What fine? You're going to say that the transfer of property was a fine? You're doubly retarded because you just said there was no judicial determination. How can you have an imposed fine without a judicial determination? Ah!
Kurt's complaint looks like he threw the contents of his pressure cooker at the wall to see what sticks.
In Big and Veiny, Cromulent says, "Yo, go sister, fucking get a mean girl. Hell yeah." Everybody needs a mean girl or two to come. And you can make them if you try.
incorporates it all. The conduct of defendants constitutes various state tort violations, including but not limited to trespass to chattels, conversion, and unjust enrichment. We're going to get into the rest later, right?
Trespass to chattels. Okay. Got it. Oh my God.
Because it's like, oh yeah, when you take someone's property without permission and like hold it, that's illegal. Yeah.
Hey, Kurt, it has to be their property, though, that's taken. It has to be theirs.
So.
Oh, God, did you see that fucking face a second ago? Yeah. I can't even, I don't have enough joy in my body to smirk this high.
Yeah. So not a super complicated theory of the case, right? The theory of the case.
No, it's not complicated, but it's nonsensical. It's literally just wrong.
Case here's pretty simple. All actions described here were conducted under color of law, including coordination between defendant Snellgrove and state law enforcement officials, thereby implicating 42 U.S.C. 1983 for all the defendants, right? So I want to sue the private guy, the individual. As
I would assume as a state actor. You can't tell me why, if you have trespass to chattels, conversion, and unjust enrichment, you don't need him to be a state actor. You don't need him to do that. You can use the 1983 claims of the cops without using the state actor theory, which is a dumb red herring that won't work. I'm 90% sure it won't work anyway. On the guy. Like, what are you talking? What are you doing?
a state actor. Spoiler alert for the future, we have pretty solid evidence that he was a state actor.
Spoiler alert for the future. I thought you weren't talking about your strategy, Kurt, or anything else. You're alluding to something that you found in Discovery that you think's a real knockout. Everybody thinks you got a real knockout in Discovery every fucking time. Until you remember there's another lawyer in the case who's going to say that you're a fucking dummy. Chairman Lamau, 1983 claims are just, it's deprivation of rights under color of law. So anytime you use the apparent authority of the law to deprive someone improperly of their rights, like you deprive them of their rights when you arrest them, and that's under the color of law, but this is improper deprivation.
We won't discuss that now. We will discuss it later.
Will we? Fucking.
But our evidence pile is pretty fucking good.
Oh yeah, I bet it is. I can't wait. I cannot wait to see how this goes. I'm so excited.
The factual allegations mentioned herein are supported by various pieces of evidence. Yeah, how do you know any of these things?
Yeah. How do you? I don't know, Kurt. How do you know them? It's because your client said so. And now we have a pile of evidence showing he was a state actor. But what you wrote down doesn't amount to a state actor. A guy who assists the cops by identifying items that are his and identifying items that aren't his so they don't improperly seize something that doesn't belong to him, that's not a state actor. That's just someone who's helpful. The police are still doing the search and the seizure. This is insane.
How do you know any of these things? Well, they're supported by various pieces of evidence generated from the associated criminal case. Oh, yeah, the government themselves told us a lot of these things already.
Okay. Good.
Right, when they indicted the guy, remember? Because they indicted Hamblin and then dismissed it. There was a criminal case with a lot of criminal discovery.
Okay.
And like the police had to tell him what property he allegedly stole. And they had to tell him what property they took from his house. So it's like, how do you know these things? Oh, the government already told us.
Well, that doesn't say anything. What? That's just the police saying, yeah, this is the stuff you took. And this is the stuff that we removed, that we seized. Because you took it. It wasn't yours. So we seized it. You still haven't said that it was your client's property, because I think there's something called guilt in the back of your mind because you know it's not true. Like because you've talked and had a protected conversation with your client. Of course, if you know that it's not true and you proceed with this case, like that's unethical. Although no one will ever know because you have, privileged conversations, and that's good. And that's good. But did your client tell you that it wasn't his? Because you said, oh, you could tell me anything. I'm your lawyer, and you could tell me anything. But if your client told you that it wasn't his stuff and he knew that and you're proceeding with this case, then you're actually violating your ethical obligations. That would be a breach of ethics, whether you get found in violation or not. If you know for a fact that you're pursuing something that is improper, if you know, then it's against the rules.
Oh yeah. In the criminal case. Oh, that's their own files, their own police reports. So
he's like, I'm fucking cool. Knowing about this. I love it.
Yeah.
I always love seeing Kurt be pleased with himself. It's one of the few things that bring me legitimate joy in a positive way about him. Like, I know he's... Oh my God. Like, I know he's an idiot, but he doesn't know.
Including police reports, body cam footage, search warrant affidavits, inventory list, dismissal documents, and statements from the involved parties. All of which form the basis of the claims. The evidence in the possession of defendants from Martin County Sheriff's Office, as it was them that generated most of it. So I like that particular.
You like that particular line? Yeah, that one really caught me off guard. I liked it.
Line. It's like, okay, not only do we know, but you know. It's like, what is the evidence that supports it? You should know you created most of it.
What is the gotcha here? Do you think they don't know where you got the information about what was seized from the property? They wrote the list and gave it to you. But you know too. Okay. Hey, Kurt, did you remember to ever, like, I'm dying to know. I got to press play. I'm dying to know if he ever wrote in there that this property belonged to the plaintiff.
Right? You're the one that created these search warrant affidavits and the search inventory lists and the police reports and I mean, you should know you created most of the evidence that we're going to use to prosecute your ass. So
you're not prosecuting them. You're not prosecuting them. You're suing them. You are not a prosecutor. That would make you a state actor and subject to a 1983 claim yourself, good sir. What are you talking about? We're going to prosecute the case. No, you're not.
Did you see the video of the Reddit mod saying they need paid by Reddit and treated like e-celebrities? Kurt gives the same vibes and smugness as a Reddit mod.
He does, doesn't he? What's funny about that is, of course, I'm fairly certain that part of Kurt's journey to where he is now involved being in Leonard French's Reddit subreddit for whatever his shitty show was called. What was Leonard French's show called? Oh my God, you're still what's up? Yeah. That's a reasonable request. This is what happened last time. Hold on, I'm getting there. Let's see. That's good. Nice. Well done. It's supposed to unlock. I'm waiting for it to confirm that it unlocked. Why would I put socks on in my office? Oh, streaming. I thought you said screaming. Like, what does that have to do with socks? Wait, the car was locked? The car's not locked. Go, get out of here. Good night. I love you. Go to sleep. Okay, here we go. Back to this. We got the proctologist must sleep. Farewell, chat. Good night. Good night. Good night. What are you? I'm on a show. I'm working. Oh my God, get out of my... Ladies and gentlemen, I need to go escort a young lady first to the car to get her charger, and then second to prison. I'll be right back. Give me just a moment. Okay. Oh my gosh. Here we go. Here we go. Here we go. Oh, damn it.
We can definitely see why she's your favorite child. Proper fear of the blacks and hatred of the Jews has made me fucking cackle twice tonight. Step up your jokes nose, Pope. She's showing you up.
I expect her to put me to shame in every way for the rest of my life. She's she's version 2.0. Much improved. Much improved. Okay. Wait, is Kurt like that much louder than I am? I could turn it down.
Oh, that makes that easy.
Yeah, it's so simple.
Plaintiffs seek redress for unlawful causes of action that have created this harm. Cool. All right. And then we start.
Oh my God. Okay. Here we go. He starts with Replevin. That'll be good. You notice what was missing from the fact section? You notice what was missing from the fact section? He never once says, this is plaintiff's property. Aaron James, good night, man. You got to run. Nice to have you around. He never once said that it belonged to his plaintiff, that his plaintiff owned it and had a right. So you're saying I need to be louder. You barely play a few seconds at a time. That's why we barely hear him, not an audio issue. If he could go longer, if he could say something coherent for longer, I wouldn't stop it as much.
Just then Uncivil starts just dreaming up every possible way to say you stole from me. That's basically what's now going to happen for a while. I'm just going to dream up every possible way to say you stole from me. It's like if one of these things don't work, I'll try a different one.
The funny thing, I can say you stole from me all day, but if I don't say that I own the thing, what did you steal?
So I start with Replevin because I find it.
Are Kurt's kids awake at 1:30 a.m. on a school night? Kurt's kids are absorbed in tissue paper. Lala Oct 16. I like the tie with the shirt. Today. Yesterday, you should have put a hot pink tie or a neon orange with the shirt yesterday. I don't have a neon orange shirt. I have something close to a pink tie, but it had a conflicting pattern on it, so I didn't do that.
I just find it to be the most entertaining version. What do you want to start with in this panoply? I was like, I want to start with Replevin just because I can.
Replevin, not Replevin.
It's like it might be my only opportunity to use this. So I was like, I want to start here. So okay, I'm going to do it as number one. Replevin. Replevin is a big fancy word for give me the stuff back. Right? Replevin is I want the items back themselves. Give me the things. That's Replevin. So, okay, we incorporate everything we've said because, we incorporate all other paragraphs because, why not? Plaintiff is the...
Because why not? I hate the way he talks.
The owner of the property described or otherwise has a right to possession. The property that's subject constitutes principally of various snap-on tools and equipment which were wrongfully seized. Defendants wrongfully detained the property after it was seized during the search. The property was not returned, but instead retained by defendant Snellgrove, who upon information belief may have sold some of the items. Defendants acted in coordination and concert to achieve this wrongful possession of the property in violation of their interests. Great. Plaintiffs have a legal entitlement to possession, as the criminal charges against Hamblin, which formed the basis of the seizure, were dismissed. Right? I mean, the police might have had initial right to have the stuff, as potential evidence, but that time has over now. The case is over now, so it's like, can we please have the stuff back? Kind of like, other cases where we've seen that. Karen Reed, for example, like, can I please have my Lexus back? It's like, yeah, if the case is over now.
Yeah, but the funny thing is Karen Reed said it was her Lexus. It was amazing. She said that it was hers, that she owned it, not that it was in her possession. Please return the Lexus that was seized from my possession. How about please return my fucking car?
I want my stuff back. Okay, plaintiffs had demanded the return of the property which had been refused or unfulfilled, thereby necessitating all this. The wrongful detention of the property is without justification, as the legal basis for the seizure has been nullified by dismissal. They suffered and continue to suffer damages, seeks an order for return of the property, or in the alternative, value for the property. All right, so that's fun. Conversion, which is just the civil version of theft. Intentionally and without authorization, exercise control. It was in the immediate possession of plaintiff.
Soldier Providence says he wouldn't have standing to bring the case if he wasn't the owner. Right. And maybe they'll challenge standing because he never asserts ownership. Not a single, not at all. Who knows? We'll see.
Defendant Snellgrove personally and materially participated in search of the property and directed law enforcement officers to seize the property. Based on the direction and with Snellgrove's facilitations, law enforcement seized the property without hearing or other due process. Determining that plaintiffs were not in lawful possession, law enforcement transferred the property to Snellgrove for his personal use.
Hold on. Let me just, I kind of zoned out reading that. Let me just see. I got to read that myself. May of 2023, defendant Brian Snellgrove, personally and material, not materially, good job, participated in the search of plaintiff's marital property. Why does he keep saying plaintiff's marital property? That's fucking weird. And identified and directed law enforcement officers to seize the property from plaintiff's residence during the execution of a search warrant. Based on Snellgrove's direction, and with Snellgrove's facilitations, law enforcement. Why are you writing like this? No one talks like this. Law enforcement personnel. Is that what you're trying to say? Personnel. Law enforcement personnel seized the property of plaintiffs. Oh, there we go. That's the first thing that has come close to saying that this was plaintiff's property. The plaintiff had an ownership interest. Without a hearing or other due process determining that plaintiffs, apostrophe plaintiffs, this is a disaster. Look at this fucking thing. There's 5 typos in this paragraph. We're not in lawful possession. Law enforcement personnel. He's writing personal. It wasn't a mistake. He just doesn't know. It's not personal. It's personnel. What are you doing, Kurt? Why are you writing personal? Law enforcement personnel transferred. I don't know if he's meaning personnel or personally. One of those two. But either way, they're both those. Either one of those would be better than personal, which is just wrong. Transferred the property to plaintiffs apostrophe again to Snellgrove for his personal use. That was a proper use of personal. Holy shit. That paragraph is a fucking nightmare. Wow.
Yep. Despite criminal charges against Hamlin being dismissed due to insufficient evidence indicating lack of lawful justification for retention of property, Snellgrove retained possession of the property. Yeah, no, there was no criminal asset forfeiture because there's no conviction. There's no civil asset forfeiture. Where's our stuff?
Wait a minute. Why is there no civil asset forfeiture? mean, he just said there's no civil asset forfeiture, but civil asset forfeiture doesn't require a conviction. It doesn't even require a charge. It just requires that the police have knowledge that it was used for the purpose of committing a crime or in the purpose of a crime or as a result of a crime. Sorry. That is less good than the Mexican pizza. Holy fuck. No thanks. Ew. John Jelaine says, feeling depleted. Ask your doctor about Replevin. that was good. I like that. The side effects of Replevin could include.
Give us our stuff back. Defendant's actions deprive plaintiff of his right of use of the property. Defendants acted in coordination and concert to convert the property. Upon information belief, defendant Snellgrove has sold or otherwise disposed of the sum of the property, thereby converting it. It was property, now it's money.
That's not what conversion is. That's not what conversion is. As a legal term.
Defendant's actions facilitated by law enforcement deprive plaintiff of their right of use as direct and proximate result of Snellgrove's actions. Plaintiffs have suffered damage in the amount of the value of the converted property. They're therefore entitled to recover full value of the property.
What is that value? Any ballpark figure? Kind of curious.
I mean, you know, it's not super difficult cause of action, right?
Look, I can just make shit up and write it down too. I can write down incorrect things. It's not even that hard to understand.
All right. Count 3, unjust enrichment. Unjust enrichment is you have gotten value unfairly. You've been enriched. You know, you are wealthier than you were before in an unjust way. So, yeah, same. Yeah, I told you I'm going to come up with every way to say you stole from me. Like, defendants retain.
I'm so clever. I'm going to come up with every way to say you stole from me. I don't think he said they stole from him. I think he left that one out.
Received and retained benefits, specifically possession and potential proceeds from the sale of various tools which were wrongfully seized. The retention of these benefits by defendants resulted without justification as the charges against Hamblin, which initially prompted seizure of the tools and equipment, was dismissed due to insufficient evidence, thereby negating the lawful basis for retaining the property. Plaintiff Austin Hamblin did not knowingly, intelligently, and voluntarily give benefits to the defendant. And seizure was conducted under color of a search warrant, which plaintiff complied with under the belief it was legal and due to coercive presence of law enforcement.
Wait a minute. Was the search warrant not legal? This is an odd turn. This is a really odd turn. Is the search warrant not legal? Because you haven't said that. But you just said that the seizure was conducted under the color of a search warrant. I mean, it was just, that's what a search warrant is for, which plaintiff complied with under the belief of its legality and due to the coercive presence of law enforcement. Bro, what are you talking about? Coercive presence of law enforcement. If they have a warrant to seize property and probable cause, coercive presence and compliance doesn't enter into it. Just because they refuse or they chose not to prosecute later does not mean the prior actions are wrong. Tell me how they're wrong. Like, tell me that they're wrong. You haven't done it.
So it's not like we gave you the stuff because we wanted to. Right? It's not because we gave you the stuff because we were letting you borrow it. The men with guns showed up. Be like, give me the stuff.
Here you go. Don't coerce me. No, they showed up with a warrant. That's more important than the gun. If they didn't have gun, what was he going to do? Fist fight him? The coercive presence wouldn't have mattered if they didn't have guns. They had a warrant. They have the authority of law to take the stuff.
That was pretty compelling. We didn't exactly do it because we wanted to. The benefits were retained by defendant at direct expense of plaintiffs who, as a result of the seizure, suffered significant loss based in part on the value. Defendant's enrichment is unjust, as he's retained possession of the property or proceeds from the sale without legal basis and expense of Hamblin, who is rightful owner. Defendant acted in coordination and concert to...
Oh, finally, he says, who is the rightful owner of the property? Should be in your facts section, not here. Your first two causes of action, don't mention it, but should be in your facts section. The other thing is, you should actually explain how he's the rightful owner of the property. How did he come into possession of it? Did he purchase the property? The plaintiff has possessed and owned the property outright since purchasing it or acquiring it in blah, blah, blah from so-and-so and such and such. Like, this is... This is something. I don't
to
know.
achieve this unjust enrichment. Hamblin thereby makes demand for return of the property or proceeds which has not been honored. By retaining benefits under color of law, is unjust and therefore entitled to restitution. Count 4, deprivation of civil rights.
He's not entitled to restitution. Restitution is a criminal remedy. What the fuck? What are you talking about? Why do you keep saying things wrong? Okay, look, again. I'm not being hyperbolic here. The whole value of Kurt in my mind before all of this was like, he seemed to have a grasp on at least like, again, I would always say he has like an encyclopedic knowledge of these Supreme Court cases and stuff like that. This motherfucker is misstating and misusing legal terms. I don't have a witty end to that statement. He's just misusing legal terms left and right, like all over the place. This is an embarrassing document so far.
I just realized Kurt's problem is that he is a midwit who has convinced himself that he is a genius because he has a high functioning memory. That and his sodium intake is catastrophic at best.
His sodium intake needs its own wiki page. God. Ryan Snerdley, did you see Kurt got another deficiency notice on one of his recent filings? No, I have this problem right now. My Pacer account is completely fucked. I don't know why. Like, I can't activate it or reactivate it. I can't do anything. It won't let me search. It's completely biffed. I don't know if it's because my license is temporarily suspended and my Pacer account is an attorney account. I tried setting up a second Pacer account because it's like, okay, well, I'll just set up another one. And it's like, nope, you already have one, good sir. Like, why is this complicated? Like, I just want access to Pacer. And I have no idea. I can't. It won't. I don't have an option to fix it.
It's under 1983.
Give them the old razzle-dazzle. Razzle-dazzle 'em. How can they see with sequins in their eyes?
Not exactly sure why I put this as count 4 in particular, to be honest. Not that it really matters. It doesn't really matter what order you put it in. You can put it in any order. It doesn't really matter. But in retrospect, it seems like a somewhat arbitrary place to put it. But, you know, whatever. I put it as count 4. So fine, it's count 4 now. Great. Defendants acting under color of law. Well,
B-Hop says, as in it posts all the case law you look up on Pacer to repack. No, I've never heard of that. But I can't even get on Pacer right now. But that's cool. Sounds cool, at least. If you have Pacer and not repack, you're a commie. Okay, so I see what you're saying. So everybody who goes and searches out on Pacer, repack extension grabs document, and then it creates a public archive of all of those things. Is that what that does? That's fucking cool. Destiny X Rose, what would make you what would make you dare to suggest that Kurt's wrong here? I don't know.
But you know, that part's pretty easy because they showed up with the search warrant, with the police uniforms and the guns. So saying that they were state actors is pretty easy. You know, couldn't help noticing the guns and the uniforms and the search warrant and the badges.
I don't know. He's like, I've got these fucking cops dead to rights on being state actors. Who would dispute that? Like, they don't care. You think the defense of the police against the 1983 claim is going to be, we're not state actors? Do you think that that was their plan? Like, fuck, I can't believe you outwitted them. Genius level, Kurt. Did you show him your Mensa card while you were towering over them as you conquered them and then fucked their wives? What are you talking about? He's like, pretty sure we got them on being state actors. Yeah, they know. They get the check.
And you know, all that stuff. So that's pretty trivial. They deprived the plan for rights, privileges, or immunities on or about May the 17th. Snellgrove. Snellgrove is the challenging one, I guess, to this because he's just a guy, or is he? Snellgrove,
or is he? No, no, he's a person with a backstory and emotions and dreams and ambitions. And why do you keep dehumanizing him to a government actor who aren't even people? God, you're a monster. I love this. Actively participating law enforcement officers executed a search. His lame YouTube show with the heavy grift, creepy comments, wandering eyes. We all heard his thoughts on his LawTube friend. Now Nick humors us while Kurt tells lies. Yeah, Nick's killing it, and Kurt just lies. Thank you. Okay, Miss Divine. I like that. We'll have to archive that chat somehow. I appreciate it. Thank you so much for the super chat.
actively participated with law enforcement, executing the search property under authority of a purportedly legal search warrant. During the execution of the search, Snellgrove personally directed law enforcement officers to seize property from the residence, identifying specific items for seizure, thereby actively participating in the search and demanding and demonstrating a willful collaboration with state actors.
Collaboration with state actors isn't the standard for a state actor doctrine or agency to apply. That's not how it works. That's not it. Do we think Kurt is going to allege that the warrant was unlawful? Are we going to get that reveal? That's what I want to know. That's where I am right now. That's where my head is.
Incidentally, by the way, it gets worse. I'm not going to tell you how it gets worse today. It gets worse.
Wait a minute. Matt W says, is this a StreamYard I can join? Who the hell are you? Why would I let you on? I mean, that's very funny. Did I ever actually like Kurt? Yeah, of course. Like, I wasn't lying. Like, I didn't want to like hang out with him in person or anything. Like, when I had my Vegas show, you know, Kurt was texting me as his plane was taxiing to the gate, and he's like, I'm here. Where are you? And I'm like, I don't want to hang out with Kurt in Vegas. Like, I don't mean to be rude or whatever, but my plans involved debauchery and drugs. I didn't want to, like, Kurt wasn't fit for that at the time, you know? But like on shows and stuff like that, you know, through the internet and like, if I saw him in person or whatever, like, fine, cool. Like at the event or at the show, he hung out with me a lot at Anime Matsuri. Like he sat at my table and stuff like that. I don't mind that. he and I would have, interesting little side conversations from time to time, like when there was a lull and people coming to visit or whatever. So sure, like that was cool. I have no problem with it. But when those shows over and I'm going to go entertain myself, I'm going to go do stuff that Kurt probably doesn't want to do, but at the time that Kurt probably didn't want to engage in. I said, I would, I was going to go do Molly, cocaine, maybe ketamine. That was going to happen. And then I was probably going to go do something degenerate and get super hammered at the same time. It was great. It was a ton of fun. Not the type of activity like Kurt does the drinking part, but usually with depression instead of with hot people. I was looking to hang out with hot people, drink and do drugs. Like that was it's not a good thing. Don't do that. Hang out only with ugly people and be sober. But that's what I was doing at the time. Okay. So that's what I wanted to go do. That was my goal. And he wasn't conducive to that. I never said, no, I hate you or anything like that. It just, there's some friends you call when you're going to go to the movies and some friends you call when you're going to go to dinner.
I have perhaps the best smoking gun ever.
I can't wait.
I didn't know that at the time I wrote this, or I might have mentioned it. It's since come to my attention, but it does get worse. We're pretty freaking confident Snellgrove was acting in coordination with the police.
What was your clue that he was acting in coordination with the police? That doesn't make him a state actor. He has to be given the authority of law, and he has to be doing something that is in the providence of the state. That's what makes him a state actor. He has to be given the authority to infringe on someone's rights, not asked to consult on their warrant. Those are different things. If they handed him the warrant and said, you want to kick the door down, you want to go in look at it, we're going to sit out here, you just go fucking ham. That's different. That's an entirely different thing. But here's the crazy thing, bro. What rights were deprived? Even if you get him as a state actor, somehow that doesn't do anything. State actor doctrine, I fucking got this guy dead to rights on being a state actor. Okay, well, he's a state actor. Lots of state actors, not a crime and not a civil infringement. You still have to win on the other issues. Your other issues cases are weak, bro.
Pretty confident.
Talking for an hour.
Anyways, acting on his instruction, directly seizing property without a hearing or due process, transfer the property to Snellgrove. The seized property includes various items of significant value, none of which were lawfully adjudicated to belong to defendant or were proven to be related to any criminal activity, as evidenced by the eventual dismissal. If it sounds a little repetitive, it is a little.
They can civil asset forfeiture something and then they can return it to the rightful owner. That can happen. They don't have to criminally convict someone to okay, here, imagine this happens. I lend you my car. Right? I lend you my car. So you can borrow my car for 5 weeks. On week 4, your friend has an issue and needs a car. And you're like, well, I was borrowing this car for 5 weeks, but turns out I could be done with it a little sooner. You can borrow this car. I'll let you borrow it. I've been borrowing it, but you borrow it. That guy can just return the car to me. Because it's mine. It's not yours. Nothing at all would suggest that the car has to go back to you and then to me. You might want to do that because maybe you didn't tell me or something, whatever. Who cares about that part of it? but nothing requires it to go back to you. And then to me, it's my property. It always was. I temporarily allowed you to use it. Now it's being returned. I don't care if that guy delivers it or you deliver it. There's no reason for that guy to have to give it to you, to give it to me. Why does he think that the cops need to adjudicate something in a particular way? Property rights don't need to be adjudicated. They exist. They exist irrespective of adjudication.
Sometimes because you kind of have to plead each cause of action and they substantially overlap. But that's okay. We don't mind saying the same thing twice or 5 times. Oh, yeah. No, the body cams is the least of their problems. Yeah.
I doubt the body cams are a problem at all. The body cams are going to, unless their inventory of seizure doesn't match what's on the body cam, that would be a problem. But unless there's some sort of massive difference between what's on the body cam and what, you know, what they wrote down, like in my case, for example, you guys haven't seen it. Unfortunately, some weirdos have complicated my ability to do any of this. But for example, there was a vial of cocaine on my nightstand. This, and on the body cam video, they open it up and it's full. It's full. It's probably about 2 grams of cocaine in a little metal cylinder, right? That doesn't exist. In the evidence photos, when they got back to the station, it's gone. There's none of that. There's no record of it anywhere at all. There's a picture of the cylinder and it's empty. Hilarious. Don't know where 2 grams of cocaine went because the list of stuff that they weighed at BCA and tested did not include that 2 grams. It was the stuff that was in the safe. It was all of that stuff was included. The 2 grams. So, I mean, that doesn't help me in any way. They stole my Coke. Shit, I said mine. But that's a funny disparity between the 2 events, between the body cam and then the written results.
We have more.
But if the body cams just show what they say happened, what are you going to do about it?
Well, no, the body cams are definitely a problem, but we have more.
Is Kurt here? Now he says the body cams are definitely a problem. How? Like, what's the thing? It's not a secret that the cops executed a search warrant and seized property. You didn't write down in your fact section any of the improper activities of the police from the body cam. So I'm really curious as to, like you're saying, oh, this is a big thing. What did they allegedly do that makes this a problem for them? This is someone saying something that doesn't make any sense. If you know that these things are problems, why aren't they written down?
Anyways, plaintiff was not provided with any form of hearing or adequate procedural mechanism to contest the seizure of the property or the basis of search warrant, which directly resulted in death.
Life in general. I actually did consider asking for my DMT back because they never identified. There was people had a lot of suspicions about an alleged brown, I think it was listed as a brown powdery substance or something like that. Brown isn't quite the right term. It was more of a camel color. It was DMT. That's what it was. And since they weren't able to test and identify it as an illegal substance, I thought about asking for it back. I thought that would be funny. But by the time that came around to do it, I was like, I'm actually just depressed and I hate life right now. I'm not like that anymore, of course. But at the time I was. So, but it would have been funny to ask, can I get the unidentified brown powdery substance back, please? What is that? Don't worry about it. The asterisk member for 5 months says definitely a problem. Definitely. It's definitely a problem. 2,200 problems. Okay, Miss Divine says, brought to you by Ricotta Records. Brought to you by Ricotta Records. Special thank you to our sponsors, Strap-On Tools. Strap on so you can snap off. Okay, I'm done. Heart. Thank you. Okay, Miss Divine. Happy that you were able to finish. You know, it's always what we aim for around here is making sure everyone is able to finish. Panzer Dude, or not Panzer Dude, over on Locals, did send in a tip. It says bum toucher, which I'm pretty sure he sent that tip in the day stream is still true. That is a bold choice of shirt and tie. Yeah, I know. Thanks.
Privation. The action defendants under color state law directly deprive plaintiff.
Tom Colby says, DMT, I understand is heavy shit. You might see God. I never got to try it. My understanding of DMT is, you put it in a pipe, and it has to be a glass pipe or whatever, and then you smoke it, and you have just a couple seconds to hand off the pipe or whatever, because you're gonna be gone. Like you're gonna fall over, you're gonna be gone, stuff like that. I never had the opportunity to where that was a thing I could do, so you need another person around to help you out and make sure everything's okay. And I just hadn't gotten around to it. I'm so mad. I wanted to try it.
The victim owner of the property knew everything that was taken by the thief. He would be able to quickly identify that property.
Because the victim identified only the stolen property means the police only had to take the stolen tool instead of taking all of the tool and sorting it out later.
Yep. 100%. Kurt's like, that makes him a government actor, a government agent. No, it doesn't. Not at all. Let's see. Did you ever get Taco Bell earlier? I did. The Mexican pizza was delicious. The gordita, not so much. Ryan Snerdley says the defense's response to this complaint is available on court. Listener, by the way. Ryan Snerdley. You know where it's also available, which is better? It's available on Uncivil Law's channel, and he has commentary on it. Which is probably going to be tomorrow's stream.
Of Fourth Amendment rights against unreasonable search and seizure and 14th Amendment right to due process. As direct and proximate result of defendants, plaintiffs suffered significant losses, including but not limited to the result of their property, right? Here, by the way, they're going to suffer other losses relating to that, but we're not going to, yeah. Defendant Snellgrove, acting in concert, directed the seizure of the property, which was transferred to him without due process, establishing willful cooperation. Yeah, the fact that he just took property and put it in his own personal vehicle and drove away with it.
It's his. He owns it.
Yeah, that's also pretty good evidence. It does get worse. Somehow it just continuously gets worse for these people. It's amazing.
Mr. K says, I'm so sick of Kurt videos, I don't find them entertaining at all. This one, look, this is a different character than the other Kurt videos. This one is literally about legal analysis. Kurt is legally analyzing himself in his own case. And it's amazing. This is frankly amazing. Because you get to see someone who their entire thing, this is LawTube, right? We're going to talk. I'm Nick the lawyer. We're here at LawTube. We're going to talk about the law. We're going to talk about drafting. We're going to talk about how you identify issues, how you spot those issues. And we're really going to bring it out and tell you how you litigate an entire case. We're going to tell you where things are going wrong, where things are going right. And that's what we're going to do. That's LawTube, baby. Kurt is telling you about his own thing. He's doing that. but he did it wrong to start. And his analysis sucks. It's so fucking good. It's so good.
Law enforcement defendant's decision to release seized property of private individual is ministerial, not discretionary. Now, this part's really important for the 1983 analysis, as I'm sure Travis, our friendly fellow lawyer here, would be happy to inform you, right? Now, suing the police under 1983 can get really tricky, as we've discussed many, 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 many times for any number of reasons, right? Because,
qualified immunity.
Normally you have to show that it's a well-established right and that it was clearly violated, right? That's the normal problem with a 1983 cause of action, right? Because the police normally are acting discretionarily because they could do this or they could do this or they could do this or they could do this, right? So like you have to prove that the way they went about it was clearly established a violation and was a violation and clearly established. That's the normal rule. That applies almost all the time. But there is a caveat that makes life easier for me.
Yay.
If it's ministerial, if the police have no discretion, if they have to do things in a particular way, then the analysis becomes much easier for me.
Oh, good.
So, therefore, I allege that the law enforcement's decision to release seized property to private individual was ministerial, not discretionary, because Texas law establishes a mandatory inventory and return procedure. A ministerial act performed in violation of law is not protected by immunity. So I'm going to argue in substantive part that the process for seizing, inventorying, and all that stuff is ministerial. There's a way it must be done, as established by law. It's not like, oh, the police had to make a decision. Right? Do I pull my gun or do I pull my taser? Or do
Hey, Kurt. It has to be his property for this to be true. Seizing the property from someone else that belongs to another doesn't require the same inventory and return. They have to inventory the seizure, for sure. But they don't have to make the return because it isn't his. This is amazing. This is, I don't even know what to do with this anymore.
I pull my baton? Right? Or do I not do anything? Right? It's not like they had a decision to make. They had no decision to make. There was no decision. There is a set of rules and procedures that you're supposed to follow.
Sassy J, you don't have to edge. We got time. Just let it go. You can probably get another one.
When it comes to seized property, you have to do it in a particular way for particular reasons. I'm saying they didn't do that. There was no choices to be made. And so since there were no choices to be made, there's no immunity.
There actually is a choice to be made. Is this his or his? Kind of looks like this guy's. We gotta have, all the information says it's this guy's. He's the owner of the company that's called Snap-on, the Snap-on tools. This is a former employee. It should have been returned, blah, blah, blah. You don't have to have a judicial determination for the police to transfer the property back to its rightful owner. You'd have to have a judicial determination to remove the property from the rightful owner and transfer it to someone else.
They are going to argue against that for every possible reason, as you would anticipate. But,
you think?
That's what I'm going with. So basically I'm just going to try to circumvent the entire 1983 analysis by saying that what they did was ministerial and therefore I just win.
Every lawyer is so goddamn smart until the smart asshole on the other side shows up. Every single time. Like, I'm going to do this and this and this, and I'm fucking awesome. And then someone reads it and goes, nope. This property did not belong to Austin so-and-so. There's no documentation that suggests that he is the rightful owner, had any lawful right to be possessing the property, or anything. In fact, he barely asserts ownership in his own complaint, often referring to it as the property or the stuff.
That's my way of trying to overcome the problem. Yeah, I'm very excited. The conduct of defendants was intentional, willful, and reckless disregard of the federally protected rights, including a whole...
Sunset Seeker, other than shitting on Kurt, what else are you actually talking about? I'm shitting on Kurt in a legal analysis, like we're talking about the law. The funny thing is, Kurt's complaint is completely bereft of proper application of law. It's amazing. It's phenomenal. This isn't the normal shitting on Kurt that I do. Normally, I shit on Kurt because, like, I'm shitting on him personally. This is his work. I mean, it's his work in the same line of commentary that I do. Cyborg Valkyrie says, are we still watching ChatGPT tell Kurt his brief sucks? It's still happening. I don't really, like, get it. Whenever I do Kurt content, there's always, like, someone who comes in like, you still fucking messing with Kurt? It's like, no. I'm making fun of him, yeah. Yeah, I'm doing that. I'm criticizing whatever thing he's saying or talking about that's wrong. I'm doing that too. I would do that to anybody on the planet and do that with relative frequency. People are like, why are you doing it to Kurt? Why are you doing it so often? Because he sucks. Plain and simple. He sucks at all of it. He sucks at the streaming. He sucks at his analysis. He sucks at his drafting. He sucks at his legal reasoning. And I'm happy to let people know. I think it's funny. And the reason I think it's funny is because he's so fucking smug about how good he is at it. He's never done it. And his first example of doing it is god awful so far. Goodfella D says, you told me I didn't have to watch the ads, but now that I know the 0.0000001/2 cent you get from me watching isn't going up your nose, I went ahead and watched them. Don't spend it all in one place. Crazy kid. As a reminder, the time when I was buying cocaine, I had a contract with Rumble and Locals. I was being paid by them. I wasn't actually taking money from y'all. Any super chats that came in on Rumble did not come to me. They went to Rumble, and Rumble paid me a fixed amount. That was in excess of the amount of super chats that came in. So, yeah, I was very happy to take Rumble's money. In hindsight and in retrospect, I think that was a terrible decision that I made. The Rumble switch thing and stuff really fucking killed the momentum of the YouTube channel. And people like to send in chats and participate in the show. And I started discouraging it because I was really happy to have Rumble's money paying me rather than people's money. I was looking at things the wrong way. I was looking at things like that super chats were a burden to people rather than a fun way to participate in their own entertainment. So yeah, I would not, like knowing what I know now, I would have gone back and not done it. I probably would have made less money, but it would have been a better choice in the long run.
A bunch of constitutional provisions. Trespass the channel. We're going back to stealing stuff, which is why did I do 1983 as cause 4? Because causes 1 through 3 were you stole stuff. Cause 4 was you violate my rights, and now we're back to you stole stuff.
Oh,
not quite sure why I put it in that order, but well, whatever. It doesn't matter.
It doesn't matter. You're not quite sure why you did your own thing. That's cool. I like that. Thanks for the help.
Any order is equally good to any other order, but yeah. Anyway, trespass the channel.
Wait a minute. Texas Farm Girl says, you're back on it, R. Take off the glasses. Okay. What? What do you want? Does this help? Am I on cocaine because I wear sunglasses? Bitch, I wear my sunglasses at night so I can see.
This is just, yeah, I mean, trespass is trespass. Chattel is just stuff. You know what trespass to land is. You know what trespassing on land is. Trespass to chattel is just trespass to stuff. Namely, you took my things.
Okay.
Defendant intentionally, without authorization, interfered with the property. In May of 2023, defendant Snellgrove, accompanied by law enforcement who were acting under his direction with his active participation, entered plaintiff's property under the pretense of executing a search warrant. During the execution of the warrant, Snellgrove identified and directed law enforcement to seize various items, including but not limited to snap-on tools and equipment. Snellgrove, with the assistance of law enforcement.
You know, you can go back. There's about a good year. There's about a good year of time in which you can observe me on cocaine. You can go ahead and do it. I think if you do, go back about a year and watch a show, or go back to that year of time and watch the show, and you'll notice some pretty significant differences, honestly. So, like, respectfully, yeah, you're back on it. That would be fun. It was great. It's not a part of my life anymore. Sorry. I get randomly tested. There's if I fail a test, I go to prison for 2 years. I'm not retarded. I'm not gonna. There's no risking it. There's no like getting around it or beating it or whatever. You just don't do it anymore. Life changes. Not really what I wanted, but okay. So what? You address what happened and you move on. You should try it.
Seize the property, constituting an intentional interference. I mean, that's pretty easy, right? I mean, they interfered with.
Was it during or after Depp v. Turd? The entirety of Johnny Depp, I had never tried drugs in my life. No hard drugs had been done at that point.
It because they took it, and they did it because they picked it up and they put it into a box, which they put into a truck. So, you know. Snellgrove, with the assistance of law enforcement and acting as directed, seized the property, constituting the interference. The interference was without legal justification. The criminal case, which initially prompted the seizure, was dismissed, underscoring the lack of legal grounds for seizure and retention.
Nope. That's not how that works. There's not a lack of legal grounds for seizure and retention because they choose not to prosecute based on insufficient evidence later. That's a weird claim.
Actions Snellgrove caused actual damage, including but not limited to deprivation of property and subsequent economic loss due to inability to use the tools and equipment in trade. Moreover, defense actions were a substantial factor in bringing about the harm to the plaintiff, as property was seized.
Oh, shit. Texas Farm Girl says, I never even thought he was using coke. Projection, he ain't on the slopes, bro. Wait, what? It sounded like that's what you were saying. If that's not what you're saying, I apologize. A lot of people come on here and they say, oh, you're wearing sunglasses, you must be on cocaine. So I thought that's what you're saying. If that's not it, my apologies. It's not your fault, it's other people's fault.
Was integral to plaintiff's business operations and losses directed in financial detriment. Defendant's conduct, trespass, willful trespass, was willful, wanton, and conduct with reckless disregard to his rights to possess in his personal property, including without a hearing or due process determining they were not lawful possession. Exciting. Number 6, the Texas Tort Claim Act. So I brought a whole bunch of common law shit. All right, so now we're going to move into some statutory shit. The Texas Tort Claim Act waives sovereign immunity. Right, so like, well, that helps a lot. It's like, how can I sue the government? Well,
I'm so glad the state has a process by which it identifies certain things that are removed from sovereign immunity. Yeah. Why do you think you're clever because this law exists? It's not like this is a novel theory. It's what it's for. if you didn't find these things, you should probably crawl back into the hole that you came out of. I don't know if your mother would appreciate it.
Well, you know, this is why.
Wait, what? Stop
The
it.
Texas
Stop.
Tort Claim
Shush.
Act waives sovereign
You're
immunity for the state of Texas.
Texas farm girl, you're a confusing woman. Now I don't know what to do. Now I'm just yelling.
As political subdivisions in certain situations, allowing them to be sued for damages arising from performance of governmental functions where the actions would, if performed by a private individual, give rise to a claim of negligence or other tort.
Sassy J in the UK, I'm just glad you stopped edging.
To establish a violation, the plaintiff, that's me, must demonstrate that the defendant is a governmental unit. Kind of got that covered. Defendant's employee was acting within the scope of employment. Pretty much got that covered. The sheriffs, you know, with the guns and the badges. Pretty sure I got that covered. The incident involves condition or use of tangible property or real property. This is the government's property, incidentally, by the way, such as their vehicles.
Okay, so defendant is a governmental unit. That guy's a fucking unit, mate. The defendant's employee was acting within the scope of employment at the time of the incident. Right, incident involves condition or use of tangible, personal, or real property. Okay, he said that's the government's property. And the government unit would, were it a private person, be liable to the claimant according to Texas law. So he's going to say because of the theft, they would be liable to the plaintiff because it'd be a theft for taking the property since they're not a government actor, I guess. If they weren't a government actor, they couldn't take the property. It's kind of wild. What's weird though, like, so I guess that's, are you gonna argue like the burglary also? Is that gonna be the thing? Because here's the thing, you know, retrieving your own property. If I lent you a shovel and you didn't return it to me, and then I come to your house and my shovel is sitting up against the wall outside, and I just go, yoink, and grab the shovel and put it in the back of my truck, and I leave. I haven't stolen anything because it isn't yours. Unless you can show some reason why I have surrendered my present possessory interest to you for the time, then it's not yours. I can take it. I can take it back as long as I don't invade or intrude in some other way. Like I can't trespass into your property or burgle you to take it back. But it's mine. If I come in and is laying in the grass of your yard, and you're like, oh, well, I'll just grab it then. No need to bother anybody. Throw it in the truck and drive off. You can't sue me for taking my thing.
That were used in the seizure, right?
Yes, this file
that
is
would,
ongoing.
that would be their property, or the government's property more properly, the vehicles. Yeah. And the governmental unit would, if a private person, be liable. Yep, so I think we're there. Defendant Martin County is governmental unit as defined by TTC.
You thinking we're there doesn't mean much of anything.
Yeah, because of course it is. Law enforcement defendants, including Ingram and other involved officers, were acting within the scope of their employment due to active and direct participation. Snellgrove was acting as an agent or otherwise an accessory to the conduct of the sheriff's office. The operation included, this is our hook, right? The operation included the use of tangible personal property, including police vehicles, search and seizure equipment, and other physical items utilized during the execution of the warrant, right? Because that's the thing. What did the police use? Namely, their vehicles.
Wow. It's amazing.
Yep. The actions of Martin County through its employees involved in misuse of tangible personal property, specifically removal and transportation, equipment, and facilitating unlawful search and seizure and retention of property, including snap-on tools. Defendant Snellgrove directly participated in and directed.
Why does he keep saying unlawful search and seizure? They didn't prosecute because of a lack of evidence. Was the evidence excluded by the exclusionary rule because the warrant was improper? Did they defeat the warrant? Did they somehow show the... He hasn't asserted that the warrant was improper. So it's not actually an improper, unlawful seizure of property. Just because they change their mind later doesn't mean the action at the time becomes unlawful. This isn't quantum physics here. There's a very clear and obvious chain of time that progresses A to B to C. Events go in order.
The search of it and identify and directed the property. Snellgrove acted as the county's agent when he directed.
Texas Farm Girl. I'm not bothered about it so much as my misunderstanding was that you were accusing me of being on drugs, which it has been. How long? How long have I been accused of? I mean, I was arrested on May 23rd of 2024. So, 20 months ago or whatever. In every single stream, tweet, whatever, people accuse me of being on coke. Every single one. And some of the reasoning behind it is really frustrating because it's like, I'm wearing sunglasses. Oh my God, that's a cocaine thing. So I'm sorry. Like I misidentified it because it just gets tiring. I realized that you weren't actually making that accusation. I read that into it, but it's just because so many people do it so often. And I felt like clapping back at someone who was doing it at the time. Turns out I was wrong. Oh, fuck, I'm Kurt. Jesus.
Deputies to release tools to him. And how? You know what? I'll spoil it because it's on the public docket for the future. I'll spoil the big yes. reveal here on it. Just how bad it gets.
Yeah, do it
for them on this issue.
Sorry, Texas Farm Girl. I realize you never said that, but what you said was something along the lines of Nick is back on it. Take off the glasses, which I think what you meant was I'm back on like streaming. I'm like back on it. Like, I think you were being positive, but understand that like usually when people are telling me to take off my sunglasses, it's because they're accusing me of being on drugs and they think I'm hiding my eyes. So again, it was my misunderstanding. And it's everyone else's fault. It's not mine at all. It's not your fault. Like you're being sweet, and I was rude. I apologize again. I misunderstood what you were saying, but I'm just trying to explain how I got there. And again, it's something I deal with on pretty much every stream and most of my tweets too.
I can't believe this exists. This is how stupid it is. Okay, so in the motion for summary judgment filed by the defendants, they included some exhibits. One of the exhibits is from a governmental actor. It's an affidavit.
Oh my God.
From the government.
Wow.
The affidavit, in substantive part, says that the government conscripted Snellgrove.
Okay. But the state actor test isn't based on an affidavit. Let's see what it is. Supreme Court has stated that a private entity can qualify as a state actor in a few limited circumstances, such as when the private entity performs a traditional exclusive public function, when the government compels the private entity to take a particular action, or when the government acts jointly with the private entity. Kurt is saying that the act is that this is a joint action between the two of them, I believe. Let's see, what do we got? Is it this one? Let's see. Constitutional requirements of due process apply to garnishment and prejudgment attachment procedures whenever state officers act jointly with a private creditor in securing the property in dispute. What does that look like? Private parties' joint participation with state officials in the seizure of disputed property is sufficient to characterize that party as a state actor for the purposes of the 14th Amendment. Respondents that his complaint alleged that in attaching his property, respondents had acted jointly with the state to deprive him of his property without due process of law. Lower courts construed the complaint as alleging a due process violation. Wait a minute, but there was due process. You got a fucking issue. Joint participation with a state official in a conspiracy to discriminate would constitute both state action essential to show a direct violation of petitioners' equal protection rights and action under color of law for purposes of the statute. Let's see. The state act jointly with a creditor in securing the property in dispute. So court has consistently held the constitutional requirements of due process apply to garnishment and prejudgment attachment procedures whenever officers of the state act jointly with a creditor in securing the property in dispute. So the question is, I mean, this is only theory, the joint acting. Who cares about Kurt? Tell us your analysis. You're smart and better than reacting to Kurt. I'm not better than reacting to Kurt. How dare you? Thanks for calling me smart. Kurt wrote this. It's Kurt's work that Kurt's talking about. So it's like we get to read the document, but we also get insight directly from the source as to why they wrote it. The source happens to be Kurt. It's funny because it's bad. Bunny Murphy flexing her member for 3 months. Thank you, Bunny. Very happy to have you. You've been great. Chris Onion says, now we're going to move into some statutory shit, lol. Exactly.
Conscripted. In a sworn affidavit. Travis, I'm feeling pretty good about my claim that Snellgrove was a government actor, Travis.
Again, a cop saying we conscripted him doesn't actually make him a state actor. Like, that doesn't pass the test. It's evidence of it. Doesn't automatically make him, because the cop has the power to actually conscript him. Because that's a weird word, isn't it? Legal definition of conscription. Conscription, commonly known as the draft, is the legally mandated compulsory enrollment of individuals into the state's armed forces. Oh, that's really funny. Wait a minute. This got so much funnier. The cops said they conscripted him. They can't. They're not the military. Kurt is so hopped up. He's like, they said they conscripted him. They don't have the ability to conscript him. They're not the military. Anyway, Texas Farm Girl, again, I apologize. We got to keep going through this thing.
Feeling pretty good about that with, the conscripted in a sworn.
You can't conscript someone into a police force. It's not a military. That's not the same thing. That's a different thing. You can deputize someone. That would be what they would have to say. They would have to say they deputized them. They would also have to have the authority to deputize them.
Affidavit. Feeling pretty solid over here. Just saying.
The grooming meter. It's going. It's kicking up. We're going to get there soon.
You have to be kidding me. Yeah, no, it's just going super well. Yeah, that's how well it's going, Travis. It's going really, really great for them. Yeah, it's going super right.
Are you winning motions, Kurt? Have you got any rulings?
The plaintiff alleges that law enforcement defendants failed to provide a full and complete inventory list post-seizure as required, resulting in the ability of plaintiff to reclaim his property, some of which was subsequently sold by a third party, causing financial loss and deprivation of property without due process. Defendants' failure to inventory and secure seized items violated, various codes, blah, 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 retaining intention of property. Violation includes negligence per se. Had the Martin County Sheriff's Office been a private entity, be liable for negligence, trespass, and conversion, among other potential tort claims, which we've been talking about for a while, for actions taken during and following the search.
Holy shit, Miss Vixen, member for 1 month, says Coca-Cola is ready. Just need my B-Day. Toast from you. I happen to have cherry Coke. Cherry Coke. To Miss Vixen, happy birthday. Happy birthday. One more trip around the sun, as they say. May this day bring you away from distractions, from depression, from disappointment, and may it bring you toward improvement, peace, contentment, and a little bit of spicy joy. Always remember mirth. Always remember levity. And bring those around you kicking and screaming into a positive experience in their life. To many more trips around the sun, Miss Vixen. Cheers. Rita, hola. Bienvenidos. Here we go.
As a direct and proximate result of the aforementioned actions by law enforcement, plaintiffs suffer damages, including a loss of valuable personal property, emotional distress, and violation of constitutional rights. Snellgrove, by his direct participation.
I still react to other lawyers. It's just Mardi Gras. Girl, it's Fat Tuesday. There are not many fatter. It's the time of the season.
At times directing law enforcement defendant as to which property seized and assisting in the removal of property implicates him in the TCCA. Well, if he was conscripted, maybe. Hello? The plaintiff seeks to invoke waiver of sovereign immunity provided under the recovered damages and loss sustained. Abuse of process. Defendant Snellgrove initiated or used legal process against plaintiff. The process was used for the purpose for which it was not designed to accomplish.
Goodfellow D. I haven't paid enough attention to the case Kurt is covering. Are the snap-on tools going to end up in a police auction? No. The snap-on tools were returned to the actual owner. They may sell them. I want to... You seem to have missed something really important. This isn't the case Kurt is covering. This is the case Kurt is litigating. Kurt drafted this document that he's reviewing right now. This is his work.
Ulterior motive. Defendant Snellgrove had ulterior motive. Defense actions were willful, intentional, aimed at achieving a result not intended or warranted by process. The improper use of process resulted in damages. In May of 2023, Snellgrove instigated a search and seizure by providing information to
Sleeping psychopathy. What happened? What's going on? You said you can't feel your face. I've been there. But Why? What's going on? Tell me more about it. Our ex-girl, is this case over now? No. In fact, there's a hearing coming up really soon in this. There's a hearing coming up really soon in this. So we've got this and the response. Both have happened. But there's other stuff that's happened. But he's done videos on his complaint and then the response, which includes a counterclaim. I can't wait. Yes, this is an ongoing case. There is a hearing coming up in it.
Law enforcement, which led to the issuance of the search warrant. Search warrant was to be issued. This is Martin County, Travis.
How much to get the video transcript of Kurt arguing this in court? Transcripts tend to cost a lot. Depending on how long the hearing is, they can be several $100s to even into the low thousands. We will not be able to watch this case. You may have missed that it is federal. You may have missed that it is federal. Federal cases are not allowed to be filmed, unfortunately. I do not always ignore you. I was literally talking to you, the earlier. What did I miss, though? About the conscription thing? I just saw it.
This is in the Western District. Stay out of my case, Travis. Stay out of my case.
Ryan Snerdley, if they have the Zoom link, those are public. But if you have the Zoom link and attend, do not record it. Do not record it. Nothing that even looks like or sounds like or feels like recording. Do not do that. It is against. You can get yourself in serious trouble. And also, remember, we observe these things. We're observing. It's great. Do not interfere with them. These are people, for whatever it is. Kurt's participation makes this interesting, particularly because it's Kurt and because I know him and all that stuff. But the clients on either side of this, these are their lives and stuff like that. It's not a joke or a game for us to play in or, to mess with. Talk about, sure. Laugh at, of course. Mess with? No, come on. That's not what we do here. This shit's expensive and it's brutal. Trust me, as someone who has been in active litigation for 3 straight years now, right? Like, because Marty Gras sued me, and that was going on and on and on. I don't remember when that lawsuit started. It might have been the end of 22. Holy shit. But yeah, I've basically been in at least one lawsuit since then. It's fucking irritating. And if people like were to jump into it and interfere with it and mess with it, and then your lawyer has to do other stuff and you have to pay for all of it. It's fucking crazy. Make sure you don't do anything like that.
The sheriff's warrant was executed at Plante's residence, where law enforcement Snellgrove, acting in concert, seized various items, principally Snap-on tools, which were then loaded on trucks removed from property. Defense Snellgrove participated directly in search, pointing out items to seize, and assisted in the process, as one does.
You know what's crazy is it took me 12 seconds to find the 3-part test for state actor theory doctrine, and the fact that the specific language is to act jointly with the government, whatever that means. Why isn't that in here? Why didn't Kurt research that?
The use of search warrant process by Snellgrove was not for legitimate purpose of recovering stolen property, but rather to intimidate plaintiff and regain possession of items without proper legal proceedings, as evidenced by subsequent dismissal of criminal charges against Hamblin due to insufficient evidence.
Joey Cannoli has rated this stream. Hey, thanks, man. Welcome. Over there on Rumble. Happy to have you here. Much love to you and your viewers.
Defendant's actions, Snellgrove's actions in directing the search and identifying the search under the guise of search warrants demonstrates ulterior motive beyond recovery of stolen property, specifically to harass plaintiff and assert control of property.
Wait a minute. Huh? Snellgrove's actions in directing the search and identifying items for seizure under the guise of a search warrant is not under the guise of a search. What it's a guise is a ruse, a deception, you know, like a costume. There was a search warrant. What the fuck are we talking? He keeps doing this. He keeps saying like that the search and seizure were somehow improper, but he hasn't stated that the warrant was found defective.
Law enforcement defendants ratify Snellgrove actions by acting in concert with him and by delivering Snellgrove the property of plaintiffs without a hearing or other due process. As directed proximate result, plaintiffs suffered damages. Negligence. Yeah, no, sticker badge would, yeah. Okay, so we'll just do standard negligence theory for a while. Each defendant owed a legal duty. Defendant Snellgrove owed a duty to act reasonably and with due care when reporting suspected criminal activity and participating in the execution of the search warrant by voluntarily assisting law enforcement. Well, maybe that's been proven wrong, or maybe their suggestion that's wrong. Maybe it wasn't volunteer, or maybe it was. But maybe it wasn't volunteer. Maybe that part is less true. But if it's less true, well, it only helps me, so I'll take it either way. By voluntarily assisting law enforcement in identifying search procedure, Snellgrove to assume a duty to ensure his actions were based on belief that the items were stolen or subject to lawful seizure. Defendant Mardi County and a whole bunch of these guys owed a duty to search reasonable care. There's just a random parentheses for some reason. Nice typo. Owed a duty.
Bro, you wrote it. I typically am not looking at his paragraphs. I'm listening, watching the chat. But the one I looked at, like stopped and read, there's so many errors. He's like, nice typo. It was, dude, unlimited typos. We got typos for days. We got typos on discount. We're getting them out of the back of an Oldsmobile. Random unbreaded commenter says 2 years and we're still arguing about a warrant's validity. You know, he's not making an argument about the warrant's validity. That's the crazy thing. That's what's bothering me. He's just saying under the guise of a warrant or whatever, but it's like,
duty to exercise reasonable care and investigate allegations, obtaining and execute search warrants, and handling seized property. This duty required them to conduct thorough and impartial investigations and ensure the search warrant was properly executed and safeguard the property in accordance with the legal standards. Brian Snellgrove breached this duty by making false and unsubstantiated allegations that plaintiff had stolen Snap-on tools and products without a reasonable belief for such claims, and after participating in search of plaintiff's residence and negligently identifying items for seizure that are not stolen or otherwise subject to lawful seizure, failing to verify ownership of the legitimacy of his claims. Law enforcement duty breached their duty by
Are you accusing him of making a false police report? Because reporting criminal activity, such as the theft or conversion of one's property, is protected, is privileged against a claim of defamation or fraud or falsity, unless you can prove that the report was fraudulently made.
Failing to conduct a proper and thorough investigation of Snellgrove's allegations before obtaining and executing the search warrant, neglecting to verify the validity of his claims or confirm whether the items were lawfully in plaintiff's possession. Executing the search warrant in an overly broad and reasonable manner, seizing items not specified or otherwise reasonably related to the crime, failed to properly inventory, safeguard, and maintain control of seized property, instead releasing Snellgrove without proper authority, due process, or any determination as to ownership. The breach of duty by each defendant were a direct and proximate result of the injury. Snellgrove.
So one of the things that kind of snuck in at the beginning is that this he said that the initial report created an investigation which resulted in a warrant. it's not like they went in willy-nilly and have no idea about any of this stuff. I mean, sure, Snellgrove is there helping them identify the property. That's mine, that's mine, that's mine, blah, 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 blah. But this is done by following an investigation. Again, developing probable cause, writing an affidavit, and to explain that probable cause to a magistrate or judge to request a search warrant, and then receiving the search warrant and then executing it. He's saying he was deprived without due process, but he actually received a lot of process. This is crazy.
False allegations of negligent participation in the search, said motion a chain of events lead to wrongful seizure.
Oh no! Who let the New Zealanders in? Why is Ricada dressed like Kurt's streaming room? Might win a match. How you doing, brother? Nice to see you, man. Dude, have you stopped streaming at all in the last 48 hours? No, I'm trying to do all of it. All of it at once. I like swing. I've got music playing in my head, man. I'm in it. You don't have to like it. I'm sorry.
Sure. But for Snellgrove's baseless claims and misidentification items, law enforcement would not
It's not
target
orange,
place
it's
residents or
school bus
seize his
yellow.
possession. Law enforcement defendants failed to properly investigate their overly broad execution search warrant, and their properly seized items directly contribute to and exacerbate the harm. Had they exercised reasonable care, the wrongful seizure and loss of property would not have occurred. Dismissal of criminal charges against plaintiff in November 2023 due to insufficient evidence further underscores defendants' actions lacked reasonable basis. Sure. As a direct result of the negligence, plaintiff suffered actual damages, including the valuable loss of property, such as the tools and equipment, which were serious and not returned, financial harm from deprivation, some of which was provided to Snellgrove without due process upon information believed, sold or disposed of, and emotional distress caused by unwarranted raid. The actions and inactions of all defendants collectively contributed to plaintiff's harm. Each defendant's negligence was a substantial harm in causing damages and therefore jointly and severally liable. Plaintiff seeks compensation for all damages for their damages. Texas Theft Liability Act. Defendants commit theft as defined by the law by unlawfully appropriating personal property with intent to deprive. As a result, defendants are jointly and severally liable for the Texas Theft Act. Defendants unlawfully appropriate property, including but not limited to Snap-on tools, by orchestrating and participating in seizure from the marital residence. I keep saying marital residence over and over again. It's just
You do keep saying the marital residence, and no one here can figure out why. Please tell us why you say marital residence.
It's a nice little extra. It's a little bit of a flourish by me.
That's your flourish? Okay, I need to know why. Why?
To say marital residence as opposed to residence, but I do like to throw that in there. Seems a little bit extra, flair.
What is the flair? Oh my God. No, I like this one. Texas Farm Girl. Oh my God, Nick, stop swaying, bro. Woman, you keep telling me to do stuff. I'm going to do the opposite. I have a bad habit of not listening to anybody. You're making it worse. You're making it worse.
It's not just the residence. It's a marital residence.
Sorry, it's not my fault.
Yeah. Blame me for stylistic choices.
Whoa, Ken's, I thought I banned you earlier. Don't tell her she can leave. She can't. She's stuck here with the rest of you. She made the mistake of clicking on the video. She has to stay. Don't go spreading these lies.
Although there is substantive effect to it too, to be honest, but We won't discuss that right now. And subsequently retaining or transferring it to Snellgrove without legal authority. Snellgrove made false allegations to law enforcement claiming the plaintiff had stolen tools or products, which prompted issuance of the search warrant. Snellgrove actively participated in the search, directed law enforcement, seized and took possession of the property. Law enforcement defected, acted on Snellgrove's false allegations without conducting a proper investigation or verifying the validity of his claims. They facilitated the unlawful appropriation by executing the search warrant without probable cause, seizing items not specified in the warrant, and transferring the property to Snellgrove without legal determination. The seizure was conducted under search warrant color of a search warrant procured through false statements and executed by law enforcement defendants without proper legal justification. And there's like a typo here. I'm not sure what this is supposed to be. Too properly. I don't know. There's just a random O for some reason. Oh, well. Proper legal procedures followed to transfer ownership or entitlement of this property, and plans were deprived of their property without hearing or due process. Defendant acted with intent to permanently deprive plaintiff of their property. I mean, seeing as that happened, yeah. Following dismissal of the criminal charges due to insufficient evidence, it became clear that near Snellgrove, no law enforcement had lawful claim to entitlement to the property. Snellgrove acted as the county's agent when he directed deputies to release the tools to him. Well, that's what I thought. That's where I thought he was an agent when he directed them.
That's where you thought he was the agent? Ah! Even your bad theory is dumb. Where he would have been the agent, if it counts as acting jointly with law enforcement, would have been in the execution of the search warrant, which is something that's solely within the purview of the fucking government, not in the release of the property. That wouldn't make him their agent. The direction of the acquisition of the property via search warrant under the color of law, if that qualifies, is what would make him the agent, because he would be acting jointly. That's state actor doctrine. Good Christ, man. The release of the property. No. Lots of people can release property. I'm going to release some right now. Seizing property is harder to do. That's the purview of the state. Fuck's sake, man. This is shit you shouldn't be getting wrong at all.
More like he was conscripted. Yeah.
What I just said is actually better than the conscription argument, because a cop saying something wrong doesn't make it something else. A cop saying conscription, which he can't do because he's not a military, and so he can't conscript him into it. A cop saying that doesn't make it a conscription. It doesn't make him a thing. It's like him saying, we conscripted him. You have no idea what he actually meant when he said that, because he said the wrong thing. You can't know what his actual intention behind it was. But if you just research the issue, and again, I typed it in to Google. I didn't even go, I didn't pull up Westlaw and dig into it and pull up case citations. I typed it into Google, state actor doctrine. I get the three different avenues for state actor in about 12 seconds. And then you just check on the one, acting jointly. That's the one it seems to be, because it's not the other two. All right. Very simple. What does acting jointly look like? Oh, okay. Well, just acting jointly. It's kind of a, I don't want to say a tautology, but maybe it's tautology. But it's just a repetition of itself. Like, okay, well, that's not super helpful. I could spend hours identifying and then, synthesizing what they mean. I'm not going to do that on stream. Kurt should have done that, though. But it took me no time at all. And he's like, well, the release of stuff. Like, what are you talking about? One cop. He said the conscription thing is his bombshell. That's the thing. That's how he's going to win. It is the pellet coming out of the musket. A cop used a word incorrectly. That doesn't actually make someone a state actor. What are you talking about?
Yeah, despite this, defendants have refused to return the property upon information belief of sold. Some of the items, the law enforcement defendants, by failing to safeguard the property, further deprived it. As a direct and proximate result,
Nick, you remind me of my brother. You annoy me so much. Hey, what did I do? I'm sweet and gentle, but I also care the same. Well, thanks. That's nice. I need more people who care about me. I really appreciate it, genuinely. May I ask your thoughts on the Guthrie case? That's the chick, the abduction, right? I don't really have much thoughts on it. It sounds like maybe the abduction is like the abduction of the old woman or something. Like, who steals an old lady? Why would you take a burden? Smells more like something else is going on with that, but I don't know what. I haven't really been following it. May I ask you to take off your glasses, for fuck's sake? You can. And I'll respond to you genuinely and wholeheartedly here. Part of the reason I wear the glasses is very simple. I have a lot of light coming at me. I got 2 studio lights, and I have blue light from these fucking monitors just right in my face. And my eyes get really tired looking at it. I also, they're green. They match my monitors and my shirt. They're coordinated. Come on, girl. Don't you like to accessorize? I do.
And of course, everyone's favorite one, conspiracy.
You have plenty of people who care about you. Oh, I know. I didn't mean to say it that way. You can always use more. I've been learning how many people genuinely cared about me that I didn't notice and appreciate. It's been great.
Conspiracy, which, once again, feel like I've got that covered. However am I going to prove conspiracy, Travis? However am I going to prove that? However am I going to prove that they acted together?
You have to prove that they did something wrong, though. You people act together all the time and do the right thing. It's just fine. It's like, Jesus.
I mean, you could just give it to me. I mean, this is... Geez, couldn't they have run it under spell check? This is me writing, Mandy.
I love you back, Rita.
This is mine. I wrote this. Are you saying, why didn't I run it under spell check?
You be quiet, Shadow Dancer. You be quiet. That girl's got some bangers. I'll sure she's mildly cute.
Jack? Yeah.
Now, take
Plaintiff Austin Hamlin
right
incorporates by reference all preceding paragraphs of the plaintiff set fully herein. Defendants engaged in civil conspiracy to commit torts of conversion and abuse of process by plaintiffs resulting in significant harm. The conspiracy is established by the following elements of Texas law. Defendants in Elk Grove and law enforcement defendants combined and acted in concert to achieve an unlawful purpose. Yep.
Okay, cool.
Yeah,
The object of the conspiracy was to unlawfully seize property under the color of law. Is that what you're going to say? They had a warrant and probable cause. You haven't said that the warrant was invalid or improperly executed.
Yeah, there was a random O, and there was a random parentheses. Yeah. There was a few stray characters along the way. I'll live. It's okay.
Hey, man, it's going to take some people
Defendants
time.
engaged in civil conspiracy to commit torts of conversion and abusive process resulting in significant harm. The conspiracy is established by the following elements. Well, the conscript pretty much took care of that for me, but defendants Stelgrove and law enforcement combined and acted in concert to achieve an unlawful purpose. The object of the conspiracy was to unlawfully seize the property under pretense of criminal investigation and convert the property for benefit consulting conversion. Additionally, defendants conspired to abuse the legal process by misusing the warrant procedure for the improper purpose of seizing property not subject to lawful actions. Defendant had a meeting of the minds. Yeah. On the object of the conspiracy, Snellgrove initiated the scheme by making false allegations of theft to law enforcement. The law enforcement defense agreed to pursue these allegations without proper investigation.
Audio souls.
Obtain the search warrant based on false claims. Allow Snellgrove to actively participate in the execution
It's
and
all
how.
right by Audio Souls.
And ultimately transfer the seized property to Snellgrove without due process. Yep. In furtherance of the conspiracy, defendant committed multiple unlawful overt acts, including but not limited to Snellgrove making false acts of theft, law enforcement defense failing to conduct a proper investigation, obtaining a search warrant based on false information, executing the search warrant with active participation and how, allowing him to identify items, seizing items that were not stolen or within the scope of the warrant, and transferring the items to Snellgrove without legal determination. As a direct result of the conspiracy, they suffered damages including loss. Each defendant is jointly severally liable for the conspiracy as their coordinated actions contributed to the harm. Plaintiffs seek compensatory damages from all defendants for loss sustained due to the conspiratorial conduct, including the value of seized property, financial loss, and emotional distress, in amount to be determined. Further requests costs, attorney's fees permitted by law, and aid.
So I can explain what's happening right here. This is inside the streamer's mind, and some people may not be. Notice what Kurt has been doing for the past several minutes of video. He sped up like crazy. I'm doing a similar thing. I'm letting him play through more without as many pauses. Reviewing these documents, this fucking thing's 20. He's on page 28 to 31. It gets really irritatingly tiring. Like, I don't know how he's doing his own. Like this would drive me nuts. I don't know how I could not review my own legal work because I would be so bored, right? Like reviewing these documents, you want it to have like some idiocy and comedy to it. And I'm a pretty straightforward legal writer. And I don't like fuck around or try and come up with some like crazy theory. I just write down the thing. Here's the things that's happening. Here's why they're the things. Here you go. Get the work done. Now I may have a little flair or something in the storytelling at the beginning, or in part of the argument, or in dispatching an expected counter argument, maybe. But generally speaking, I would just write down what happened, because that's how law like usually works. You just write down what fucking happened. If you're representing someone who is actually in the right, it's really easy. When you're not, you may have to be a little bit more ambitious. But yeah, he's getting tired of doing this because imagine reading the thing you already wrote. You know it's not going to be particularly funny. I mean, he's a little proud of himself. That's cute and adorable and stuff. Like, Mom, I got an A. That's wonderful. But it's like, oh, read me your paper, honey. By the end, the kid is tired of doing it. That's what Kurt's doing now. It's great.
Additional relief. So 10 causes of action later. So after having said theft like 7 different ways and some other stuff.
Wow. That's
we get to the prayer for relief.
No prayer.
Wherefore, plaintiff, that's me, I suppose, or my clients, either way, respectfully praise this court, grant judgment in favor of plaintiffs on all claims and for remedy sought, issue a judicial termination of rights, duties, and obligations, enjoin defendants from any possession, sale, or distribution of wrongfully seized items, or the return of all property seized, or in the alternative, award monetary equivalent of the property current market value or replacement cost, whichever is greater. Impose a constructive trust on any.
How dare you in any way try to convince the world and gaslight them into the idea that Kurt has a girlfriend? What the fuck?
Proceeds from sale of property held by defendants, requiring them to disgorge such proceeds. Nice. Award plaintiff actual damages for the value of property stolen in amount to be determined in trial. Award compensatory damage for replacement of items unlawfully taken, not recovered. Grant maximum economic, non-economic, actual, statutory, including but not limited treble damages under Texas Theft Act, emotional, general, specific, other damages. Award attorney's fees with appropriate multiplier, costs and expenses, and other damages. Any other measure of legal damages, including and without limitation as appropriate under law, compensatory, nominal, punitive, treble, statutory, consequential, incidental, liquidated, and any other special or general damages permitted by law, together with prejudgment and post-judgment, cost suit attorney's fees, and anything else I didn't think of.
Wow, it was really good, Kurt. I'm really happy you did that.
And also, we'd like a jury trial. Sincerely yours.
Yes.
Kurt Mueller. The Kurt Mueller Law Form. That's me.
Oh my God, it sold it. That was so cute. Oh, it's like a puppy. And that's me. Oh, that was so good. Genuinely. Oh, man. There are these moments. You watch people enough. There are these moments that are so fucking real and genuine. Kurt's walking this line and doing this because he's never done this. He's never represented a client before. He's conveniently omitted that the entire time he's been on YouTube and acted. To be fair, though, I don't think he lied. I don't think he lied and said he did. I think he kind of let it go. He kind of let it go and let people make assumptions and stuff like that. Fine. But he's never done this before. He just saw his name on a document that's filed in federal court. He drafted it. It says Kurt Mueller, and it says a Kurt Mueller law firm. That's me. My God, you don't get to see genuine shit like that often. That's a treasure. What a place in the human experience. Imagine that. Imagine your first achievement ever. And you've got this unique way to share it with the entire world. And you get to the end and you realize that is you. That's you. And he's proud of it. I can sit here and rip that shit apart all day, and that's great, whatever. But that was worth all of it right there. To see someone take so much pride, like rightful pride, not sinful pride, rightful pride in their own work. It takes a lot of work to become a lawyer. It really does. That was worth everything right there. That made me so happy. Holy shit. You don't get to see people in this way very often. It's usually behind closed doors. That shit doesn't happen in public. That was great.
So that is the case. Summarizing, we believe the police took stuff, transferred it to Snellgrove, the guy. Snellgrove converted the stuff into his own property, and our clients have not gotten the property back. And also that all this was done without a hearing. And also we believe that he was conscripted because the police said he was. So, and we believe that we've been harmed and we'd like, money.
Go for it.
So all those things. Are there 3 L's in Mueller? Apparently there are now. Apparently I mistyped my own name. Although to be fair,
own name. That's not. Ah, damn it. He just said all that. There he is. He's like, it's me. It's me. When he typoed his own name, he put too many L's in. Don't worry, Kurt. You can take one of the L's out of your name and just give it to yourself and save you a lot of time. The court's going to borrow that L later, I'm guessing.
Although to be fair, I mistyped my own signature. But since the signature is any mark you intend to be a signature.
There it is, right there. There's 3 of those bad boys. That's so funny. Holy fuck.
Well, yeah.
Oh, wow. Whoa, I've seen that before. Mi hermano? I'm going to switch to French. Qu'est-ce que c'est? Qu'est-ce que c'est? Oh, woo.
So all that good stuff. So
Hey,
the
Robin.
process is underway. We're having all kinds of fun. Trial isn't scheduled for a year. If we get that far. We'll see. But we're having fun. And now I've got to go yell at Snellgrove some more on the record. So I've got to file some things today.
You can do it. I believe in you.
So I got to go yell at Snellgrove on the record some more. You know, I should not be given this much power. I should not be given this much power. I have the power.
Okay. Holy fuck. Legal analysis document was trash. We went through. I paid as I went on that one. I don't have to. I don't have to settle this bill. The legal analysis is done, bro. The person analysis, like that moment of him seeing himself and his work and all of the work that he's ever done culminate in being filed in federal court. That's fucking cool. By the way, the first time you file a document is cool. It's so wild. That was a unique thing. You should treasure getting to experience that in some way with him. What is this? I should not be given this much power. You haven't done anything. Like, it was cute when you you got to see your homework on display in the newspaper or whatever. But now this is weird. I shouldn't be given this power. You haven't won. You haven't even started at this point.
Power to just file things and make them appear on the docket instantly. You know, it's like the worst "Are you sure?" button ever. Every time when you get to the end, you know, and you're going through the CM ECF system, and you get to that last screen, and it says, "By hitting next, you commit this. Are you sure?" It's like every time I press next, I want to shit myself.
Every time you pressed it, like what, twice at this point? I love it. I fucking love it. Life in General says, we'll laugh really hard if the court comments and says, this is really good work for a first-year lawyer. Or it's nice to see a 3L interning. Where's your lead attorney? Holy fuck. Man, like this is a... Guys, I don't know if this I've been made very clear about me. I love people. Like I love people so much. They're fascinating to me. And like as I get older and older and older and hear more and more stories and watch people in the places that they are, like you realize how complex and intricate each life is, how wildly different it is from yours, how our experiences are common and foreign at the same time. Because we hear something, we think we know what that means. Like we go, okay, I know what that means to me. And then you assume that that's what it means to them, and you're wrong every time. You're always wrong about it. It's the craziest thing. But it doesn't matter. Like, none of that matters. I love people. I think I could listen to people talk about themselves all day. Teach me something. Please, teach me something. Everybody knows stuff I don't. Getting to study, like, these little moments, like, wow. Wow! That's the best. I would love to see those like little moments from each one of you. Like I would love to see that. You never can, right? But what a fucking gift to watch someone go from this like hopeful satisfaction in the work and the result to then kicking that bitch into gear, being like, yeah, put the pedal down and go, nah, you shouldn't give me this much power. I can drive this car faster than the speed limit. Okay, why shouldn't they give that to you? That's weird. They give it to everybody else. It's amazing. To see this stuff is crazy to me. What makes someone like that on this thing? Like, why is that thing? I understand the first part. I understand him seeing his name and just, there's such a vulnerable moment. He's on a live stream, but you know, you filed the thing, like he typed it up, he filed it. It's been 3 months, but now he gets to look at it. Something he probably wasn't going to do, but now he looks at it and he's like, that's me. That's me. Amos. Someone did the razzle dazzle thing, was quoting Chicago earlier. in Chicago. Richard Gere. I don't remember who. I actually know the guy. He's the fucking dad from Dirty Dancing. Played Richard Gere's character on Broadway, but Richard Gere plays the lawyer in holy shit, where was I going with this? Oh yeah. Richard Gere plays the lawyer on the movie, and John C. Reilly plays Amos. Amos is Renee Zellweger's husband. Renee Zellweger shot a guy. Amos is taking the blame, or like ends up taking the blame for it. It's a whole mess. But so Richard Gere is representing Renee Zellweger. The entire movie, he doesn't remember Amos's name, or like he doesn't say Amos's name. He calls him something else. He calls him something wrong. The entire movie. When he has him on the witness stand, he says, "Okay, Amos." And John C. Reilly's character looks up. He goes, "Hey, yeah, that's me, Amos. That's my name." And it's like this. It's this moment. It's this moment where you're real. You're real in a way that you weren't before to yourself. And that's so cool. I love it. I love this stuff. It's so amazing. All right. Oh, shit.
And then it just instantly appears on the court docket. It's like, I should not be given this much power. Yeah.
But I understand that satisfaction. I don't understand this next thing. That's something else, which makes it fascinating. That's a disorder. That's therapy needing. Stop doing that. Ew. Imagine how much mucus this man eats. You hear him do that snort multiple times every stream. Just, you know, he's going to swallow that down.
So, yeah. Oh, and then
I would just
then I had to file a notice of correction for something I filed yesterday because I made a mistake on the certificate of service. So I had to file a notice of correction yesterday.
I'm gonna have a guess that you make a lot of mistakes on all the documents
because I put the wrong date. You know, of the many sins, you know, of the many sins, a random stray mark. I mean, it's not the most professional thing, obviously. You shouldn't have random letters and random like stray marks appear in your complaint. It's not great, but it's not like of the many sins, you know, it's like yeah. So all those good things.
Yes, this is interesting to me. He is not prideful. Like he being me or he being Kurt. Sorry, I haven't been following your conversation explicitly anymore. I stopped because I think I had addressed everything. So I don't know if Kurt is not prideful or I'm not prideful. I think Kurt is very prideful. I try not to be. Like I'm proud of certain achievements and stuff, but pride, what is it? He is a humble being. I'm the most humble. I like being simultaneously humble and a little bit braggadocious. Knowing all of the things people think of him. I don't know if this is me or Kurt. I need to know. Nick, roast those above you. So that's what I'm curious about. Like the first one, I just want to know, are you talking about me or Kurt? The second one, I want to know, what do you mean by roast those above you? Please explain. Are you hurt that much? Are you talking to me again? I don't know if you're even talking to me anymore. We had a thing. That's awful French, by the way. Were you criticizing my French? Of course it's awful. The last time I spoke French was 12 years ago when I took Lady Raggeds to Tahiti for our 10th anniversary. And the last time I spoke French before that was like 13 years before that. I don't speak it very often. Have I seen myself in my work? What do you mean? Holy shit. I watch myself work all the time. And then I sometimes come across like video clips or people quoting me. But what do you mean? Talk to me. This is wild. Now I want to know about this stuff.
Thanks. Well, I will keep you posted with this. We need to come up with a thumbnail for this. We need to come up with a thumbnail for the series or something. So we'll work on creating a thumbnail after I yell at Snellgrove on the record. Because I got to go yell at Snellgrove on the record.
Go yell at him on the record.
I'm going to go ahead and sign off.
Then go yell at him on the cassette tape. Then the CD. Then the MP3 player.
I've been having fun. And we'll talk later. Until later, my friends, I hope all is well. Cheers for now, my friends. And goodbye.
That blonde who centrally becomes available. Everything's so cryptic now. What's going on? Is it just because it's so late that I don't understand anything? Just ask her if she's under 35 and single. Are you under 35, single, never married, with no children? You can have some children if you stole them, but they didn't come out of your hoo-ha. You come up with them. Arian says to the nude resort. Now, wait a minute. No. Tahiti doesn't have nude resorts. Well, at least not the island of Moorea where I was that I know about. No. I stayed at the Hilton on Moorea, which is fucking cool. I had an overwater bungalow. It was amazing. But no one was naked there. I was naked because in my room, but because back then actually me being naked was far less common. This is a long time ago. I was a much different person. But Lady Rackets and I took an excursion. It was like a tour. Took you out on a boat. You went and swam with the manta rays that would come up and like they would hug you. It was wild. And oh, there, we're back. We're back. Holy shit. Here I was just talking about Tahiti. Where did I leave off? I like this. I like this. Texas Farm Girl. What moments of your kids do you remember in the middle of the night? Let's make a joke. Stop. When your kid, oh, this is amazing. When your kids think of you, how you want to be remembered. This is fascinating. Do you want to come on the stream and talk to me about this? I'm mostly kidding. Mostly kidding. I know what my kids think of me. I'm very, it's okay. Let's see. So anyway, we went out on an excursion. You take a boat out the. Oh my God. What is going on with the internet? I don't know why the stream's fucky. I thought it was, I checked the, stream. God. Oh my goodness. Okay, here's what I'm going to do. Deflection. I'm sitting here just talking to you. Deflect. Ha! Ha! How do I spend time with them? Honey, I have worked from home since 2010 for 16 years. Okay, so I spend, and we homeschooled our children. I've spent more time with my children than most men will get the opportunity to, because they worked 8 hours out, outside of the home. They had to commute somewhere, blah, 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 blah. Their kids were in school, etc. How do I spend time with my kids? I spend all day with them, every day. Some of them, wanted to go to high school at a school, so we said okay, and that's great. So they're not in the house as much. Our youngest two are still here. They're still homeschooled. I've spent every day of these kids' lives with them, unless they're like with a grandparent or something, and I'm not around. How do I spend time with my kids? In every context, in any context. Watch TV, read, teach them, drive them, smile with them, take them roller skating, take them ice skating, take them bowling. What do you mean? How do I spend time with my kids? I spend all of my time with my family that I'm not on here. It's crazy. Crazy. Don't tell me. Tab, buddy. I got one hand on the wheel and I got one hand on my gears or whatever, like a Nickelback. Okay, good night, everyone. Good night, Kens. Good night, Kens. Oh, I'm not worried about explaining anything. My explanations don't matter, but I like conversing with people. I find it interesting. What I want to know, though, was what was that fucking thing that I was asking? I was like, oh, shit, that's what I want to know. I wonder. Oh, fuck, what was it? Moments of your kids you remember in the middle of the night, blah, blah, blah. I drive my kids to school every morning, all that stuff. What was the thing? I'm almost there. I'm almost to that. Have I seen myself in my work? Yes, I guess. Am I hurt that much? That's awful French. I remember this. Almost there. So close. This thing. Yeah. Roast those above you. He's a humble being. Okay. I missed it in all the commotion. Are you talking about me or Kurt as the he? And then roasting those above you. I'm more interested in that. I call BS on this dude. Can't connect the dots. Wait, what are you talking about? You're so randomly weird. I'm intrigued. TBRHT says, just slightly vindictive. Can't wait till one of these douches make a mistake and get called out. I hope they remember their words. So sorry if I'm mean. Also not. Okay. My secrets are too deep. Oh my gosh. Oh yeah, that could be. It's a Bangladeshi AI. That'd be funny. I've devoted my entire adult life to my children. One of those ironies you can do nothing but laugh at is to be known by some as an abuser, a neglector, and all this stuff. It's like, that's literally the exact opposite of me. Oh my God. But okay. What do you do about it? But that's one of the things I've, learned over the past 2 years of trials. Holy fuck. What is the internet even doing? Is it operating by letter right now? Anyway, I got I got distracted, so I don't really care. How? I'm not ignoring you. Sorry. My husband would call him an embarrassing ninja. None of us would allow him in. I don't have the pass like he does, but I agree. Wait, who's a ninja? I'm not that quiet. My ankles creak. I'm going to go to my 28.8 backup. Internet by pigeon. No kidding. Holy shit. Here's what I'm going to do. I'm going to play the peeing lawyer song again. I'm going to go to the bathroom. And I'm going to hope that when I get back, the internet is stable. I do want to start. I want to at the next video. Miss Vixen, but I need all the pornography. I can't shut it down. Okay, I'm going to be right back. The show is not over. Don't leave. You can't. You're not allowed. You're disallowed from leaving. I'll be right back. Don't go anywhere.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited for what you have for us when you're being is through. When you have a small bladder and no sphincter control, freedom of the liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, drink some when the stream is over. When you have small bladder and no sphincter control,
Okay. Has the internet fixed itself yet? All right. So we watched Kurt here. Stop doing this. We watched Kurt. It was great. That's the first video. And it's done. It's done in its entirety. But Kurt has a follow-up to this because he filed a lawsuit and the other guy replied. I don't know that we're going to watch the whole thing because it's about the same length, maybe even a little longer. You know, that's okay. But let's take a peek. Let's take a peek at the beginning of it. Can we watch some Donut Daddy videos? Like Donut Operator? You know what sucks? A video with Donut Operator. And I don't think he ever uploaded it. We reviewed, what movie was it? We talked about like all the crimes in that movie. I think Jingle All the Way, the Arnold Schwarzenegger Sinbad disaster. Okay, here we go. Somewhere right around here, just a second. There it is. Shit. Just a second. I'm waiting for it to load up. Everything's all choppy and slow. Internet's 210 Kansas of string night. Well, people have, pointed out I've been streaming a lot, so I think out of internet today. Let's see. Was it before or after the news of you snorting a kilo came out? Long before. Years before. It was, yeah, he's like, yeah, let's do a video. We'll like go through some clips of and like the crimes and stuff that are in it. It's like, oh, okay, that's weird. Why didn't? I don't know what that means. Am I on Starlink? No, Starlink only recently became available, like officially available in my house. I was in that like penumbra of Starlink for a while. I think it's fully available now, but it costs a lot. It costs a lot. Your ISP is blaming you for using up the interweb. To be fair, I did have Kurt in frame for, and he's heavy. Why is every heavy holding on? Why is everything so heavy? Okay, I think we actually have 27 members. I didn't know. I'm sorry. Okay, so in the practice of law, one of the realities you have to fucking deal with is that catch you later, cat slave. audios. In the practice of law, one to deal with is having another smart, educated, well-read, researched, and probably prepared person come across from you and go, everything that guy said. Oh, wait, here, I'll just let Joe Pesci say it.
Everything that guy just says, everything that guy just says, bullshit. Thank you.
See? Brilliant. Brilliant. Oh, I don't know if I should do that. I'm not sure about that one. Some of those streams got really fucking wild. I got in trouble for several of them. I got in trouble for the concept of them. Holy shit. Destiny Rose, one of my favorite movies. It's one of the best law movies that exists. The legal procedure that happens in My Cousin Vinny is about the most accurate of any movie. It's crazy. When they did it as because he wasn't even licensed or anything. All right, so this is the response video. The defendant's counterclaim, I believe. Is it a counterclaim? It's the defendant's counterclaim. So it's not just a response. It is a counterclaim. They answer and say, no, in fact, it's him who's bad. You DM me a video. Why do I bother to roast Kurt but not Sean? Well, two reasons. One, Kurt's funny. And two, Sean isn't. Like, I don't know. What do you want me to... I mean, I've made fun of how fat that guy is quite a bit. But he was kind of one note, so I didn't, it's like I called him fat. I usually offer him a sandwich or two. But I'm not, I don't know. Sean hasn't offered minors alcohol and sex. This guy has. That was wild. He did it. He did it years ago. No one noticed. It's amazing. But yeah, Sean was really, really fucking... He got really out of pocket talking about my wife and my kids. He got so out of pocket, he actually unprompted, because I didn't know about it. He unprompted apologized to me and said, I was too far. I said shit that was mean. And it wasn't about me. It was about and before anybody says any other weird shit, this is before I got arrested or anything like that. He just started being an absolute cunt. Don't know why. There's a bunch of stuff that transpired because Sean would rip me another one. Do I have hostess tattooed across me? Trust me, I'm safe from Sean. Dear Christ. Sean is an appointed defense counsel attorney. He makes something like $55 an hour at most, with a cap of $5,000 per case. All of us lawyers who end up on YouTube, if you haven't figured it out yet, none of us are Alan Jackson, right? Or Bob Alessi. None of us are charging $2,200 an hour. None of us are getting out of our Ferrari to get into our Bugatti. some of them try to pretend that they're that level of lawyer. I never did. I just said, hey, I can translate what's happening and tell you guys about it, and we can laugh. It's okay. Is that what this is? Is it like, is this a Sean thing? I don't give a shit about Sean at all. Sean and I had a private conversation. Sean and I had a private conversation. Sean knows what happened in that conversation. He also knows I won't ever tell anybody about it, like the contents of it. Sean knows what he asked. Sean knows what I answered. Sean knows that that was after he apologized to me for needlessly making fun of my family, who no business doing that. And when he apologized, I said, forgiven, man. Like, who cares? And then he continued to be an absolute cunt bag after it. He said, I'll stop doing that. Like, that was too far. Like, I'm sorry. I said, forgiven, of course. Like, who cares? And he went right back to it. Sean was an asshole to innocent people who he has no business, like, no connection to at all. Because I guess, like, making fun of me wasn't working. I don't know. I don't know why he did that. But Sean knows. Sean knows why he called me about Mardi Gras. He knows about Mardi Gras. Sean acts like I did something to him. The only thing I ever did to Sean was say, hey, man, like, don't worry about it. Like, I forgive you. I don't, it's okay. That's what I did to him. That was my crime to Sean. Someone else asked him about it at some point. He's like, well, I am religious, and he was sinning, and, I take that shit serious. Okay, got it. Are you serious? What a fucking pussy. Well, I'm religious, and he did stuff that wasn't religious. All right, I guess. But Sean knows that in private to him, that he talked to me about, and he knows I always said the same thing. I forgive you. Don't worry about it. Thanks. Do what you need to do. Take care of yourself and yours. I'll be good. He knows that. He acts like I somehow did something to him. The guy can go fist himself, except he can't. He's too wide for his hand to reach his anus. Talk about Sean. He's uninteresting. But is that what this is about? Like, what's your deal now? I was just trying to figure out the, like, roasting people above me thing. That's weird. I don't know what that means. That being said, guys, let's take a peek at the opposing counsel's response. We're not going to watch this whole thing because it's 4 a.m. Although I have no problem staying up for another hour. We're just going to take a peek. Let's go.
Welcome to Uncivil Law.
There's a shocking difference in appearance from that other stream. Like, look at how crazy difference. Right? This is wild. He looks like a different person. He looks like Ric Flair right now. What happened? Like, this is this is blowing my mind. The lighting's entirely different. The lighting in the last video was way better. I told Kurt for years now, never ever not wear the hat. The hat's a good look. I like the hat. I think it's good. There we go. We're back. Is the shitty part about working in the middle of the night? The shitty part about working in the middle of the night is like that's when like internet service providers will just do their upgrades and shit like that. This is fucking killing me. I just want to take a peek at this video. All right. He looks way different. He's got a ton of dander around the... I can see a halo. Halo. Anyway, so he's got that going on. That's nice. Halitosis, I think they call it. He looks like a different person. It's wild. Okay, here we go.
Hope you're having a great day. And for today's stream, we are going to continue discussing an ongoing lawsuit that I, yours, Uncivil Law, am the lawyer for the plaintiffs for. Very exciting.
So
this
exciting.
complaint relates to a search and seizure that happened at my client's home. The police came in and seized some stuff in response to a criminal case.
If someone shelled out the 10 cents for plaintiff's motion to compel, motion hearing set for 2/18/26, 1:30 p.m. That's today. Holy crap. Would it have the Zoom link? Probably. Ryan Snerdley. Yeah.
Okay, then the criminal...
halitosis is bad breath. What's the... It's not psoriasis. What is it? There's like a condition. It's in Shallow Hal. The one guy has like a halo of dandruff, and he says what it's called. I just don't remember. Is my camera doing it because the Chiron at the bottom of the screen doesn't stop when you freeze? I don't know. It shouldn't be. I don't know why it would. Can you guys hear me when I like disappear? Because if you can't hear me, I'm usually talking. I don't think it's eczema. It's not dermatitis. Psoriasis is one thing, but there's something else. Audio drops too. Yeah. No, so it's not the camera. All right, let's go. Let's go.
The case eventually ended. The prosecution dismissed for want of evidence eventually. And then my clients are like, can we have the stuff back? And they're like, no, you can't have the stuff back. It's like, why not? Well, we don't have it anymore. What do you mean?
Well, because it wasn't yours, I think is probably what they said first.
Don't have it anymore, and so forth and so on, right? It's like, you took my stuff, presumably as evidence in a criminal case. The criminal case has ended. I'd like the stuff back. That's normally how that works. But no, not so much. We don't get the stuff back. So
it only works if you actually have a right to it.
Yours, Uncivil, on behalf of my clients, have sued everybody in sight. The police and also a guy. The guy who is the...
That's everybody in sight, by the way. The police and a guy. It's everybody who's in sight. Everybody else is out of sight.
Reported lawful owner who engaged with the police in the search.
Wildling Soul. No, she's not saying that. I don't think that she would be saying that at all. Anyway, I've met Tug in real life. He's definitely not Montegraph.
Search and seizure and some other things. And today we're going to be reading the answer from the guy. Now, the government also filed an answer to the complaint where they either admit or deny to, the various accusations, as you do, plus, the standard affirmative defenses, standard.
Yes, they assert all their affirmative defenses and reserve the right to brief on them later. Cool.
Standard run by the number template. So not much to discuss there.
Just some standards,
but
just some standard
the
stuff.
guy, Snellgrove, decided to go a little bit spicier in his answer, and he would like to file some counterclaims relating to this. So we're going to discuss the counterclaims today. So that sounds exciting.
Okay, let's talk about them.
So we pick up on page 10 of 12 because it's relatively short.
Answers are usually short because you just deny everything. Like you just deny, or you admit insofar as this thing and then you deny the rest. Nana K. Wag is a new member. Thank you, Nana K. Wag. Very happy to have your member here joining ours. Together we can fight infertility or whatever. It's like a field of green. We're gonna get it. We're gonna get there sometime soon. And my goal is to have the entire chat one stream be completely green without doing members only. That's cheating.
Pages 1 through 10 are, the affirmative defenses and the answers. But he picks up with counterclaims. Now, right away, you got to say, you're not in the greatest shape, right? I mean, you're bringing a counterclaim. This is like you filed a lawsuit against me.
Yeah. You're not in the greatest shape. You filed a counterclaim. Wait, what? What is that? What are you talking about? This is very confusing, Kurt. What are you talking about?
So you can do that, obviously, but 2 pages, right? It's a 2-page lawsuit because you only have 2 pages to discuss it.
Some people win $1 million judgments on 1-page complaints. What are you talking about? It's just a counterclaim. It's not a memorandum of law.
Right. If you want to, sue me, it probably needs more than 2 pages.
It depends on how many causes of action there are. What are you talking about? And he doesn't have to go through the jurisdictional series because you're a plaintiff. So you've already assented to the authority of the jurisdiction. He didn't have to go through any of that. All the parties are named unless he's adding one. Why would he need more than 2 pages? What does he need all the space for? You laid out a factual basis. He admitted or denied all of it. And then he's going to have his counterclaim. He'll add any relevant facts. And then he'll add, the count. But seriously, multi-million-dollar lawsuits are sometimes just 1 page long. They don't, depending on the pleading standards of where you are. Now, this is federal court, so you need a well-pleaded complaint or a well-pleaded counterclaim, which would mean that you have to lay out a factual basis for it sufficient to meet every element of the tort.
So right away, you're not off to a great start. But okay,
Why?
So you know right away it's going to be pretty conclusory, and yeah. But we'll read it for whatever it has. Defendant's counterclaims. Okay. Plaintiff was an employee of defendant. I'll remind you that there's technically 2 plaintiffs. The husband was an employee of defendant, not so much the wife. The plaintiffs are.
Who cares? You wrote it as his. You're like, I'll remind you there's 2. Who reminded you that there were 2, Kurt? You kept saying his. You didn't say theirs, I think, once in the entire fucking thing.
Husband and wife. The husband was an employee of Snellgrove, this guy, right? He was an employee of Snellgrove and for Snap-on Tools. And Kiska, is his wife. Okay, so plaintiff was an employee of defendant. While working with defendant, but whatever, plaintiffs conspired with each other and with others to be determined in the discovery process to steal merchandise from defendant's Snap-on franchise and sell the stolen merchandise out of his home.
Holy shit. That's one hell of a claim. Real Patriot Party says, Replevin Law, it's called seborrhea, a form of dermatitis. Thank you. Seborrhea. Did you get that from Shallow Hal, or are you just being smart? Yeah, see, one of the questions is, why does this guy have this Snap-on equipment at his house? Why does he have all of it? How'd it get there? What's it from? Alan Home, I'll always be gray. Why wouldn't you be green? Nick's my shyster lawyer, but I'm always willing to share. I'm shareable.
Well,
like Snickers.
I would like to note a problem right away. First of all, I can't speak to who these others theoretically are, since you haven't told me. So we'll ignore the theoretical others.
Yeah, we'll ignore this. They said they're going to try and identify them in discovery. Some jurisdictions and some courts require you to propose the hypothetical other parties in your complaint. In California, you have to have John Doe defendants. You put in like 10 John Doe defendants as standard, just in case you find someone.
For the moment, because who are these people? The husband is married to his wife, the other plaintiff. One of the key problems that you have here, of course, is that communications between husband and wife are presumed privileged in the first instance. Now, there are exceptions to that, but you actually have to work for it.
Yeah, the exception is claiming that they're both part of a criminal conspiracy. See, a husband can't be compelled to testify against his wife, and a wife cannot be compelled to testify against the husband. But if they're co-defendants in a criminal conspiracy, that privilege erodes pretty quickly.
Right.
He thinks he's really fucking smart right now.
So, and a conspiracy requires an agreement, right? We agree to do something illegal, and the illegal thing happens. It's like, well, how are you going to prove the agreement?
Really? The conspiracy requires an agreement. The conspiracy requires participation in the knowledge of the conspiracy, and then an affirmative overt act in furtherance of the conspiracy. The overt act in furtherance of the conspiracy necessarily require prior assent to joining the conspiracy. Assent to joining the conspiracy does not need to be express. You don't need someone to testify about the statements of another, because no one has to say, I'm joining the conspiracy. The participation and the overt act in furtherance of the conspiracy necessarily required you to join the conspiracy in purpose already. It's almost like if you could just get away with conspiracy, civil conspiracy, by being married, and then be like, how are you going to prove I joined it? If you could just do that, it would be, that would be addressed by Congress immediately. Are you fucking kidding? Stop being dumb.
Right? How are you going to prove these two people agreed on anything? Because
What is the statute? Which statute? The statute? The statute of what?
communications are presumed privileged in the first instance. So it's like, okay, that's fun. All right. Anyway, plaintiffs and others not yet fully known engaged in a civil conspiracy to commit the tort of conversion and theft of property.
Yeah, so here's the crazy thing. The prosecutor refused to prosecute because they cited a lack of evidence. Who knows? They dismissed out the case. One of the tough things is if the co-conspirator is the wife, it might be hard to compel the statement out of her, right? Makes sense. Okay, cool. If they couldn't flip the wife, and they couldn't flip any potential customers or whatever, the case falls apart. They've done the investigation. They find out that they've been stealing these tools, etc. But if they can't get testimony from other people, or if they're going to have uncooperative witnesses, it may not be worth prosecuting. Plus, they've recovered the property. The property is now going to go back to the rightful owner. Who really cares? This case is done. Do they really need to send people to jail for it? Do they need to go through the expense of a public trial on a weak case? No. But that's cops who have to get to beyond a reasonable doubt. Well, a county attorney have to get to a beyond a reasonable doubt. That's a high standard. That's hard to prove. It is what isn't happening in those cases, but is now happening here. Going after someone for civil theft and conversion at the beginning, right? Because Kurt's going for civil theft and conversion after his client theft and converted. Going for it at the beginning doesn't require you to get to beyond a reasonable doubt standard. Doesn't require it at all. It just requires you to get to, 51%. 51%. More likely than not. It's called a preponderance of the evidence. Like, based on the evidence, is it more likely than not likely that this thing happened? That's a much lower threshold, a much lower standard, much less specific evidence can carry and support the case. Also, there won't be a Fifth Amendment claim in the, aside from the marital privilege in a criminal case. You would have the marital privilege. You would also have Fifth Amendment nightmares. In a civil case, Fifth Amendment, they may plead it. In fact, that may be part of the strategy, is to get them to plead Fifth Amendment to avoid making self-incriminating statements or admissions. Cool, except you're in a civil case now, and that means that they're able to draw a negative inference. You're still able to take your Fifth Amendment protection, but they're able to draw a negative inference from it and assume the worst answer possible. On the record, the judge actually will take judicial notice of the negative inference. Okay? So now you've gone from the situation where the Fifth Amendment protects you to the Fifth Amendment condemns you. That's a problem. It could be the strategy of them to make criminal accusations, because remember that, the prosecution was withdrawn by the prosecutor, dismissed by the prosecutor, which means it was probably without prejudice, and jeopardy likely didn't attach, which means they could be recharged under the same set of facts that exists. Except, what if one of those facts is an admission that you were stealing or whatever, or that you did something that would amount to theft or some criminal thing? Well, now you go, okay, well, shit, if I say that, I'm saying it on the record in court, that admission goes against me, and then I can be criminally charged again. So now I'll take my Fifth Amendment protection. Except you doing that, it's like a forced chess move, right? Now I can say, I need to draw a negative inference on this question, Judge, over their Fifth Amendment avoidance of the answer. Well, now you've got a negative inference that's delivered to a jury or a judge, and you're fucked.
In furtherance of the civil conspiracy, plaintiff committed numerous overt acts, including but not limited to stealing property from defendant Snap-on franchise, producing false receipts for the stolen merchandise he had at his home.
Oops.
Selling stolen merchandise to defendant's customers and others not known at this time. How does he know any of these things? By the way,
no, he doesn't know it. How does he know any of these things? How does he know your client stole a bunch of shit from him and produced false receipts? Probably because he doesn't have the money from that would have been generated by the sales, Kurt. and he doesn't have matching receipts on his own system. How do you think? How does he know his stuff was stolen? Oh, I don't know. My God.
Wait, these are all conclusory statements. How does he know any of these things?
It's not a conclusory statement. Selling stolen merchandise. I guess the conclusory statement is that it's stolen. I don't know. I don't know if that's a conclusory statement in the way he means. He means in civil procedure way. Bellsouth versus Twombly, Ashcroft versus Iqbal. Oh my God. Here we go.
Lying and producing false information to his attorneys. Yeah, that's a good one. Lying and producing false.
That's you, Kurt. Did you get lied to, swindled by your client?
Information to his attorneys. How do you know that? Again, communications between a client.
Hey, Kurt. I would love to give you another guess as to how he knows that, but let me just suggest that you just wrote a complaint, presumably based on what your client told you. If reality is sufficiently different from what you wrote down, his only possible conclusion would be that either you made everything up on your own or your client lied to you about the facts of the case. Like, that would be the conclusions. Like, because reality is different than what was said. So you go, okay, well, the client lied, or it's something else. Like, it doesn't make any sense. He's like, how could they possibly know? Because they know what did happen or didn't and can weigh it out versus what you said.
An attorney are privileged. They're secret. So how do you know we had any communications at all? How do you know we talked? And if we did talk, how do you know what the substance of those conversations are? I guarantee you'll never find out because they're privileged. You won't find out from my client, and you're not going to find out from me. So how do you intend to prove that he gave false information to his attorney? I'm not going to tell you what we talked about. He's not going to tell you what we talked about. So how are you going to prove any of those things? Good luck.
You know, Kurt, there are ways to pierce privilege. I love that about Nick. He would spit statutes and facts so fast. Back in the old days, I would look him up, but he was usually right. I still do. I don't get it. I don't think you've been watching lately. I haven't seen you in chat very much, and so you're saying like what I'm like and what I'm not like. Look, if you watched when I first came back like a year ago, I wasn't ready to come back. I shouldn't have come back. I shouldn't have been here for Karen Reed, really. But I needed to start streaming. I would have died if I didn't. But I wasn't ready. It wasn't the right time. I was in a way different place, and I was a way different person then than I am now. So just hang out and don't worry about it. We'll have a good time. SVG Apricot, member for 4 months, says this guy is going to be arrested because Kurt sucks. There's a serious risk that his client could be arrested based on this civil case. It's amazing. Nick, my shareable lawyer. YouTube will not let me pay for or receive a free membership. I would have to start a new account and lose everything I've done for the last 15 years. Yes, they suck. You can always join on Locals. I'm with it. You could just create another YouTube channel too if you wanted to. Whichever one you want.
Good luck.
Alex Scott Thompson says, I remember back in the day, you used to have a massive hog and were so cool, you knew the name of every member of the A-team. Two of those things are still true. I did forget some names, though.
And operating a legal operation out of his home, which, by the way, not so much because those charges were dismissed, lest I forget.
Now, Gertie can still run an illegal operation and not be criminally convicted. Like, Jesus Christ. I know he's advocating for his client.
Defendant has been damaged in an amount over $300,000 for the stolen merchandise. Well, we do appreciate you establishing the value of the goods. So it's like, what is the value? Oh, it's $300,000 of property. Oh, yeah, you've been damaged to the 300. Oh, so you're going to establish the value of the property yourself and say,
hey, Kurt. Hey, bud. Has it ever occurred to you that in the process of doing this, your client is going to have to assert ownership of $300,000 worth of Snap-on tool property to a court? And one of the interesting questions that someone might ask your client is, where'd he get that? Maybe they won't ask your client. Maybe they'll just ask his boss and say, does your store have any record of this gentleman purchasing $300,000 worth of your products? And when he goes, no, in fact, our system has no record of that at all, nor does it have the $300,000 that we should have. Has it occurred to you yet the potential catastrophe your client and his wife, with all their privilege, are facing? Because if they're asked to claim how they came into possession of $300,000 worth of property of a company they work for, which I'm guessing they were not much above minimum wage in pay. And someone's going to go, hey, wait a minute. I can't buy $300,000 worth of stuff on a $30 an hour salary. How did that guy do it? And the moment someone does that, and the moment the depositions that are coming your way, I'm guessing, when they depose your client and they depose his wife, by the way, it's a conspiracy that they're both a part of. They don't have to ask questions about the other person's participation. They can just ask them about each of their own participations. When you're in a conspiracy or you're a co-defendant, like, privilege becomes much less protective, because they can just, now they'll take each one of them into deposition and individually ask them about their own status. They don't have to ask about the spouse. You're not privileged to not talk about yourself unless you want to plead the fifth, which again might be the strategy. Because when they get in that deposition room and they say simply, how did you acquire this property? Walk me through it. How did you pay for it? What register did you use? What sales associate helped you out? How did it get into the car? How did it get to your home? Who helped you unload it? Who helped you? You're going to start saying, yeah, actually, I'm going to go ahead and plead the Fifth Amendment. Because what you're going to do in the alternative is, under oath, explained how you started to construct a criminal business in a conspiracy with your wife and potentially other people that you're going to either talk about or plead the Fifth Amendment about. Or you cannot plead the Fifth Amendment. You can talk about it. You can talk about your criminal acquisition of property that wasn't yours. And then that missing evidence that they had that prevents them, where they're like, oh, we have lack of evidence, so we're not going to sue or whatever. Or we're not going to prosecute. Suddenly they have the evidence because it's your client saying it under oath. touchdown. On paper, unbreaded.
It's over $300,000. Thanks for clearing that up. Yeah, we think you took $300,000 from us. We appreciate you clarifying that. For the stolen merchandise and damage to defendant's reputation, defendant's entitled to recover this sum from plaintiff and recover any attorney fees he has to pay. Why? Why are you entitled to attorney's fees? What's statute?
Brooke, I used the fifth to relatively good effect. Unfortunately, that case is sealed, so I can't really show you how, but I did. It was cool.
Statute or clause of a what? Why? Do you want to cite anything? No. Defendant is also entitled to punitive damages. Okay. It's also worth noting that conversion is not a standalone. Conspiracy is not a standalone tort. You can't really just sue.
No, it's conspiracy to commit theft or conversion. They said that earlier. Were you not paying attention to the document?
Somebody for conspiracy. That's not a thing. It's a conspiracy to do something, right? At least in Texas. I can't speak to other states. Maybe in other states you can sue someone for naked conspiracy.
Ooh, I have a naked conspiracy. Hey, Ryan, I can't remember your last name. Not Ryan, the editor, the other one. Who is looking at this? Are you still in chat? Are you acquiring that Zoom document? If you are, can you send me the Zoom hearing info?
But in Texas, not so much. You can't sue someone for naked conspiracy. It has to be conspiracy to do a thing. Presumably the theft, I guess. But his only other cause of action is conversion, which is the civil version.
Destiny says, the way he said thanks for putting a value on the property. Did he not know the value of the property? Snap-on is expensive, but damn, that's still a lot more tools and so much more than I expected. Yeah, that's because they stole wholesale boxes of this stuff. Probably had it stacked up in a garage and were selling it part of the time. I don't know anything about Snap-on tools. I don't know how big they are or whatever, or what type of tool they are. Maybe it's a Kurt-sized flavored tool, whatever it is. I don't even know. You know what I mean? But, excuse me. No, I'm sure Kurt's client has some indication of what the value of the property would be, but he's excited that they're confirming it effectively, right? Like, whether they knew or not, now it's confirmed.
Of theft. So I guess that's what the conspiracy is for. Plaintiff took over $300,000 of Snap-on property that belonged to defend Snap-on franchise. Again, thank you for establishing the value of the property in dispute. That's very helpful.
Thank you for establishing the value of the property when you accuse my client of theft. Hey, Kurt, has it occurred to you that any jury or judge at this point is going to go, how did like an underling employee and why do they have $300,000 of boxed up Snap-on property in their garage? Did it occur to you at all that that's a weird thing, considering your client isn't Snap-on, but it's just $300,000 worth of their property sitting around? How did he pay for it? First question, how did they pay for it? It's insane.
Helpful. Plaintiff wrongfully and without authority, took the property and equipment that belonged to the defendant, stored the property at his home, and illegally sold the property that did not belong to him. Defendant has.
You know what I wonder? I genuinely wonder. I bet it's possible. I shouldn't say I bet. It is possible that Kurt, who has troubles with reality and with how people interact and act, literally doesn't fathom. It doesn't get it. His client definitely stole this stuff. Like, he doesn't get it. He might genuinely believe his client when he's like, no, that was mine. Here we go. Cyborg Valkyrie. As a stepchild of a 30-plus year auto mechanic who worked on European cars, his tool collection at retirement was only $180K. Let's see. Right-wing extremist. Snap-on basic auto mechanic said it's about $7,000. Let's take a. Should we take a quick peek? Snap-on Incorporated. They're not going to have purchasing on there, are they? Blah, 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 blah. Oh, okay. Here we go. And this shit's insane. Like, this isn't... I'm not familiar with Snap-on. I don't, off the top of my head, hadn't looked at it. So when I see a bunch of tools or whatever, I think like some socket wrench sets and, like some drill bits or whatever. We're talking those big fucking carts, like those rolling carts that cost like $2,000, and they're full with thousands of dollars of specialized hand tools. And they have Snap-on seems to sell, different tool sets for different prices. Okay, like someone says the basic auto set is $7,000. How are you going to explain having 40 of those? Right? Like, how are you going to do that? Why do you have 40 of those? I really like them.
Has been damaged to the amount over $300,000 for the stolen merchandise and damage to reputation. Defense entitled to recover this sum is entitled to punitive damages and recovering attorney's fees. It's pretty conclusory, guys. Are you really even trying? I mean, not really. I mean, it's pretty conclusory.
And Kurt, let's go back. Okay, let's see. It's actually not. This is amazing. So conclusory statements are from Iqbal versus Ashcroft. What it says is that in federal court, in your pleading, any statements of legal conclusion are disregarded. Again, you allege some counts, some causes, which all have elements, and then you lay out a fact pattern, and those facts relate to the elements of each claim. Right. And you have to have a fact, at least one fact alleged that fulfills each element of each claim. You have to have that. If you don't have that, that claim is going to get dismissed once the person challenges it. So you have to have they did the stealing. What are the elements of stealing? The elements of stealing, we'll say theft or whatever. Direct theft. Direct theft would be that the accused removed property that was not theirs from the owner to somewhere else without consent. Okay, so you have the 6 elements. And so then you just lay out a fact pattern for those. I don't know if that's the actual 6 elements, but it's something close to that. So you lay out a fact pattern, a fact that addresses each one. Plaintiff, like my client is this, owns the property. Other person came in and took property. My client, no permission. They took property somewhere else. Was not theirs. So here we go. Plaintiff took over 300. Sorry. I should explain this. A conclusory statement under Ashcroft versus Iqbal. A statement of legal conclusion would be someone defamed me. That's a legal conclusion, right? Defamation is a legal matter. To say someone defamed you is a legal conclusion. That would be ignored. So-and-so made a statement about me to so-and-so too that was false. That's not a legal conclusion. That's not conclusory. Those are facts leading to a conclusion of defamation, all right? That's the difference. That's what, when he's saying it's conclusory, what he's trying to say is it's a conclusory statement that should be excluded because it draws a legal conclusion. But let's look. Plaintiff took over $300,000 of Snap-on property that belonged to defendant's Snap-on franchise. That is not plaintiff stole property. Stealing, theft, that's a legal conclusion. Plaintiff took the property is just a fact. Plaintiff wrongfully and without any authority took the property. That's, again, not a legal conclusion. And equipment that belonged to defendant. So now they were not allowed to take it, and they didn't have the authority to take it, and it belonged to the defendant. That's just facts, not a legal conclusion. Stored the property at his home, fact, not a legal conclusion, and illegally sold the property that did not belong to him. The word illegally is a legal conclusion. So maybe they would ignore that. But they might just sever that and say, and sold the property that did not belong to him. Which is what it should say. They shouldn't have said illegally there. They should have left that out. But they can sever that word. They can sever the legal conclusion, just say, sold the property that did not belong to him. Which would be the same thing, really. But they just ignore the legal conclusion, which is illegally. So when you ignore the one legal conclusion in this paragraph, do you have a set of facts that support the idea that they stole something? Yes. Yes, you do. That's not conclusory. Kurt's like, it's pretty conclusory. This man legitimately does not understand first year law school terminology. Iqbal versus Ashcroft is first year civil procedure. I guess some schools might reverse the order, but probably not. Legal conclusions, conclusory statements in federal pleadings, first year civil procedure. He's wrong on this. Like blatantly, brazenly wrong in asserting his correctness. And this is basic stuff. This isn't complicated stuff. He's flat out misunderstanding it. The entire last video, incorrect usage of terminology, incorrect explanations. This is weird. This is not actually the Kurt I remember. The Kurt I remember, like whatever it was back there. I feel like he would have criticized his own work. I can't imagine him saying this was conclusory because it's not. It's clearly outside the definition of conclusory. But he said, we call it removal because we want to be fancy. I don't know why they don't say transferred. What are you talking about? Because it's not a transfer. It's a removal. It's different. I don't know if you guys know this, but we get very pedantic as attorneys because which word when you're just out in the world, you can carelessly use, similes. Or not similes, but, synonyms. You can use synonymous words and just, if the meaning is close enough, you go, oh yeah. And you just kind of adapt to it. Legal language is a little more precise because you might have two things that are really close to each other, which would make them synonyms, but have a critical difference that makes one matter and one not, like one legal, one illegal. Kurt's been all over the fucking board on this. I know he's being biased, but he's normally supposed to be unbiased. And he kind of said that up front, but that's not an excuse for what he's been doing here. He's just flat out wrong. And it's weird. I don't remember him being like that. The asterisk says Kurt seems to fight each battle as he first imagines it without ever reassessing any assumptions or adapting to changing conditions. Dangerous behavior for any agent, let alone counsel. Yeah, I think that's a fair assessment. Holly Movie Star says, worked at a dealership. Snap-on were the trucks going shop to shop. Was Kurt's client a dealer? They require initial investments from $200K to $500K. No, Kurt's client was an employee of the dealer.
Defendant has been damaged in the amount over $300,000 for the stolen merchandise and damage to reputation. Defendant's entitled to recover this sum, is entitled to punitive damages and recovering attorney's fees. It's pretty conclusory, guys.
It isn't.
Are you really even trying?
Oh,
I mean, not really.
Like, I'm starting to get tired now, so I'm starting to have a different, like, emotional output that's less mirthful. Kurt's going to get fucking killed on this. Sean McDonald says, artistic representation of the judge testing Kurt in his first appearance. Retarded. That's a fucking good one. Look, Kurt getting tested in his 20s. Okay. Those are funny. Why'd you do that? Why did you do that? That's amazing. Dirty Sippy Cup. Oh, shit, I missed this one earlier. Says, I love the glasses, legal and culinary Kurt analysis, and listening to Rockin' Tunes. Excellent work. Hey, thanks, Dirty Sippy Cup. I should focus on the positive instead of the negative. Where the fuck did it go? Oh, weird. That was very strange. Okay, here we go.
Really, I mean, it's pretty conclusory. It's like, do you want to provide any facts at all? As opposed to us when we filed our suit.
Right-wing extremist says, then in that case, $300K is nothing on the stock they'd have on hand. Right, but it's a lot for an individual to have at home, especially if it's repeated equipment, and stuff like that. But in any case, they're going to be asked in deposition how they acquired that equipment. Do they have receipts? Where'd they get the $300,000? Talk about your income. Talk about your savings. Are they rich? How much are they getting paid? Can they afford? Again, can they afford a fucking house worth of tools in their private marital home? Told the judge totally it's marital. Just remind him of the privilege. Like, okay.
Our claims were more specific. You came to our house and you conducted a search. You, the police, and Snellgrove, together acting in concert, came and took items and loaded them onto your trucks and took them away from us. And we want that stuff back.
Texas Farm Girl. Stop trying to protect Kurt. You can't stop me. You can't protect him from me. He is going to be bullied into being a better streamer, a better lawyer, a better lover. Whether he wants it or not, but he wants it secretly. So just chill. Relax. Show us your legal analysis. I have been doing like 6 hours straight of legal analysis, of actual legal analysis, rather than just ripping on Kurt being fat or ugly or dumb or bald or any of that. Literally 6 hours of legal analysis. We want to watch you do legal analysis. You are. You have been. You're just not paying attention.
Right. We actually detailed stuff that you did, like steps you actually took. Here it's just very.
They did too. You took $300,000 worth of stuff, didn't belong to you, but belonged to me. stored it in your house, sold it to people. That's every step of all of the things. That's the funny thing. He's like, 2 pages. That's all they needed. They didn't need anything more complicated than that. They did this. They took it, wasn't theirs, was mine, put it in their house, sold it to people without my permission or any authority to do so. That's all of the elements. That's everything. You're now on notice for exactly what they're going to come at you about. Like they haven't given you dates or whatever, but who cares? They don't need to. This happened. And they know because they don't have the money from the merchandise.
Conclusive. What did they do? I don't know.
They took stuff.
They just
that didn't belong to them. Put it in their house and sold it to other people without
it leaves a lot to be
permission.
desired.
It's not conclusory, you dumb motherfucker.
Request for relief wherein defendant praise the plaintiff take nothing but by their claims and causes of action. And as such, other and further relief which defendants should be entitled at law or equity. Defendants should be awarded attorney's fees and any costs. Again, why? Would you like to cite a thing? No? Defendant reserves the right to amend his pleading after...
What's up, shady conservative? Shady conservative. Yeah, I'm streaming not for much longer. I'm getting really tired really quick.
Completion of discovery. Uh-huh. Well, that's all there is to that. So this is a very, very short stream. I guess we can discuss my response to
This is a very, very short stream. 50 minutes remain.
This. Because there's not much to discuss.
Yeah, let's talk about your
response. So give me a second and I'll download my response and we'll discuss that too.
Oh, perfect.
Give me a second.
Why do you have to download it? That's weird. Aaron is gifted a membership. Thank you, really? Aaron.
Yeah.
Much appreciated.
Yeah, it's like, would you like to say anything? Would you like to make actual arguments of any kind?
Babe, the old Ricada, you never saw the old Ricada without some sort of mind-altering substance in his system. Not once. For 7 years straight, every single stream. I wasn't always actively on them. I wasn't always actively drinking. There are a couple, like streams and stuff that I would not drink pretty intentionally, but you saw me with liquor somewhere recently consumed every single day. You never saw me sober in the true meaning of the word of sobriety. And then eventually you saw me as, like on drugs every single time. And that's from the very first video that I put out. Every single stream, every single time. And there was a substance still in my system. Liquor at first, eventually hard drugs. You're looking at someone who's completely different today than that. I've been through a whole lot. My entire perspective on life is different. I've made peace with so much. I've gone through a lot of pain. I still go through every day. The old Nick isn't there. If you're looking for him, you will never find him. He's gone. And that's good. Don't live in your past. Why would you bother?
My only question is, why didn't the DA press charges for possession of stolen property? $300K of tools is a lot of stolen property.
The DA did press charges, but at some point, for some reason, they decided to voluntarily dismiss out the case for lack of evidence as the citation. They said, lack of evidence. We don't know if we can prosecute this case. That's to get to beyond a reasonable doubt. Getting to preponderance of the evidence is much different question. Much, much easier. Swinging Cod says, is Kurt opening himself up to sanctions or a lawsuit for malpractice if he ends up walking his clients into a criminal conviction? No, probably not. I mean, maybe his clients can make an ethics complaint, but I'm guessing Kurt fully discusses the risks of all this stuff like a good lawyer that he is. He's probably letting his clients know that there are significant risks where and likely traps involved in these counterclaims. And if they want to proceed, they're going to have to subject them to the very real possibility that they'll be deposed and have to make under oath statements that could lead to criminal implication, and that they would be able to plead the Fifth Amendment, but by doing so, a negative inference would be drawn that would have serious deleterious effects on their ability to prosecute the case that they are bringing. I'm sure he's advised his clients of all that and does so at every step because Kurt is a thorough and careful lawyer. Sharon P54, thoroughly and carefully joining as a paralegal. Thank you so much. And TBRHT coming in with 10 gifted memberships. A boom. Which brings us to 39. 39 subscriptions, or 39 members. 39 members tonight. Thank you so much. This ticker, of course, the membership tracker, the member tracker. We track all members around here. The member tracker is brought to you and sponsored by Kurt's Dating Advice, Cosmetology, and Chicken Shop, your one-stop shop for chicken, cosmetology, and cosmetology products, advice, technique training, and of course, most importantly, dating advice. What purpose is poultry? What purpose is being pretty if you're not putting that into practice? And Kurt's Dating Advice, Cosmetology, and Chicken Shop is your one-stop shop for all of these needs and to take care of you and your soon-to-be. Thank you very much, Kurt's Dating Advice, Cosmetology, and Chicken Shop for sponsoring the show. As always, huge fan of the show, endorses everything I say. Clav Jez has gifted a membership as well. Thank you so much, Clav Jez. I think that's Greek. That brings us to a cool, even 40 YouTube memberships. Beautiful. Thank you so much. You guys are generous. You guys are communal. Just kind of smelling a little Russian in here. That's why y'all are so pretty.
Okay. So let's go ahead and discuss my response to this, which I filed on the docket. We'll go ahead and cover that.
Sharon P54.
So that we can have some
gifting
discussion about
membership.
something that
Thank
might,
you, Sharon.
have merit.
Very generous of you. Bring us to 41 rigid, magnificent, and enviable members.
All right, make this a little smaller.
Are we still over 2K members? We are, last I checked.
Great.
Which was earlier today.
All right, let's discuss what I filed.
You didn't get groomed hard enough earlier? Welcome back. We can fix that. Come on. Get in here. Get groomed. Get groomed. Thank you.
In response to that wonderful little 2-page bullshit. I
feel like I'm just trolling you guys right now, just dragging the stream on forever. It's like, oh no, I'm gonna end it soon.
A motion to dismiss and motion to strike.
I have to drive at 7 a.m, so I'm not going to sleep until I get home. I got all the time in the world. But 2 hours. I'm not going to use the 2 hours though. I would like a little break.
So let's discuss that. Plaintiff moves to dismiss defendants Brian Snellgrove's counterclaims pursuant to Rule 12b-6
Aaron.
and to strike certain scandalous accusations under 12f.
Aaron gifted a membership. Thank you, Aaron, for doing so. Very awesome. Very awesome, very awesome, very awesome. 42 members. An uneven and irrelevant number. Oh, shit. I'm sorry, Jackie Robinson. Jackie Robinson was 42, right? Did I get that right? Joe Choi gifted a membership as well. That brings us to 43. One member at a time. One member at a time. We will climb out of the pits. Thank you, Joe Choi. Much appreciated. Much appreciated. Wildling Soul, I have one of the best jobs on the planet because one, get to groom. Two, I get a ton of positive reinforcement. I'm encouraged constantly. I'm rewarded for being a good boy. Clav Jez is gifted a membership as well. Now we're up to 44. Terrible number. Terrible number. 44 members on YouTube tonight, which is relatively insane. All things considered. All things considered. If you only consider some things, it's sane and not insane. But all things considered, it's relatively insane. Let's see. Just doing a quick locals check. Oh, shit. We actually had a locals subscriber. 2 of them. Holy criminy. We do have 2 locals members as well. And one's 2 cents says, keep streaming, broski. My post-op entertainment. 1 month. 1 month of firm membership. Thank you so much. So we got 2 locals, and Aaron is gifted another membership, which brings us to 45. Impeach 45. And then Sassy J in the UK, boom, 10 memberships dropped on the table. The thundering sound of members slamming into surfaces brings us to 55 members for the stream. Thank you so much. Really, really amazing. You guys support me like good underwear. Clavjez, thank you for the $2 super chat, even though there are no words. A man of few words, or woman, as it were, if you will, ambiguously named.
Snellgrove's counterclaims are facially deficient, among other defects.
It's clove. Clove like clover. My bad. My bad. My bad. Oh, yes. I got to add the 2 locals memberships. It's always cool to see a couple locals memberships pop up. Locals has so much potential. It really does. But at the same time, they just overlook simple ways to add a ton of value. Doing stuff like Discord incorporation, because they don't have chat rooms. Like, they don't have the feature. Oh, shit, I think I just realized. Oh, wait, no, we're not on local. I was worried that locals, that it would exceed the local streaming time. But we're not on locals streaming. We have a chat open. But so we're good. But locals needs things like just the ability to gift subs like YouTube does. Stuff like that. Like a simple way to do it. There's a very complex way to do it. They need that. Discord integration, shit like that. Make the space appealing. I think locals, I pitched this to, what's his name? The guy who used to be the CEO of locals back when there was, I can't think of his name off the top of my head. Really nice guy. Really nice guy. First thing he said to me was, Nick, love you, but why are there so many Jew jokes in your chat? And I was like, oh, buddy, I'm sorry. Anyway, I pitched crowdfunding to locals. I'm like, you guys should become like a Kickstarter, Indiegogo type thing. Like, not become that, but offer that as part of a community. Like, imagine so you buy the thing and then you have membership baked into it as like part of the tier reward. Okay, I'm going to order my $40 comic book and that gets me 3 months of membership. Or, well, you get your $40 comic book, or you upgrade to $70 and you get a year or whatever. You know, these types of things. They have all the tools right there. Like, everything's set up where they could do a crowdfunding thing, and payout on locals is immediate because it goes through Stripe. And it's like, Why don't they do that and promote it? There's so many things that locals could do. It drives me crazy to see it kind of languish.
On the face of Snellgrove's own allegations, these counterclaims are time barred by the applicable 2-year statute.
When is your criminal ass coming back on Cody's stream, you bum? He invited me the other day and I couldn't come, but next time he wants to have me on and I have the time, I'm there. I love that kid. That grown ass man. TBRHT, another 5 memberships. Oh my gosh, throwing it down, girl. Thank you. Thank you so much. Much appreciated. People are getting dicks in their faces tonight. We should all be jealous.
Limitations. Oh yeah, there's that.
What did Kurt say here? So plaintiff moves to dismiss under 12b-6, which is failure to state a claim upon which relief can be granted. He'll fail that. The claim was well pled in the it was simple, but it was well pled. They took things, didn't belong to them, belonged to me, took them from me, put them in their house, and then sold them. Boom. That's all of it. It's not any more complicated. It's how you 12b-6 that. That's a clear, non-conclusory statement of facts that leads to the legal conclusion. Then they have Rule 12F, which is, oh, fuck. Let me see. Federal Rules, Civil Procedure. I don't remember what 12F is off the top of my head. I feel like I just looked this up. Okay, this is a motion to strike. Okay, so under fucking hell. Strike certain scandalous allegations. It's a lawsuit. All the allegations are scandalous. What the fuck are you talking about? And holy shit, TBRHT dropping 10 more. Suddenly we're at 70 members. Holy shit. Suddenly the activity has kicked into overdrive. Wow. God, look at all those beautiful members. And then, let's see. Snellgrove's counterclaims are fatally deficient. All right. Among other defects on the face of Snellgrove's own allegations, these counterclaims are time barred by the applicable 2-year Texas statute of limitations, Texas Civil Practice and Remedies Code, Section 16.003. That'll be an interesting one, the statute of limitations. It's Texas Civil Practice and Remedy Code 16.003. Let's see what this is. Hello, fine law. 2-year limitations period, except as provided in 16.010, 16.0031, 0045. A person must bring suit for trespass, for injury to the estate or to the property of another, conversion of personal property, taking or detaining the personal property of another, personal injury, forcible entry and detainer, and forcible detainer not later than 2 years after the day. The cause of action accrues. Person must bring suit not later than 2 years after the day the cause of action accrues, an action for injury resulting in death. Cause of action accrues on the death of the injured person. Okay, what's this one say? What's 16.0? Oh, I don't. See. Damn it. So 16.010, 0031, 0045. Okay, go away. 0. Misappropriation of trade secrets. 0. Whoops. Fuck, what was that? 0045. There we go. Limitations period for claims arising from certain offenses. Let's see what that says. Limitations period for claims arising from certain offenses. Sexual assault, aggravated assault, continuous abuse. Okay, this is all this stuff. So here's going to be something interesting. Here's something interesting. How are you going to establish that it was outside the statute of limitations? They didn't say the date upon which these events occurred. They just said that they occurred. It's going to say they're time barred. No, we stole them earlier than that.
Background. This lawsuit arises out of an incident in May 2023 when law enforcement officers, along with and acting in concert with Snellgrove, searched plaintiff's home in Big Spring, Texas, to recover certain Snap-on brand tools that...
Wait a minute. Wait a minute. How are you within the statute of limitations?
Been reported as stolen by Snellgrove. During the May 2023 search, defendants seized various items of personal property, including various Snap-on tools. All criminal charges were dismissed by the prosecutor on or about November.
Stokes X says, will you have Darkside Phil on the show, yes or no? It's time to finally answer up, son. I've invited DSV on the show several times. I don't know. Does he want to come on? Like he has... Homegirl has my contact info. Texas Farm Girl says, yes, the I have to drive soon is concerning. What are you talking about? What are you so worried about? I do this every day. Calm down. M1 Ping 686, member for 3 months, says, does Kurt write lawful law better than he cooks? No, not really. It's all trash. It's amazing. Cat Black says, Sean is jealous of you. And stop. You are the Pope. Yeah, I mean, probably. Sean is jealous of the 6 of me that don't exist. V-Sync says, hey guys, is Iran happening? Because oil futures are kind of launching right now. Swinging causes everything makes sense now. They waited until the statute of limitation timed out before filing suit, but that doesn't change whether they stole only criminal punishment. Similarly, the statute of limitations may have been suspended during the pendency of the criminal trial, or the criminal charges. I don't know. Like, that would take some research.
November 13th, 2024. Plaintiff filed the present suit seeking redress for violation of their rights and for return or compensation for their sneezed property. Among other counts, plaintiff alleged that defendants, including Snellgrove, have wrongfully continued possession of the property that was initially seized with a facially valid search warrant. We are conceding that the warrant was valid on its face. Now, what it was a warrant for is something we will argue about later. But we are conceding that the warrant is facially valid.
What?
We think they...
Oh my God! That kills your entire case! The whole thing is over, you dummy! If you concede that the warrant is facially valid, then it was properly exercised, or that the property was properly seized. Your entire complaint said it was improperly seized under the color of a warrant, depriving your client of rights improperly. But a properly executed warrant, a facially proper warrant, does not improperly deprive you of your property right. It properly deprives you of your property right. That's the fucking point of it. Holy fuck.
It went beyond the face of the warrant but we do concede the warrant is facially valid because, yeah. So we'll give them that much.
How are you going to justify your lawsuit if the warrant is facially valid? You're going to say it doesn't name with particularity all the stuff they stole or that your client stole that was then recovered? Because they didn't know exactly what it is. I'm sorry if they go, they have the right to, seize any Snap-on parts, anything related to the acquisition or unauthorized sale of Snap-on parts. Here's a theory. They said they didn't prosecute for lack of evidence. It's quite possible that they had a witness, someone who was a buyer, for example, who had bought some of the stolen goods, who then flaked out on them as a witness. But they may have had them as an informant and stuff during the investigation. Something like that could happen. But then the witness flakes out, dies, disappears, has a huge credibility issue, like a bunch of fraud charges and convictions, things like that come up when you start like looking into the case, and you built up all the procedure going up to it. But then when it comes down to actually prosecuting it, and you have to put dick to paint, you go, holy shit, we're going to have trouble here, and here. We know this is all right, but like we can't actually, like, we're going to have procedural issues, or we're going to have a massive challenge here, or this person's going to burn us. And you go, maybe we can't win this case. Maybe we can't win this case. Plus, we got the person's property back. What do we care anymore? Like, we got the right thing done.
Plaintiffs have not regained possession of their property that was seized from their home. Additionally, plaintiffs have alleged that defendants disposed of plaintiffs' property, including for Snellgrove's personal use without a hearing adjudicating plaintiffs are not in lawful possession. Right. That's basically the sum of the case. You took stuff and there was no hearing to determine whose stuff it was, and you didn't.
You don't need one. What are you? No one does this. No one lives like this. If your client wanted to challenge the ownership, you bring a challenge to the ownership. You're suing the state for depriving you of property, but they're returning it back to someone who it belongs to. Can you imagine, guys? You're sitting in your like 2-bedroom house, your 1,800 square foot house. You're a Walmart employee. The cops bust in, all right, and you have $100,000 worth of the same HP laptop just stacked up in boxes. You got 100 of those bad boys. They're $1,500 a piece. They're all omens. They're just stacked up next to your couch. Cops are like, we're going to go, like, we have a search warrant. We're going to seize those. And they return them to Walmart, where they were obviously taken from. And you're like, they didn't have a hearing to determine those were Walmart's and not mine. Can you imagine, like, the audacity? The insanity of that scenario. Like, it's so fucking obvious you didn't buy that, because why would you buy 10 of the same laptop? Where'd you get $150,000 working at Walmart? Like, they didn't go to court and prove it wasn't mine. Okay.
I got off work early tonight, BQS3. I worked 12 last night. I can't believe you are still going my knicker.
Bequest 3. I love typos in Super Tips because it doesn't know what you actually are trying to say. Something on my lip. Probably a piece of lip. But here's the thing. I love my job. I had some troubles getting back into it for various reasons. You have apprehension, anxiety about it. You're worried about failure, all that shit. Blah, blah, blah. Boring. I love my job. I always have. This is what I've wanted to do my entire life, is tell stories, make people laugh, talk, hang out, learn stuff, meet cool people, like do something, and then impact people positively, you hope, right? This is what I wanted to do forever, and I actually stumbled my dumb ass into it. And while I was working at banks and finance before, which I didn't mind, but, you know, like, I'm not built to be governed by a boss. I'm far too self-important for that type of shit. I don't mind streaming all day. I was always serious when I said, guys, I really want to stream more. My schedule is just fucking killing me, and I just can't do it. I just don't have the time to do it. I don't have the opportunity. I always have something to do. I love streaming. I'd stream all day. I think it's it's so much fun. If people are there to watch and talk to, I will stream all the time. I just can't because I have other obligations. Cat Black says Kurt is flaky. He sheds when he moves. Ew. Thank you for ruining my appetite.
Give it back to us. Snellgrove answered the First Amendment amended complaint in August 2025 and asserted 2 counterclaims: civil conspiracy and conversion. In essence, Snellgrove's counterclaims allege that the Hamblins themselves.
What adult uses the word dummy? Tons of them. Why are you like this? What's going on, girl? Who stole your oatmeal?
Conspired to steal or wrongfully retain Snap-on tools belonging to Snellgrove and thereby convert the tools to their own use. Yet Snellgrove's pleading is short and plausible facts. I mean, there's really no facts of any description, to be honest.
What do you need? They took it. It wasn't theirs. Was Snellgrove's or whatever. Didn't have permission. Put it in their house and sold it. What more do you need? The only thing they maybe are missing is the date. They may be missing the date. They may not know exactly when they were taken. They may know exactly when they were taken. Maybe they didn't put the date down because of the statute of limitations issues that you were mentioned. Maybe it's possible to overcome the statute of limitations issues since it's a counterclaim and involves another claim. Who knows? Who knows any of this shit? Don't know.
He peppered his counterclaims with inflammatory accusations. For example, plaintiff Austin Hamblin lied to his attorney, falsified receipts, and was running an illegal operation, but fails to set forth a coherent theory satisfying the required elements of conspiracy or conversion.
He was running an operation which stole and sold expensive tools. They're what are you talking about? I remember this from my legal writing class. My legal writing class, all of my colleagues would write these like 40 and 50 page responses to the assignments. And mine would be like 18 to 24 pages. And I get an A on them. My professor says, it's really nice to see someone use words economically and to speak clearly and to write clearly and concisely. But I was a writing major. But I wasn't one of those writing majors who wanted to write like a million words. I wanted to write as little as possible. and then go cook lo mein for cheerleaders at midnight. Like what is college for? Is college for all this learning? No. College is for hanging out with cheerleaders. Well, other stuff just got in the way. But you learn to write concisely, crisp, get the point across, put it on paper, and then let it go. These people were write and overwrite. Kurt is sitting here going, well, his complaint was short, so it's bad. My complaint was long, so it's good. Okay.
Moreover, Snellgrove sat on any such claims for over 2 years after he had knowledge of the theft by his complaint to the police that initiated the seizure. See, Snellgrove knew the things were taken when they were taken, right? So he has knowledge of the conversion at that point. So his clock started running earlier than ours, as we will discuss soon.
Okay, discuss it with me, Kurt.
Standard of review. Always helpful to discuss the standard of review. 12b6. A motion to dismiss under 12b6 tests the legal sufficiency of claims stated in a pleading to survive a complaint or counterclaim because they're the same.
It assumes all properly pleaded facts in favor of the non-moving party and determines if relief could be granted if all facts are resolved in favor of the non-moving party. If they can, then it goes on. If they can't, then it's dismissed. Very straightforward.
Thing. Must contain sufficient factual matter accepted as true to state the claim is plausible, right? All facts will be taken as true, but you actually have to state.
Thanks for this very helpful life advice. I didn't know how to do that. I didn't know how. I've been doing it longer than you, sweetheart.
That would be nice. And then I cite some relevant case law. While the court must accept well-pleaded factual allegations as true and view them in the light most favorable to the claimant, legal conclusions are not entitled to an assumption of truth. Yeah, your conclusions are not entitled to the truth.
Hey, Kurt, name the legal conclusions in their paragraphs. There was one. It was the word illegally. They can remove that. The court will ignore that, and every other thing still leads to the conclusion that your client's a cunt who stole a bunch of stuff and is now trying to sue the government to return stolen property to him improperly. Fuck off.
Facts are, not your conclusions. The claimant's obligation is to plead.
One's 2 cents is if you're cold, they're cold. Bring your trolls inside, lol. Enjoy those properly used oxys, my friend.
Facts that, if true, raise the right to relief above a speculative level. Dismissal is proper if, after accepting all well-pled facts, the court concludes claimant has not stated a plausible claim or the claim is barred as a matter of law. Notably, the court may dismiss a claim on limitation grounds under 12b6 when it is evident from the face of pleading the claim is time barred. And then I just cite a case for this proposition that says dismissal is appropriate if it's clear from the face of the complaint.
Dude, he cited a case. Fuck. Oh, yeah. My blood is flowing now. He had a citation. I cited a case for that. Cool, Kurt.
Claims asserted are barred by the applicable statute of limitations. So it's like, I just said a thing and now I'm going to, cite the case that says what I just said, because that's usually a good thing to do.
That's what you do, yes.
Rule 12F permits the court to strike from a pleading any redundant, immaterial, impertinent, or scandalous matter. Motions to strike are generally disfavored, which is true.
Motions to strike are generally disfavored. What are you striking from this pleading? What's too scandalous for it, Kurt?
True. You got to accurately state the law, It's like you got to make sure the court knows that you know that you're not trying to pull one over on them. So I know they're disfavored, so I've got to tell the court that. It's like, yes, I know they're disfavored. I'm going to try to tell you why you should do it anyway, but I'm going to tell you it's disfavored, and then I'm going to try to tell you why I do it, because, it doesn't hurt to be honest about the standards. It doesn't hurt to be honest and be like, here's why you should do it anyway, right? So yes, it is disfavored. However, scandalous allegations.
I love it. I'm gonna tackle the negative possible argument and right away dismiss it out of hand and then talk about why I'm right. That's what you want to do. Oh, is it? Is that what you want to do? Okay. So how do people watch this guy? Oh, I want to rub my teeth across cinder blocks when he talks.
Those that improperly cast derogatory light on a party or person are an exception. Courts have more latitude to strike such material in order to uphold the dignity of the proceeding. Scandalous matter is that which casts an improperly casts a derogatory light on someone, and typically includes allegations that unnecessarily reflect on a party's moral character or use repulsive language. If the offending allegations are irrelevant.
How many views does this have? Is 4660
to issues and may prejudice one of the parties, the court may strike to avoid distraction or harm.
No, Sunderwear, I'm thanks for pointing that out. It's 5:30. We should wrap it up. We don't know where this chick's been. We're going to have to go. Well, we're going to have to resume this later today or whatever. All right, guys. sometime this week, I think I'll be interviewing Ryan Mullally. We'll be talking about, there's a shitload of legal issues out in the cultural zeitgeist to figure out. So we'll have him on the show. The guy's been practicing attorney for like 30 years. Should have some cool stuff to talk about. Ron Coleman will not be this week. Maybe next week. We'll see. See how that goes. When is Lips? I will text her. She's in Florida. It's a little early. I'll text her before I lay down. Sometime in the next couple hours. I'll text her and just say, hey, like, let's get back to planning this thing. I would love to interview her and Michael. And then Laura Owens coverage is going to start soon. I want to start in advance of that. And then that Corey something trial that's about to start in 5 days, I think. That Corey Rikens, Corey something, whatever. The chick who poisoned her husband. I want to do a full trial watch on it. It starts on the 23rd. Winnie the Blue. Kurt looks like White Shrek. He does. I know. Oh, Kurt crashed. I wasn't trying to tell you how to do anything. You weren't trying to tell me how to do anything. You tried to tell me to do a whole bunch of stuff. I care like Megan does. Stop being rude. You said you didn't mind. Now I'm hurt. I may not know you like Megan does, but I care like Mrs. Fox does. The fuck? Sorry, Nick. You misunderstood me. I said that from the beginning. I was just trying to get you to answer some fucking questions so that I could talk with you, but it gets kind of lost in the chat. I'm not like, I'm sorry if I upset you at all. I'm just energetic. I'm not mad about anything. Courtney Clenny is still holding it April 27th. No, like I was, I clapped back right away because I misunderstood your initial comment. And then we discussed that. I told you why. It's because other people who say the same thing mean something different. And so that's what I assumed you meant. And I apologized. I said, I'm sorry for misunderstanding that. Here's why I did it. But, that's on me. I made an assumption. It was wrong. My bad. And then, we had some back and forth. You kept telling me to take my glasses off. How dare you? And stop swaying. I'm sorry. I've gone through a lot of different learning and attention-paying styles throughout my life. Well, I mean, there's really three. There's visual, there's audio, and there's kinesthetic, right? And these days, probably due to the ongoing impact of my adult ADHD, plus a distinct lack of certain type of stimulant, I move around a lot more to listen. I used to drive Lady Raggets crazy with this when we first got married, and she didn't understand how I work and how I operate, because we would go to Bible studies at church, and the person would be speaking and talking, teaching whatever lesson it was, and I would be reading something else from a different book of the Bible, from a different chapter of whatever study guide I would be reading. And Lady Raggeds, at first, this is early on in our marriage, she was like, hey, come on, pay attention. I care about this. Why are you being whatever? I'm like, I'm listening. Stop. Leave me alone, woman. And she's like, no, you're reading something. I'm like, I can't just listen. I can't. I'll lose my attention. So I can read and listen at the same time. I used to be able to do that. I don't really do that the same anymore, but I did. For very, very many years, I would read and listen, two different things, and absorb both of them. If I would read alone or listen alone, it would be boring, and I would get distracted. But when I had two things, it was just the right amount of input. Nowadays, I think through music a lot, and sometimes I move or touch things because like it helps me focus on the other stuff. So I'm sorry if my swing or whatever bothered you. But hey, what am I going to do? It's just who I am. I like it. But anyway, I think you're cool or whatever. I still like the whole like roast those above you. I don't think you understand how I view myself. I always punch down, never punch up. What are you doing? Just kidding. All right, guys. I love you all very much. You guys have made this a fantastic stream. 70 members, 2 locals members, bunch of super tips, bunch of super chats. You guys are awesome. And like I said, I like doing this. This makes me happy and brings me joy. I love talking to you guys. And I know some of you have really long nights that are kind of boring. You got a, like an IT job that has overnight stuff or security or truck drivers. Lots of people who are just up. And a bunch of y'all are just up because you're wrong and crazy and broken like I am. Well, hey, I like that too. So thanks for being broken with me. Thanks for hanging out. Make sure you click the like button gingerly, softly, but with a little bit of venom in your eyes on the way out. Until next time, I'm out of here. See you guys then. Peace. Peace.
So pour out an odd bag of Balmore at the brook. Spirits flow as the one suit get unemployed. So pour out a glass for the tea. Post on Twitter as we hear Lost Planning tonight. From the wide shores of Nam to the hills of Glenlivet, there's no one who's